Court officer, madam. Serial number.
May I request, Malad? Malad, serial number 14, Malad.
Which list, sir?
First list, Malad.
My lord, I represent the petitioner in that case, my lord. Senior counsel has already been engaged. There is urgency in the matter. Was for any adjournment, my lord.
Malad, senior counsel also engaged by me also. Malad.
2008 decree, my lord. I have filed execution.
We'll
Till
see,
it is
we'll
in
see
my
when the
name.
matter reaches when the petition is, when
Grateful, madam.
counsel is opposing. Yes.
Page 7, cell number 36 to 40. Page 8, 41 to 45. Page 9, 46.
No, this 44, this final hearing matters.
Yes, ma'am.
In this part third, look at it, where there is interim order extended and give a date on 7th of July. Yes.
Page number 10, cell number 48 to 50. Page 11, 51. Page 12, 52 to 54. Page 13, 55 to 59.
My lord,
My lord.
59, serial number 59, my lord. Tomorrow in trial court, it's before tomorrow. Kindly have it at 2:30, my lord. Today.
Yes, 230, 59. Yes.
Page number,
It's not at
page
call.
number 14, cell number 60 to 64.
My lord, serial number 63. The matter is before the trial court today, my lord. There's emergency. May listed at 2:30.
230.
Page number 15, cell number 65 to 69.
68. Yes, 230.
Page 6,
Huh? Which case?
cell number 65, she wants adjournment for 1 week. Rohan Osmat. She is including a
Have you informed the counsel for the petitioner? Wait for your turn. Yes.
page number 16, cell number 70 to 73. Page 17, 73 to 77. Page 18, 78 to 82. Page 19, 83 to 87. Page 20, 88 to 91.
90, my lord. Serial number 90. Tomorrow the civil court matter is an urgency, my lord. Tomorrow civil court matter has been listed, my lord. In the civil court, the trial court.
When is the matter listed?
Tomorrow, ma'am. Tomorrow.
It's coming up tomorrow?
Yes, ma'am.
Yes.
There is an urgency, ma'am.
Inform the other side, whoever is mentioning,
yes.
if the respondent is there.
I'll inform.
They should inform, otherwise I will not take up
Please,
the matter.
I'll inform.
Yes.
Page 21, cell number 92 to 94. Page 22, 95 to 102.
Milords, serial number 100, Milords. The matter is coming up before trial court on Monday for a
Monday, there is a lot of time. Yes, next.
Page number 23,
Yes, 101.
103 to
Become 101. You have already withdrawn the petition.
Take that. Then counsel receives permission of the court to withdraw the revision petition. The revision petition dismissed as withdrawn.
It's already withdrawn.
Then how come it is listed? Take out that file. This is CRP number 68 of 2020.
Serial 101.
101.
Yes, ma'am.
That is WP number 14121.
Number 3.
Huh?
System
This is list number 2.
Sorry.
Yes.
number 2, sir.
Yes, next. Yes.
Page number 13, serial number 103 to 110. Page 14, 20, page 24, serial number 111 to 117. Page 25, 118 to 124. Page 26, 125 to 129. 27, 130 to 33.
Then this PRT partnered matters.
Yes, ma'am. And fine.
All these partnered matters of DRT, this is 133. This also like in the other matter, what is the date given? July?
That is 7 July.
7 July, look at it. If interim order is there, extend till then. Yes.
That is including this final hearing.
Final hearing also, CRP final hearing. Yes.
Page number 28, serial number 134, 35. Page 29, 136 to 139.
Serial number 138.
Hmm.
Already I have filed
It
memo
is
for
all-
withdrawal, my lord. Matter has been settled between the parties, my lord.
Yes, memo is filed seeking to withdraw the petition that the matter is settled between the parties. Accordingly, memo is taken on record, dismissed as withdrawn. Yes,
Much obliged.
Serial number
139.
We appear for the respondent, my lord. We have no objection. Serial number 139.
See, they have an objection.
We have no objection.
Let's
My
just
lords, I appear
matter
for the
in the month of
impleading
July,
applicant.
don't give the date.
My lords, I appear for the impleading applicant in this matter, my
In
lords.
which case,
Serial number 139, my lords. Kindly a date may be fixed, my lords.
says this matter on 21st of July. Interim order order granted is extended.
Page number 30, serial number 140 to 43.
Serial number 142, my lord. I represent the respondent. I am seeking vacating the interim order. Lord, the writ petition is filed against the issuance of a notice in miscellaneous appeal. In an original suit, a temporary injunction rejected. Then the plaintiff filed an appeal in which notice is ordered. That order is challenged under the writ petition and the interim order is obtained. Lord, there is a serious dispute at this part regarding possession.
No, what you have to understand is, in this list, out of 250 matters, in 200 matters, interim order is granted. So it is not possible for the court to hear all the matters. Only the matters which have an urgency, which are resting before the.
Serious urgency, Lord, there are.
What urgency? Everyone has the same urgency. So your case is not different. You have to wait till your matter reaches. Yes, next.
Page number 31, serial number 144 to 147. Page number 32, 148 to 152. Page number 33, 153 to 157.
157, madam, serial number 157. The respondent obtained ex parte decree without notice. And I have filed miscellaneous. Miscellaneous is also dismissed. And appeal is filed, appeal is a part also. It shall be, appeal is also dismissed.
Any urgency is only if the matter is coming.
Because he has already filed FDP and trying to take possession.
That is on the merits of the matter. Everybody has the same urgency. No. I will not take up any matter at 2:30 except on the ground that the matter is coming up before the trial court. All will be in the list.
This is the decree is already passed.
In so many cases, that is the same situation. What to do?
And he is trying to.
Let it be. That is urgency for every advocate, for every client. But that can't be addressed by this court. Yes.
Page number 34,
No.
158 to 160. Page number 35, 161, 162. Page number 36, 163 to 166. Page number 37, 168 to 170. Page number 38, serial number 171 to 175. Page
Serial number 171, my lordship.
170?
171.
Yes.
Because the matter is on day after tomorrow for final hearing, my lordship. The trial
I
court.
will take up tomorrow. Make a mention tomorrow. Make a mention tomorrow. Yes.
Tomorrow.
Page
trial
number
court
30.
is there.
Huh?
N number of cases are there. Please, today, my lordship.
I will not take it up today. Tomorrow you have to make a mention.
Please.
I made
Page
it very
number
clear.
39, 176 to 179. Page number 40, serial number 179 connected.
Yes.
40.
What are these matters? Batch matters.
Sir,
Yes.
all the batch CPC.
Hmm. Yes.
Serial number 40, page number 42 also connected.
Yes.
Serial number, page number 44, serial number 180 to 185. Page number 45, 186 to 190.
This further hearing matters. 190, let it be listed on 2nd of July. And interim order, if it is there, extended. Yes.
Serial number 40, page number 46, 191 to 195. Page 47, 196 to 200. Page number 48, final hearing.
Yes, this final hearing matter
Part third matter.
and part third matters all these parted matters. Give the date on 7th of July. Look at it, interim order is there, extend.
Or DRT matters.
Yes, all DRT matters.
Yes.
My lord, serial number 205 in the list number 2, it's for paper publication IA, my lord. Last time on the direction.
1 minute, which one?
205, my lord, 205. In the list number 2.
205.
There is no application.
There is no, where is 1 minute?
No, non-filing of IA for substituted service.
Non-filing of IA for substitute.
No, we filed on 2nd of June, my lord.
Take out this file. If there is an IA, then we'll order it. Take out this file. Yes.
Much obliged.
Page number 55. 55 also 205.
Yeah, full, the entire list.
Yes,
The dismissal matter, let it be there in the list.
List number 3, page 1, serial number 1 to 3.
Find out for serial number 2, the needful compliance is done.
Huh?
The needful compliance is done, and the opposite party, relevant opposite parties also served. Might will kindly be taken up today.
What is urgency?
My lord, the nature of the suit is such that since 2014, I am embroiled into back-to-back suits from the family members. Again, I am embroiled in another suit.
That is not at all the urgency because everybody has the same urgency. So let it be in the list. Yes.
Page number 2, serial number 4.
Item number 1 is 3, it is for withdrawal.
Item number?
1 is 3, it is for withdrawal. The matters coming
This
up
3
before-
is, there is no memo here.
File memo is not.
Furnishing of so and so.
It is,
What is the number?
list 3, item number 1.
Huh?
List 3, item number 1.
Case number 8, sir.
CRP 595 of 2020.
No, memo is not there.
There is no memo it
I
appears.
will mark it as
She'll verify.
yes.
If it is there, take out that file. Yes.
Page number 2, serial number 4, page number 3, page number 5 to 7, page number 6, 8 to 11, page number 5, 9 to 15, page number 6, 16 to 20, page 7, 21 to 25.
17 million. Kindly take up 230 million because my lord, this is a suit for partition. In the execution, my lord, the police has police protection given to the defendant, that is his sister. The brothers are not allowing. They are harvesting the yield of the Araconate garden, my lord. That is why urgency is there, my lord. I offered the vacating interim order.
We will see.
230 million.
No. Yes.
Page number 7, serial number 21 to 25, page number
22.
Take that. Memo is filed stating that the writ petition has become infructuous. Petitioner wants to withdraw the same. Accordingly, dismissed as withdrawn. Yes. Yes.
page number 8, page number 8, serial number 26 to 30, page 9, serial number 31 to 34, page number 10, serial number 35 to 36, page 11, 37 to 40, page number 12, serial number 41,
Yes.
page number 13, serial number 42 to 47,
40? Huh.
One of the defendants who don't choose to file the written statement until the defense final arguments are over.
No, I think you understand what the court is, because what will happen is, if I start taking up the matters like that, in every matter there is a stay, wherever there is stay, vacate petition has its own urgency. So it's not possible. No. That's why date is there. It will be there in the list. Whether it is, but till it reaches, it will be there in the list. Yes.
page number 14, serial number 48 to 56, page number 15, 57 to 64,
230.
page number 16, serial number 65 to 72, page number 17, serial number 73 to 79, page number 18, serial number 80 to 87, page number 19,
80? Why? Have you informed the other side? Huh? No, your petitioner's respondent is there. Have you informed?
Actually, it is for rectification of object.
No interim order in this? No interim order? Huh? Just in the month of July at the request of land council for the petitioner. Yes.
Page number 19, cell number 88 to 19.
Don't, even if there is an interim order, don't extend. He says it is not there. Yes.
Serial number 89, for the petitioner, respondent counsel has consent for the adjournment. Person inconvenience.
Yes.
Interim order is there. but
Serial number 89, there is a connected matter.
Huh?
Connected matter also is there. In that there is a stay, it may be extended.
89, in both the matters, 89 and 89.1, at the request of land council petitioner. There's this matter in the month of August, interim order earlier granted is extended. And it is submitted that the same is informed to the respondent council.
But a date may be fixed.
You can't have both. You can't have adjournment and a date. Yes.
Page number 20, serial number 91 to 97. Page number 21.
96. The case is posted today and there is a threat of demolition, a number of bulldozers are.
Yes, 96 at 2:30.
Yes, ma'am. Page number 21, serial number 98 to 103. That's fine.
This in 102 manner. In 102, there is a very urgency. TCR is received in this court.
What is the very urgency?
They are the final hearings. There, the other side is going to be alienate the property. TCR in this court, my lord. That's why kindly be heard.
CRP of 2024, now they are going to alienate the property and there is an urgency.
Yes.
I don't see that.
My lord, the TCR is received in this case, in this court.
Not now 1 and 102. This is the matter on 8th of July. Yes.
Serial number 101, my lord.
Yavat.
Serial number 101.
Yavat, madam.
It's already withdrawn.
Yavat.
Petition is already withdrawn. I
Oh,
have
this is the
placed-
one you are
I
referring
have
to.
placed the
Yeah,
hard copy for
it is
consideration.
listed. How are you listing the matters like this? This 101, when it is already withdrawn and an order was passed on 28th of March 2024, why did they list it again? Verify that. Yes, land counsel for the petition has placed before the court the copy of the order dated 28th March 2024, where the petitioner has withdrawn the writ petition and the revision is dismissed as withdrawn. It's there,
101.
withdrawn.
Huh.
Hence, no further
States
orders are
here,
required to pass in this. And registry shall verify why the matters are posted when already the same is withdrawn, dismissed as withdrawn long back. Yes. Yes. Anyhow, we'll see. Tell the, show it to the registrar judicial why it has been listed today.
No restore application is filed.
So this part-heard matters or part-heard matter, what is this? It is
Part of matters.
this part-heard matter also, this also listed on 8th of July. 8th of July and interim order in all these matters extended. Yes, call the list.
My lords.
My lord, may I make one
This matter, my lords, KEB is installing a HT tower on my land without acquisition process at all, my lords. I'm requesting for 230. They are basing their strength on the basis of an injunction order passed by the deputy commissioner on the 5th. And now, my lords, already they are undertaking excavation works using JCBs on the
What
property.
are you doing till what? Till they get the material and they start excavating?
My lords, they just came all of a sudden yesterday, my lords. Therefore, then only I got to know that the order was passed on 5th of June, my lords.
Serve notice, serve the papers and all the concern, then only I'll hear the matter.
Please, my lords, may I request for 230?
Yes,
my lords?
230, provided
My lords,
any panel counsel is there, he shall be served, AGA, anybody. Once they get
AGA
it-
is respondent one, my lords. Respondent number 2, I'll serve the standing counsel.
My lord,
I'm grateful, my lords.
My lord, in serial number 2, my lord, list number 2, serial number 89, my lord, it was a writ petition GMDRT. Your lordship disposed the writ petition in the month of April 28, my lord. We have filed IA seeking extension to deposit the amount, my lord. It was filed on third.
That, tell that matter, that will be taken up at 2:30.
Please, my lord, I'll inform the bank.
Because remaining other matters I have adjourned all partners.
Please, 89 at 2:30.
With permission, my lord. See, list number 2, 147. Other side is await service. It's they're not yet served. May be listed after the service, my lord.
It has to reach, it will be there, whatever adjournment you are seeking, that is already, your purpose will be served. Don't have to mention. Yes, call the list.
Page number, list number 1, page number 1, part-heard matter, serial number 1. Patil Dayanand Subraya Gowda.
Waiting for the petitioner.
Petitioner.
Petitioner is a bank, my lord. They filed the application for rejection of client, my lord, on the ground that 180 of the act, my lord. there is a bar to file suit, and also 125, they have to give mandatory notice to file a suit, my lord.
Why this case is posted?
Last date of hearing, my colleague is appeared, my lord. Intend to dismiss the, therefore, kindly see the Karnataka Cooperative Society Act 118 of subclass T, my lord. There is a bar, my lord.
It is a bar. How that bar applies to this? And what is the relief that is sought? In every case where there is a society is a member of the society is a defendant, that bar will not apply unless and until this particular dispute is concerning the management or the business of the society.
When I gone for recovery of the amount, my lord.
He is unconnected with you.
Please.
It is not, his case is that he has nothing to do neither with you nor your member. He has
They have
independently.
alternative remedy, my lord. They have to go before register.
How will
They have
go?
to file
Why should they
objection, my
go?
lord.
He has no connection with you. He has not purchased a property from your member.
Please,
He has
madam.
independently purchased a property. And if
I-
you are raising a litigation on that, you have to go. You go to the civil court,
My
or
lord,
if you go
one
to the civil
submission, my
court.
lord. Kindly see the 125 of the
Yes.
Property Act, my lord. May I read, my lord?
I've seen it. I've seen it and passed an order. Give that. Give the act, Cooperative Societies Act. I've seen, I remember, and much prior to what you are saying, they have purchased the property.
No, my lord. Mortgage is 2006-8, my lord. They purchased on
Vendor
2018.
is also not one and the same. Your
Same
vendor and
property,
their
my lord.
vendor
Their
is not one and the
PID
same.
number is different, my lord. Some
Parties are different, altogether different. How can your registrar will deal with all this?
No,
It's
if
purely a
any
civil
action,
dispute.
conducting action, my lord, then any grievances, they have to file objection before the registrar, my lord, as per the act, my lord, rule 38 subclass 5A, my lord.
He has an independent grievance with regard to his declaration of title. He has gone to the civil court, which
He has
cannot be
not
done.
filed the declaration, only injunction suit,
Let's
my
see,
lord.
let's
filed,
see.
my lord.
Section 70 or
118, my lord, first I will read. Bar for jurisdiction of court, my lord. Save as provided in this act, no civil, labor or revenue court or industrial tribunal shall have any jurisdiction in respect of, go to subclass C, my lord.
You're
Any
referring to
118, my lord. Bar of jurisdiction of court, my lord.
Cooperative Society.
Please, my lord. Section
108.
118.
Powers of revision of state.
No, my lord, 118, my lord.
118.
18, my lord. Bar of the jurisdiction of courts, my lord.
Yes.
Save as provided in this court, in this act, no civil, labor or revenue court or industrial tribunal shall have any jurisdiction in respect of first and second not applicable, my lord. Third one, my lord. See any such.
Also A not applicable, B not applicable.
Please, my lord.
C.
C is any such application required under section 69. That was also not applicable, my lord.
Yes.
Any dispute required under section 72 refer to the register or recovery of money under section 100 or execution of any award or order referred by register for execution of section 101, my lord. As per the execution order, I gone for action, my lord. If any grievance of the party, they have to file objection before the register under section 38 subclass 5A.
Any surcharge application required under subsection 69 or any dispute required under section 70 to be referred to
I
the
have taken the
registrar.
award from the section 70, my lord.
And then section 70, come to section 70. What does
And
section 70?
I taking award, I will execute the on 101 execution proceeding, my lord. The register order for action of the property on
Under section
101, my
70
lord.
to be referred to the registrar, or the recovery of monies under section 100 or the execution of any award of order referred to the
When
registrar.
I executing for the award.
For execution under section 10. Now please come to
My
the
lord,
place.
one more thing, my lord.
The place.
38 subclass 5 is
38.
subclass rule 38 5 subclass A, my lord.
38. Yes.
At any time within 30 days from the date of sale or any immovable property, decree holder or any person entitled to share in the
rateable distribution of the assets or whose interests are affected by the sale may apply to
Reading
recovery officer
38,
to set aside.
38,
38(5)(a), my lord.
38, 5A. How it starts, what is that section refers to, 38?
Attachment and sale of immovable property, my lord, 38 apply. In subsection A, this is a procedure, my lord. Attachment of,
Section 38.
please, my lord, attachment and sale of immovable property, my lord.
Exemption from compulsory
Rule
registration.
38, my lord, not section. Sorry, my lord. Rule.
Yes,
5A, my lord.
yes.
At any time within 30 days from the date of sale of an immovable property, decree holder or any person entitled to share in a rateable distribution of assets or whose interests are affected by sale may apply to recovery officer to set aside the sale on ground of a material irregularity or mistake or fraud of publishing or conducting it, provided that no sale shall be set aside on the ground of irregularity or mistake or fraud unless that recovery officer is satisfied that the applicant has sustained substantial injuries by reason of such irregularity, mistake or fraud, my lord. The petitioner has to approach before register, my lord, for that.
Come to the suit. What is the suit?
One more, my lord. Section 125 also there is a mandatory notice has to give before filing a suit, my lord.
Please come to the plaint. Come to the plaint. What is the dispute?
Injection. Yes, they sought for injunction.
Dispute. What is the case?
Please.
The case of the plaintiff.
Para 3, page number 38. No?
Page number?
Annexure D. Para 3, my lord. It is respectfully submit that plaintiff acquired the absolute right over the scheduled site having purchased the same under a registered sale deed dated 10/8/23, which has been registered as a document 603 executed by Srimati Sonabai, wife of Papu Naik. On same day, plaintiff has put in possession of the scheduled property. Subsequent to purchase, this kata of the scheduled property has been transferred in the name of plaintiff, Shumaga Municipal Corporation record white kata, so and so miller.
So the property is purchased on 25/4/2023.
23, my lord. My property.
2003, not 23.
23, my lord. In
Para 4.
Para 4 is allotted in 91. Some Akkupatra.
End of the para.
Please, my lord.
End of the para.
Please, my lord. Municipal endorsement
is dated 25/4/2023. 2003.
When I go on for action, they will they taken as a cause of action, my lord. They filed suit, my lord. My lord, kindly permit to read 125 of the act, my lord. Trial court only 118 has considered that it is not applicable. He is not a member and is not taken the loan, my lord. But they have to give mandatory.
Look at your application. What did you seek?
My application, my lord. My lord.
According to you, this property is mortgaged in the year 2008.
Please, my lord.
And according to the plaintiff, the property was purchased in 1996 and 2003 there was a mutation in their name.
Please, my lord.
Yes.
One more thing, my lord.
You have created the charge in the year 2008.
Please, my lord. And I take.
Mortgage was created as a loan was borrowed by one GS Nagaraju.
Please, my lord. Is a
and as per the plaintiff and this Nagaraju, they have nothing to do with the other. Yes.
On the ground of 118 and 125 of the Act, there is a bar. Therefore, I filed application, my lord. They have not given a mandatory notice for also the petitioner, my lord.
Person, when he is unconnected with your society, how will you know about all this?
At least 125 mandatory notice has to issue, my lord. Is not
What is
issued.
the respondents? In both the matters. Delete from part two.
Cell for orders
Petition is
for
permitted to take court and summons on the counsel appearing before the trial court. In 1.1, office objection shall be complied within 2 days.
Obliged.
cell number 2,
Please,
Prakash M.
petitioner. I'm told that two applications are disposed
What are the
under a
office
common order.
objections?
I need to file one more
One order.
petition.
For order, yes. Office
Order.
objections are overruled, yes.
Lord, it's a belated challenge of the impugned order passed by the court.
When was the impugned order passed?
Please, Lord, into August 2023.
How are you
Lord,
questioning
please.
it? Because there is no limitation for filing a writ petition under 227. That can't be the reason.
Lord, the thing is, the suit for
Why should
partition.
we entertain it?
Yes.
First, you argue on that.
Please, in a suit for partition, the petitioners are the plaintiffs. Lord,
The entire order, everything is in Kannada.
order is impugned order is in English, Lord. I say.
Please come to that order. Where is the order?
Page 66, annexure L is the.
66.
Please. And the finding, Lord, commences from page 77. The two applications are filed.
Yes, IN number.
Lord, IN number 13 is for directing the defendant number 2 and 3 to produce lease agreements. Lord, there are 3 scheduled properties in respect of which partition is sought. The item number 1 is a commercial property in Taluk headquarter, wherein about 16 shops were.
This is an intro. This
Yes.
Sir.
My Lord, so far as the first prayer is concerned, my Lord, I am not pressing
What
it.
is to the respondents?
No, my Lord,
Petition is permitted.
even without issuing notice, my Lord, the second prayer, what I have sought is to dispose, direct the trial court to dispose the suit within time limit. Lord, the trial court says that at this moment the applications are not maintainable. Because why? Because the petitioners have filed the second application invoking order 16 rule 6, seeking direction to the defendants to produce. Now the cross examination has been commenced right now, just now, about 1 week back. So that's why, my Lord, reserving my liberty to renew the application. Lord, my request is a direction could be given to the trial court to dispose this suit.
Notice to the respondent. Petition is permitted take for transmission. The counsel appearing to respond. If the memo is filed, is the matter on second of history.
cell number 3,
I appear for the petitioners, my lord.
Yes.
My lord, in this case, I am seeking indulgence of this honorable court, my lord, to give the direction to the trial court to pass orders forthwith on my IAS, my lord, because the first petitioner has developed cataract, my lord. Therefore,
When was the IA filed?
my lord, IA was filed on 6/9/2025, my lord. And thereafter it was heard and it was posted for orders, my lord, from 9 from
The
5
petition is filed.
23/1, it was finally heard by the regular court.
The
And now,
petition
my
is
lord,
filed
it has
in the
been
following prayer. When counsel appearing for the petitions of his son, the A's which are filed, I number 12 to 14, which are filed on 6/9/2025, are pending consideration before the trial court. Hence, there will be direction to the trial court to dispose of the IAs as expeditiously as possible. To dispose of the IAs within 2 days.
very well, my lord.
What is that? No. What is that relief within 2 days?
My lord, within 2 days, why I have sought, my lord, everything has been heard. And the matter was, my lord, for 4 times the court has adjourned to pass the orders.
Considering the submission of the land counsel of the petition and the IAs were filed on 6/9/2025 and they are pending till today, this court deems it appropriate to pass following order. Say the petition disposed of, requesting the learned so-and-so to dispose of IAs, IA number 12 to 14 within 15 days from the date of receipt of the copy of this order. Same, no notice is issued because no adverse. Yes, next.
number 4, Nagaya for petitioner. 4,
That suit is for temporary injunction, Mulats. What's the respondent number 1? On the strength of the alleged agreement of rent, Mulats, he has forcefully entered into the premises of the petitioner number 1 here in Mulats. But he says that respondent number 2 has made the agreement in favor of respondent number 1. Mulats, there is no authority or there is no power that has been given by petitioner number 1 in favor of respondent number 2 here. And on the strength of the alleged rental agreement, Mulats, he has forcefully entered and he has filed a case against me to restrain me from dispossessing from the shoot scheduled property until the disposal of the rental agreement herein. The rental agreement has also been it has also been terminated now. Plus, and in the suit, I have filed my written statement. By entering into the suit, I have filed my written statement and I've also sought for amendment, Mulats. And the same has.
There's a suit.
Mulats, sorry, Mulats.
When was the suit filed?
Mulats, it was filed on
Which year?
2025, Mulats.
File your written statement.
The written statement was filed on. The suit was filed on 4th February 2025. The written statement is of written statement was filed on 19/2/2025.
This application?
Mulats?
This application is filed?
It's on 9/12/2025, Mulats.
Come to your affidavit.
Please, Mulats.
Yes,
It's affidavit of,
affidavit in support of the IA.
please.
Page 52. Page 52 is objection. Where is affidavit?
Please, Mulats.
At 49.
Shall I read, Mulats?
49, yes.
Please, Mulats. I submit that I am the defendant number 5 in the above suit and such I am well conversant with the facts of the case and I am competent here to swear to this affidavit. I submit that the plaintiff has filed the suit against me and other defendants for the alleged relief of injunction and the other relief in respect of the scheduled property. I submit that in the said suit I have filed my detailed written objection. In the above suit, the amendments made in the written statement may kindly be read as part and parcel of this affidavit to avoid repetition of facts. I submit that the plaintiff is in unlawful possession of the portion of the scheduled property consisting of 2 BHK house. One, I am the absolute owner of the scheduled property by bearing survey number 12/1C, measuring to an extent of 19 gutta, situated at Geddalahalli village, KR Puram, Hobli, Bengaluru South Taluk, Bengaluru, along with consisting of ACC sheet roof houses with electricity and water facilities and other civic amenities. I submit that the plaintiff in collusion with the defendant number 1, 2, 3 have created a fabricated document styled as rental agreement, which is no way connected to me and I am.
Seen that. Where is the impugned order?
What's impugned order is at page number 59, Mulats.
Where the reasoning will start?
Starts from 62. Reason start from 62 Mulats. Point number 1. It is well settled that though the amendments are to
Come
be.
to para 6.
Para 6 Mulats, please. In the present case, the suit has framed in one for injunction based on alleged tenancy. The scope of adjudication is therefore confined to possession and alleged interference. However, the proposed amendment seeks to introduce a counterclaim for recovery of possession and damages, which necessarily involves adjudication of title and rival ownership claim. Such a claim cannot be treated as incidental or ancillary to the defendant, but constitutes a substantive and independent cause of action. The Honorable Supreme Court has observed that a counterclaim, though treated as a cross suit, must still satisfy the requirements of mentality and cannot be permitted where it alters the fundamental nature of the proceedings. Further, it is to be noted that defendant number 5 seeks eviction and damages without seeking declaration of title. When the title is seriously disputed, the relief of possession ordinarily follows a declaration of title. In the absence of such a foundation pleadings, the proposed counterclaim is legally incomplete. The Honorable Supreme Court in Anatula Sudhakar versus Buchireddy has clearly held that where there is a serious dispute regarding title, a mere suit for injunctions are sufficient and proper remedies to seek declaration of title along with the consequential reliefs. Applying the same principle, the counterclaims ought to be introduced without seeking declaration is hereby inherently defective.
Take out hand summons on the counsel appearing for the response. We shall file a memo to that effect. The memo is filed by 29th of June. This is matter on 30th.
In the meantime, I request the Lordship to pass.
Yes,
Because Because,
number 5.
30th, we will take it up. Yes.
because the matter is posted on 15th, my lords, for additional issues. If issues are framed, my lords, then
That doesn't matter. Yes.
Case number 5, Chintan Chinnappa for petitioner, Abhinav R for respondent.
Lords appear for the petitioner. My lords, the dispute, my lords, pertains to a landmark restaurant, my lords, in Church Street called Mainland China. The dispute, my lords, pertains to the leaseholder, the previous owner, and now the prospective auction purchaser. My lords, for about 20 years, we have been in occupation of the property for over 2 decades. We have a registered lease deed, my lords, which is executed with the initial owner.
What is the suit for?
The suit, my lords, is multiple reliefs. My lords may see the reliefs.
May I just interrupt, my lord?
At page number
My lord,
119.
petition is not maintainable. My lord, it's an order passed by the commercial court. My lord, so therefore, my lord, they'll have to file an appeal.
What is the order? Order under?
It's an order passed under Order 6 Rule 17, rejecting their application seeking amendment. Lord, it is appealable, my lord, and therefore writ petition does.
It is rejected.
Yes, it is rejected, my lord.
It's not an
It has
appealable
been
order.
rejected. May I
It
just
isn't an appealable
point out
order.
the provision?
Rejected.
Not the plaint is rejected. The order 6 rule 17 for amendment, my lords, has been rejected.
Any
My lords may just see the prayers before my learned friend
May I just
interrupt.
clarify? Any order passed by my lord commercial court, my lord, appeal has to lie, my lord, as per my lord section 5.
Let's see.
Please, my lord,
Commercial Code Act, sir. Section 5 of
commercial courts.
Let's see.
My lord, please see, my lord, section 5. Thereafter, my lords may kindly see section 13 as well.
Let's see section 5 first.
Section, please, my lord, section 5. Constitution of Commercial Appellate Division, after issuing notification under subsection 1 of section 3 or order under section 1 of section 4, the Chief Justice of the Commercial High Court shall, by order, constitute a Commercial Appellate Division having one or more division benches for the purpose of exercising jurisdiction and powers conferred on it by the Act. The Chief Justice of the High Court shall nominate such judges of the High Court who have experience in dealing with commercial disputes to be judges of the Commercial Appellate Division. Now, please take, my lord, section 13.
Yes.
Appeals from decrees of commercial courts and commercial division. Any person aggrieved by the judgment or order of a commercial court below the level of a district judge may appeal to the commercial appellate court within a period of 60 days from the date of judgment or order. 1A, now this is relevant, my lord. Any person aggrieved by the judgment or order of a commercial court at the level of district judge exercising original civil jurisdiction, or as the case may be, commercial division of a high court may appeal to the commercial appellate division of that high court within a period of 60 days from the date of the judgment or order.
My learned friend should read the proviso also. The
Please.
proviso reads, provided that an appeal shall lie from such orders passed by a commercial division or a commercial court that is specifically enumerated under Order 43 of the Code of Civil Procedure. And Order 6 Rule 17 is not enumerated under the...
Any appealable order
Yes, only if it's appealable.
division. And any order which is revisable or where writ petitions can be filed under 227, it is maintained.
Only then. Otherwise, it's a 226, 226. My lords, the urgency today is this. The dispute, my lords, has been filed. A commercial suit was
You are referring
preferred.
to the plaint. Where is
Yes,
the
my
plaint?
lords. The plaint, my lords, is at page number 119 of the writ petition.
Yes.
These are the prayers, my lords, in the plaint.
1 minute. Yes.
Declaring that the plaintiff continues to be the lawful tenant / lessee of the demised premises bearing number so and so. Declare that the...
You are the plaintiff.
Yes, I'm the plaintiff. I'm the tenant, my lords. Under a registered and duly stamped document, declare that the lease agreement dated 1st of August 2013 executed is valid and subsisting and in full force. Declare as to who the plaintiff must deposit the monthly rentals subject to the receipt of valid GST compliance notices. Direct either defend number 1 or in the alternative defend numbers 2 and 3 to enter into such documents and or writings or agreements with the plaintiff so as to
Now,
ensure...
what is IA?
Yes, my lords, the IA is for amendment. The application, my lords, can be found at page number 308.
300 and?
.308, my lords, the prayer that we are seeking to add is at page 315.
What is the stage of the suit now?
My lord, it's posted for statement of admission and denial. It's prior to the trial. It's prior to the trial. 315, my lords, declare that the notice. So during the pendency of the commercial OS, they, my lords, issue a termination notice of the lease. Now I'm seeking, my lords, a declaration that that notice dated 28th of January 2025, issued by defendant numbers 2 and 3, who my learned friend represents, upon the plaintiff is void and bad in law.
Only this to be added?
Please. And my lords, the substantive statements in support of this prayer, my lords, has been also included. That is at page number 309 onwards.
No, the prayer is to add this, this prayer.
That's
amendment.
nothing further. Then this happened after the suit was filed.
How the court dealt with it?
And the court says that it changes the cause of action.
Yes.
Yes, my lords, the impugned order is at page number 26. The relevant part is, my lords, at page number 36. May I read from para 9 onwards?
Yes.
By perusing these reasons, it is noted that the said facts are subsequent, and this different cause of action causes delay and change the nature of suit. The rights and obligations of the applicant with respect to the demise premises are restricted to the rights in the indenture of lease dated 1/8/2013 as per the lease agreement. As lease agreement is already produced by the plaintiff and detailed explanation has been made in the plaint about the lease agreement. Therefore, the act and notice of the plaintiff in a subsequent event need not be inserted as such in not the proper cause of action arose at the time of filing of the suit. Therefore, if the application is allowed, defendant will be put to great loss and hardship, and it causes more delay in adjudicating the suit. It is also noted point that if the application is rejected, there will be a loss to the plaintiff.
Say, what is this?
My lord, please take my,
According to the court, again, another, you should file another suit on that.
no, my lord, please take the plaint, my lord, page 94. Now the prayer, my lord, is at page 119.
Yes, I have seen that.
Yes. My lord, they have substantially, my lord,
No,
pleaded
this is
regarding all
pertaining-
these aspects.
Pertaining to the suit scheduled premises, and he has asked several reliefs. Now, this termination notice is also pertaining to.
Question. Yes.
If that is added in this, trial has not commenced, what is the prejudice to you? And it would avoid multiplicity of proceedings.
Please.
Yes, please come. Agreed with her.
My lord, notice has to go to the other respondents, my lord.
How
I'm only appearing for
many
respondent
of the
number 2.
respondents, let's see.
My lords, one is the original owner and 4 is the bank. My lords, of course.
The
Original,
bank for whom?
I appear for respondent number 2, my lord.
Respondent number. You are the owner of the property.
I am the owner. My lord, the respondent number 4, my lord, is bank. My lord, where, my lord, this property was auctioned by the bank. And my lord, I have purchased this property. And my lord,
No, anyhow, this relief is concerned, what the bank has to do with this?
Nothing.
My lord,
Absolutely.
respondent number
They've not
1,
even
my lord,
filed
is-
objections.
No. One, who is
What?
Kurian Thomas?
He's
My
the
lord, he's
original
the
owner.
original-
Of course, now they replace the original owner.
They are, my lord, the defendants in the suit.
That is true.
Yes.
As far as this application is concerned, you are the only affected party.
Effectively.
Who is 3?
My lord, the
Nazima Farooq.
3, my lord, is also the owner.
Husband and
Yes,
wife.
You
husband
appear
and
for
wife.
3, 2 and 3.
2, my lord. I am appearing for 2. Yes, my lord.
You're not
Necessarily.
No.
Yes.
In the suit, they're appearing together.
Huh?
Husband and wife are appearing together. So
No, in that case, for this application, 1 and 4 are not necessary.
not necessary.
Then you give a memo.
I'll file.
Yes, why should we keep it pending?
Please.
A memo, that order would be, a memo is filed seeking dispensation of notice to 1 and 4. 1 and 4. The 1 and 4. According, the memo is taken on record. Give it to me.
Well, it's-
The memo is taken on record. A notice to 1 and 4 is dispensed with. So and so, you have already filed wakalat?
Yes, ma'am. For caveator.
He is a KV, he has filed on behalf of respondent number, Land Council submits that on behalf of respondent number 2, a caveat is filed. 2 and 3 are represented by the same advocate before the trial court. Next part. The present writ petition, this is a separate order, that is docket. The present writ petition is filed. Agreed with the orders passed in I number
6.
I number 6 in commercial was 1443 of 2024. But, on the file of so and so dated 4/4/2026. The petitioner before this court is a plaintiff in the suit. The petitioner has filed the suit seeking the following reliefs at page number.
Well, it's a page number. Well, it's in the prayers in the
Prayers,
plain, my lord.
prayers.
119.
As sort filed the suit seeking the following prayer at 119, 120, the reliefs are there, you extract it. During the pendency of the suit, a termination notice dated
Well, it's January of 2025.
Jan,
28/1/2025.
a termination notice dated 28/1/2025 is issued by the respondent, defendant number 2 and 3. Hence, the petitioner plaintiff has filed I number 6 seeking amendment of the prayer by inserting the prayer that the termination notice is not valid.
Please.
Termination
The declaration that the termination notice is not valid.
is not valid. That came to be dismissed by order imputed. The learned counsel appearing for the petitioner submits that the whole dispute is with regard to the tenancy and other issues arising out of it. And during the pendency of the suit, when the termination notice is issued, the court has dismissed the same on the ground that it's a different cause of action and that cannot be included in this. It is submitted that if this is not made part of the prayer of this writ petition, again the petitioner has to file another suit where it is concerning between the same parties, and it unnecessarily gives rise to the multiplicity of proceedings, and this aspect was not considered by the court. By inserting this, the nature of the suit is not will not change, and further the whole dispute revolves around the tenancy between the petitioner and the respondent number 2 and 3. Next paragraph. When counsel appearing for the respondent number 2, caveator, submits that the court has rightly considered this aspect as the suit is filed on a different cause of action. Now, by inserting this relief, the cause of action itself would change, and it would cause prejudice to the defendant, and rightly dismiss the petition. And there are no grounds to interfere with this grounds to interfere. Next, having got the counsels on either side, produce the material on record. The suit is filed seeking several reliefs pertaining to the tenancy, and also on the reliefs are running into A to I.
I'm sorry, my lord.
Prayers.
Yes.
A to I.
A to I, please.
Running into A to I. Now, during the pendency of the suit, the termination notice is issued.
A to J.
A to J. And during the pendency of the petition, the termination notice is issued. The observation of the court that this is a cause of action, it would change the nature of the suit, and it would cause prejudice to the defendant. The observations of the court cannot be sustained in the interest of the parties, and to put an end to the litigation and to avoid multiplicity of proceedings. It is very much necessary. It is very much necessary to necessary that this IA should have been allowed by the court. Hence, in the considered opinion of the court, the order dated so and so needs to be set aside. Accordingly, the writ petition is allowed by setting aside the order dated so and so, and consequently, a number 6 filed by the plaintiff is allowed, and you shall make the necessary amendments to the within a period of 10 days.
Obliged.
Grateful.
K. Ravi Shankar. Bill number 6, K. Ravi Shankar for petitioner.
Yes.
But the defendant's writ petition,
Yes.
suit for permanent injunction. IA number 1 filed by the plaintiff is came to be rejected by the trial court on the ground that there is no prima facie case is made out And also, my lord, there is a dispute with regard to the identity and the proper.
MA it is reversed.
It is reversed.
Come to the order in MA.
MA, you lost me, kindly turn to my lord. The starts from page 11.
Yes.
Annexure A.
Yes.
The reasoning starts from my lord, page 9, para 17.
I think you can come to paragraph number 10.
10. Yes. On perusal of the plaintiff. The appellant plaintiff has stated that he has purchased the suit schedule property through a registered sale deed dated so-and-so from one so-and-so. And from the date of purchase, he has been peaceful possession and enjoyment of the suit schedule property as absolute owner. In order to substantiate his contention, he has produced the copy of the sale deed so-and-so in revenue documents. On perusal of the copy of the registered sale deed, it is noticed that the southern portion of the land property bearing survey number 32/2, measuring 1 acre 29 guntas situated in Galipura village, originally belongs to Nanjunda Swami, son of so-and-so. The said Nanjunda Swami sold 2 sites, each site measuring east to west 14 to so-and-so 60 feet on the western portion of the 1 acre 29 guntas in favor of Venkatramana through registered sale deed so-and-so. Thereafter, the said S. Venkatramana become the owner of the total extent of an east to west 14 to north to south 120 feet. The Geeta is the daughter of the said Venkatramana. The municipality had issued a assessment in favor of the Geeta. Then Srimati Geeta sold one site on the northern portion east to west so-and-so so-and-so to Afsar Khan through a registered sale deed dated so-and-so. On the basis of the sale deed, the municipality transferred the Khata to the name of so-and-so. Subsequently said Afsar Khan sold the site in favor of the Muhammad Akbar through a registered sale deed dated so-and-so. Thereafter, the Muhammad Akbar sold the northern portion of the east to west 14 to north 30 feet in favor of the appellant plaintiff through a registered sale deed dated so-and-so. Next bullet 11. The property assessment number measurement
What
and
is the injunction sought?
Please, bullet.
What is the injunction sought?
Not to put up any compound wall, any structure on the.
Dispute is between the two, the adjacent owners.
The trial court says, though the properties are different, it situates adjacently, therefore injunction has to be granted. Your cardinal principle with regard to the identity boundary, everything.
What is he going to do now? He is going to construct a compound wall.
Only to protect my compound wall, I wanted to construct a compound wall. That has been the trial court after holding the prima facie case, everything, it has been rejected. The identity, boundary, everything. There is no reference in the sale deed with regard to the survey number itself. But my land has been converted, properly identified. But a conversion order is also I produced.
Come to the trial court order.
Yes, the last my kindly turn to para 17 onwards. It starts from the reasoning, starts from page para 8, 49. The para 9, it has been discussed with regard to the temporary injunction grant of the cardinal principles with regard to grant of or refusal of the temporary injunction. Thereafterwards, last me kindly turn to para 17, page 54 onwards. On the perusal of the plain schedule and the written statement, it is seen that both the property.
Status.
That's what the trial court with all fairness would
Please
have
come.
done.
Then counsel appearing for the defendant submits that when the plaintiff has filed a IA seeking interim injunction, the trial court has rejected the same, and the appellate court, without considering the facts and without considering the fact that the plaintiff's property and the defendant property are two different properties, are granted an injunction, restrained injunction against the defendant, and the trial court by way of a reasoned order, when granted injunction, refused to grant injunction. The appellate court ought not to have interfered with the same, just because another view is possible. This court has perused having heard the counsel for the petitioner and having perused the order of the trial court as well as the appellate court. There shall be an order of status quo obtained as on today. Till the next date of hearing, same hand summons on the counsel appearing for the respondent and memo to that effect shall be filed by 1st of July or else the stay granted by this court stands vacated.
Number 7.
Great.
Manu Shankar.
Petition, madam.
The petitioner challenging the order passed by the trial court, my lord. Trial court has directing to inquiry on application under our 1 Rule 10 Class 2 of CPC, my lord, filed by the proposed defendant, my lord, that is 7th respondent herein, my lord, in FDP number 1/12/2020, my lord.
It is the impugned order.
Impugned order is in page number, my lord, 234, my lord. 234, my lord. Last page.
234.
As primer. Pursued the material on record and IA in order to dispose of the IA under order 1 Rule 10 Class 2 CPC, inquiry needs to be conducted as a legal right of the objector as to be ascertained on evidence. As such, order is deferred from time being. Inquiry.
Who are you?
I am the petitioner, plaintiff, my lord. In original suit, I am the plaintiff, my lord. The suit is came to be decreed, my lord, on 6/10/2015. The suit came to be decreed, my lord. As per the
When is it? 6/10?
6/10/2015, my lord.
The suit is decreed.
Decreed, my lord. Thereafter, my lord, contesting respondent are preferred the first appeal, my lord. First appeal is dismissed, my lord. Confirming the order for the trial court, my lord. No, yes, my lord. Being as per the preliminary decree, my lord, petitioner filed the present FDP, my lord. The proposed defendant is no way concerned the family of the plaintiff and respondent, my lord. So,
what is that IA? Let's see.
IA in page number, my lord. Kindly see page number 225, my lord. And supporting IA, my lord. 226 affidavit is filed. In para number 4 of the affidavit, my lord. 286, my lord. 226, my lord. Affidavit, my lord. The proposed defendant contending that, my lord, I further submitted while the commissioner was appointed for measurement and division of the scheduled property, while preparing the sketch and conducting the measurement, the court commissioner has wrongly and illegally measured the property belongs to me, that is survey number 215/9, to an extent of 8 guntas, which infringes my rights over the property. I have to protect my property, including my court commissioner, and the sketch prepared the commissioner is
In
bad
the
and
final decree proceedings, according to him, his property is also included. Who has nothing to
No,
do?
madam. As per the petitioner, proposed respondent contending that, my lord, his property is agricultural and, my lord. Item number 15 is the house property, my lord. We are not encroach the.
It has to be decided what is wrong in it.
My lord,
No, under the guise of executing this decree, if somebody else's property is included in the final in these decree proceedings, he has every right to object it.
But, my lord, in this case, what happened, my lord? His survey has been conducted in the year 2022, my lord. Still today, my lord, no one can file any application, my lord. Now, when the matter is fag stage, my lord, at the stage, my lord, is the husband of the respondent number 2, my lord.
Oh, the matter is posted on, what is the date?
Date is, my lord.
3/6/2026. What happened on that date?
My lord, is short time, my lord. Next.
Sir, we'll ask the court to conclude it at the earliest.
But this honorable court may kindly say, Annex G, page number 222, my lord. Petitioner is aged about 82 years, my lord.
I understand.
This
Because the petition is aged about so and so, that can't be the reason that under the guise of this decree, you include some other property.
But direction is there, my lord.
Whatever this inquiry that the court is proposing to do on this IA, I'll ask them to conclude within 10 days.
Please, my lord,
Within 2 weeks.
2 weeks, my lord.
Yes, please come. Agreed with the orders passed and agreed with the order dated 2/5/2026 in FTP number 12 of 2021 dated 2/5/2026. The plaintiff who is the decree holder is before this court. And counsel for the petitioner submits that the objector has nothing to do, is not a member of the family, and he has nothing to do with the joint family property. In fact, the commissioner was appointed long back.
2022, my lord.
The year 2022. Now, only to stall the final decree proceedings, the present application is filed, and the court has adjourned the matter for conducting inquiry. It is submitted that what is the age of the plaintiff?
82 years, my lord.
Plaintiff is 82 years old, and this and already there is a direction for expeditious disposal.
6 months, my lord. January.
When was that order?
My lord, Annex G, my lord, January 20. Annex G, my lord.
the court has directed the matter to be disposed of within a period of 6 months from the date of receipt of the order. This order was passed on 28th January 2026. It is submitted that in spite of the said order, the court has issued the court has adjourned the matter for conducting inquiry. Next paragraph. When an application is filed and stating that the property belonging to a third party is included in the final degree proceedings by the commissioner, he has every right to be heard before the court. However, in the light of the fact that the matter is the decree holder is 82 years old and already there is a direction to dispose of the matter expeditiously by this court. This court deems it appropriate to pass the following order. The writ petition is disposed of, requesting the trial court to dispose of the IA number
Next date
IA
is
filed
17th.
under order 1 rule 10-2 CPC.
Date is fixed on 17th this month. 17th this month. The date is fixed by trial court, madam. 17th, madam.
Yes, it's coming up then.
Yes,
They shall complete the same within 2 weeks from the date of receipt of the copy of this order. Same notice is not issued, that no act.
Cell number 8, Varun A for petitioner.
Lords, only a limited prayer in this writ petition, my lords, that an IA filed at Annexure J, page 56, may kindly be considered and disposed of by the learned commercial court, my lords.
When was IA filed?
My lords, April, my lords, the IA was filed. I'm sorry, I'll just clarify the date, I'm sorry. Lords, this IA came to be filed now recently, my lords, on 1st June, my lords. 1st June, I filed it.
You file a IA on
My lords,
1st June, you come to the
I
court.
quite follow. May I please just explain what is the situation? My lords, in fact, originally, my lord,
Give the time to the court. What is the date today?
my lords, originally, my lords, this petition itself had to be disposed of much earlier. The limited ask in this is only extension of interim order. My lords,
That is not appropriate.
may I
on
just
the
take a
part of
minute,
the-
my lords, perhaps I have not explained myself clearly. Please, kindly, my lords. My lords, the basic facts are that a loan has been lent by the petitioner to the respondents, my lords, and they have not repaid it. Therefore, some protective.
And whatever it is, you have filed the application on 1st of June. Where are we now?
My lords, it is not much time has passed. I certainly bow down, my lords. I am not.
Why should we pass an order?
Lords,
Just because you have come to the High Court will not give any
Lords,
direction.
even
to
the-
They have their own work, and if there is unreasonable delay, and if really warrants, those are the cases where the court will pass issue an direction to them. Not in every
Lords,
case.
may only make two submissions.
We can't interfere with the
Certainly.
word of the court.
Only two submissions, my lords. That's all. And then,
Submissions, but there won't be any change in.
no, my lords, only on this.
My
My lords,
observation on this.
my lords, one is sufficient time may be granted. I am not saying, my lords, that in.
He will not at all grant anything.
Second, my lords, the nature of the interim order, the IA that it is. Lords, the main issue has already been decided in a section 9 order, page 15, if my lords may kindly take.
Will not. The present petition is filed in the following prayer. It is submitted that the IA is filed.
Any time period, my lords.
No.
Any time periods that my lords may grant.
That is very
I don't-
inappropriate on the part
I
of the
don't
High
mean to
Court.
put any pressure, my lords. Any time that is considered appropriate, my lords.
Advocate who can come to the High Court, and because he has come, the court shouldn't pass any orders unless
Sir,
and until it warrants.
In fact, my lords,
No, it's filed, seeking the following prayer. The IA is filed, submitted that the IA is filed on 1st of June, and the Land Counsel with the petitioner has argued on the merits of the matter and how the expeditious disposal of that IA is required in the facts of the case. This court is not at all inclined to hear any of the submissions, consider any of the submissions that are made by the petitioner, as IA is filed on the 1st of June, and this expeditious hearing of the matters, in the light of the orders passed by the Honorable Apex Court, this
would
court,
my lords
unless
kindly
and
permit
until-
me to withdraw, my lords?
Do
Grateful. I apologize for troubling the court
Yes.
with any liberty that is reserved, my lords. In the event that with sufficient passage of time, next time, my lords, when I come, I will not come with so much urgency, with some passage of time,
You just withdraw.
with some liberty, my lords, kindly. Kindly, my lords.
No liberty, what liberty you
Lords,
want?
in the event that now sufficient time passes, my lords, in one sentence, 35.5 lakh rupees is frozen in the bank account. If, my lords, this interim order expires this Saturday.
To that order, I have to say something, and you don't want the court to
No, my
express
no, my
anything.
lords, in my memo, I'll just indicate a request for liberty. I'll leave it to my lords. In my withdrawal memo, I'll just indicate a request.
Memo is filed, seeking to withdraw the writ petition. It is stated that if there is any delay on the part of the court in disposing of the matter, they may be given a liberty to approach this court. Dismissed as withdrawn, with the liberty as sought for.
Deeply grateful.
Yes.
Bill number 9, Ashok Kati for petitioner.
Yes.
The petitioner has constructed a building 5 years back, my lords. At that,
What is the
it's,
suit for? What is
the-
this? KEB?
my lords, the building was constructed 5 years back, my lords. The land was converted. It is situated in a village, my lords, which is at a distance of 55-60 kilometers from Bangalore, my lords. There, after giving connection and all, my lords, now the BESCOM has issued notice for disconnection of the power, my lords. Without, my lords, at the time of giving connection, there
Did you notice to serve the papers on him? Was Devraju?
will serve the, my lords, will serve until then, my lords.
Till you serve him, I'll take it up at 2:30 and let
Please.
him get instructions.
Please, my lords, please.
Next.
Bill number 10,
Petitioner.
30.
Lord, the identical matter of the same village, I have argued yesterday and it is.
Where is it listed?
Item 65 in today's list number 3. If it is brought up, my lord sir, please to direct me to file an affidavit also. The affidavit is also ready. I have served the copy on the learned Christian.
Lords,
65.
with respect to this case, my lord, that is writ petition number 17049, my lords. I request my lords, just 5 minutes of my lords, my lords. And also, my lords, I request my lords to kindly make a note of the dates, my lords. I'll just take 5 minutes.
I'm here both the matters in the afternoon.
Yes.
Let me finish the list.
Yes.
My lords, there is no violation of principle of natural justice. Already they have preferred an appeal.
No, I will hear that time.
Please.
Court officer,
2:30, my lords.
call this matter 2:30. Like there is a protocol as per that.
I agree.
This matter along with that, call it along with the 2:30 matters. Yes.
65.
When, my lords, may please to permit me to pass on, serve the copy of the affidavit.
I will take, I will give
Please.
it, I will take it up when the matter reaches.
Please, my lord, I'm
Yes.
grateful.
For admission matter, CL number 11. M. Ashwat Narayan Reddy.
I have filed an application order 7 rule 11A for rejection of claim on the ground that there is no cause of action, my lord. The few facts are necessary, my lord.
What is the
Plaintiffs
suit for? What is the suit for?
suit for declaration and injunction. Father executed a sale deed in my favor. After 1 month, he sets up sons to file a suit for declaration. Apart from that, he has also lodged a police complaint against me. I obtained answer bail. Subsequently, I asked for caution. Police submitted a P report. But there is no, lordship, may kindly see the plaint, averments of the plaint.
Can you please come to your IA first?
Pardon?
Can you please come to your affidavit that is filed in support of the IA?
Yes. IA 3.
Yes, please come to that.
IA 3 at page 37. Affidavit is page 38, Miller.
38.
38, Miller. 3G.
What is at page 24?
24, Miller. 24 plaint, Miller.
No, in my papers, it is affidavit at 24.
24.
Yes,
That is
Venkatesh.
a verifying affidavit, Miller. Verifying of along with it. IA for injunction.
Yes. Page number?
38, Miller. 38. Affidavit. Third para is important.
Please read.
That the plaintiffs have filed the above suit to declare sale deed dated 1/1/2004 executed by defendant number 1 in favor of third defendant by so and so in respect of social property is illegal and not binding at the plaintiff. Further sought for permanent injunction restraining defendant 3 from interfering with plaintiff personal enjoyment of property. The plaintiffs award in the plaint averments that during the year 2010, in way of the residence, the plaintiffs have constructed residential house property bearing number 388, measuring east to west 15 feet, north to south 40 feet, totally measuring so. In survey number, Gomala land so. But they also alleged that they were in possession of social property from the date of construction. The concerned authorities recognized unauthorized construction and provided civic communities, and their mother filed an application to regularize the unauthorized construction to Tahsildar. Yelahanka and paid necessary fee, and further alleged that their mother died.
I have read that. Let's come, please come to the order in the IA.
Order 45, Millard. Page number 45. Reasoning given by the trial court, Millard, Lordship McKay is the reasoning given by 49, Millard.
Yes.
Millard, at the stage of considering the application under Order 7, Rule 11A, the court is required to look only the averments made in the plaint, assuming them to be true without referring to defense set up by the so and so. Assuming to be true without, well, that's not the Supreme Court says that in a if on meaningful reading, not on formal reading, if the court comes to conclude that suit is frivolous and vexed.
So now I looked at your affidavit. You have not stated any specific reason.
I have, my lord, his right is only contingency right. He says her mother filed an application for regularization. He has not produced any documents. Even according to Land Revenue Act, regularization to be filed within 1/6/2020.
Oh, those are all on the merits of the matter, not at the time of rejection of the.
No,
plea.
no,
That
no,
cannot
not
happen.
my lord, when he has no right, my lord, legally.
How is right, how it will be
Oh,
established?
he says that he has only contingency right, my lord. It's not a vested right.
All that
It
can
may,
be
it
decided,
may not happen, my lord. Frivolous suit, my lord. There is no, father executed sale deed, unless sale deed is.
One might be having a good case on merits. Everything can't be decided.
No,
at
no, but
the
he has
stage
not
of-
produced any documents along with the plaint, but Order 7, Rule 14 is a mandate of the law. He has not produced, but only Xerox copies. The Heban case, the Supreme Court says, but plaint can also be looked into along with the documents. He has not produced any document.
So not producing the documents is a ground to reject the plaint as per order 7, rule 11.
11, 11, Order 7, Rule 14.3.
No,
And
Order 7, rule 11, not producing the documents along with the plaint is not a ground to reject the plaint.
yes, court can look into documents produced. He has produced only photocopies.
He has not produced the document.
No,
He has
no,
stated
madam.
something.
No, this
On
is
the face of.
unnecessarily wasting judicial time, my lord. But once his
No,
father executed, see the conduct of the father and son, he sets up there, just blackmailing me, arm twisting methods they're following. I shall leave it to lordship discretion.
Yes, dismissed. Order will follow. Yes, next.
I leave.
Cell number 12. Ketan R.
The matter, the defendant CRP, this matter essentially arises out of a dispute between two public charitable trusts. If I may briefly explain the facts, Bhagwan Sri Satya Sai Baba, my lords, during his lifetime,
Have not filed even the plaint and certain orders not which are passed in this another suit between the same parties. So Lordship will place that on record.
I'll also place it on, take it up, kindly take it up next week.
This is matter next week.
I'll file all the documents with a memo.
Yes, next. Next week.
Cell number 13. Cell number 13. Ravi HK.
Lord, defendant CRP, my lord. Suit is one for partition. My lord, the background is earlier, my lord, the
No, before you, first you can tell me what is the IA.
my lord, IA pertains to rejection of plaint that was filed by the petitioner. The said application was rejected by the trial court.
Come to your affidavit
yes,
and
ma'am.
understand the condition.
Yes, my lord. The IA is at page number 42,
Yes.
annexure D. Affidavit commences at 43, my lord.
You said the suit is for?
Suit is for partition filed by respondent number 1.
Yes. Let's read the affidavit.
Yes, my lord. May I read para 1 onwards? My lord? I am the defendant number 4 in the above case. I submit that averment made in the written statement may kindly be considered as part and parcel of this affidavit and application in order to avoid repetition of facts. I submit that plaintiff has filed suit for various reliefs. Plaintiff claim for partition and separate possession of 1/3 share in the suit scheduled properties and further declaration that suit scheduled properties belongs to the plaintiff and defendant number 1 and 2. Plaintiff has also sought for sale deed executed through court sale in favor of defendant number 3 and further sale deed executed by defendant number 3 in favor of me are to be annulled and cancelled. I submit that plaintiff has also sought for judgment passed in OS number.
The plaintiff, he refers to this OS number 195 of 2011
Yes.
in his.
My lord, that was a suit where the petitioner herein had filed a suit for specific performance against the father of respondent number 1. The suit was decreed and father of respondent number 1 was directed to refund the earnest money. In the said suit, the respondent number 1 was also a party. Since they failed to refund the amount, execution proceedings were initiated. In the execution proceedings, auction was conducted and the respondent number 1's property was sold in favor of the petitioner. My lord, this happened in 2016. Subsequently, they filed a miscellaneous petition seeking to annul the judgment and decree that was passed in the suit for specific performance. Miscellaneous petition was also rejected on the ground of delay in laches. Later, again in respect of the very same property, a suit for partition was filed. The trial court categorically held that they don't have any shares in the property because the property was already sold away in the auction proceedings. By ignoring all those aspects, again a fresh suit for partition has been filed, saying that
the judgment and decree passed in OS number 195 has to be annulled and partition has to be ordered in their favor. My lord, this is impermissible, my lord. There is no cause of action. Suit is barred by time.
Come to the plaint.
Plaint, yes. My lord, the prayer portion of the plaint is at page number 33.
That's in Kannada.
Kannada, my lord. May I just assist this honorable court? My lord, the prayer number 2 may kindly be seen, my lord. Prayer number 2 says that defendant number 3 and 4, the documents that have been executed in favor of defendant number 3 and 4 in the auction proceedings have to be annulled. That is in the court auction. And prayer number 3 pertains to annulment of the decree itself, OS number 195/2011. Therefore, my lord, at this point in time, after the court holds that their miscellaneous petition for restoration is not maintainable.
It is also mentioned in the plaint.
Yes, my lord, I have produced the order, my lord. Repetition order is also, yes, that is mentioned.
In the plaint.
Yes, it is mentioned.
Please come. Then comes to the petitioner, defendant submits that an application is filed under order 7 to 11, that there is no cause of action to file the suit. It is submitted that the plaintiff has sought for cancellation of a decree that's passed in OS number 195 of 2011. And in respect of that, they have already earlier filed a miscellaneous and that came to be dismissed. Having stated all these facts, still a suit is filed. And the court, without considering all these aspects, had dismissed the IA that's filed under order 7 to 11. Considering the same, they shall be stay of all further proceedings pursuant to the order dated so and so. The petitioner shall take out hand summons on the counsel appearing for the respondent and memo shall be filed by 3rd of July or else the stay granted by this court stands vacated. Yes.
Great.
So number 14.
Yes.
In this matter, my lord,
Lordships kindly, my lord.
I represent K-Vitar and respondents, my lord. I seek indulgence to the
My lord,
court.
may I just
granting-
make, it's an
granting
admission matter, my lord.
3
I
days
should have-
time. My lord, it is a miscellaneous proceedings, my lord, wherein, my lord.
Whatever it is, when you file a caveat,
Yes,
we'll only
true, my
hear
lord.
you. But you can't seek
I accommodate
adjournment.
only 2
But
days
it was
time
served-
to file
it was served a
objections.
month
And
ago.
true, my lord. Let me kindly appreciate, my lord.
No, but let
It is
me
not an
have a-
executable order. It is not an executable order.
Argue on the merits of the
True, my
matter.
lord, true, my lord.
Can't- that-
My lord,
that they will argue.
only accommodation of 2 days. My lord, he wanted to engage in senior counsel, my lord. Therefore, my lord, is an inconvenience. Abruptly, the matter is listed before this court. Therefore, 2 days time.
Abruptly,
My lord. Monday, my lord.
whatever matters that are that
True,
are
my lord,
numbered
true.
will be listed.
True, my
No
lord.
abruptly.
I'm sorry for this, my lord. Monday, maybe have it, my lord. Monday, my lord.
Yes, Mr. Senior Counsel.
My lord, your lordship may just hear me for 2 minutes, my lord. This is a case that your lordships would admit and issue notice to them in any way. Let me tell your lordships why.
is
No, my
it
lord, I'll
still
tell your
for
lordship what's happened. A suit was filed.
I'll dispose it off on that day. On the day, on Tuesday, that it come in the first list. I will take it up on
That's fine. That's
Tuesday in the
Please.
first list. At
Great.
request of learned counsel, the respondent.
with the understanding that it will be heard and disposed of.
True, my lord.
No, this court will not grant any further adjournments. And on the day, the court will pass orders finally on the
Please.
petition. Yes.
So number 15, Submit hearing. Akash Kumar Gowda.
Yeah, where is Mr. Devraj? No
H.V. Devaraju.
No representation on behalf of both the councils. This is matter in the month of July.
List number 2 for order. Hearing on interlocutory application by JC.
My lord, final order in FTP proceedings. Appeal has to be made, has to be filed.
Suit is pending.
Suit is not pending, FTP is.
Lords, I
disposed
just
of, my lord.
indicate, my lords.
Suit is pending in respect of other issues.
No. Lords, dispute between mother, daughter and son. Suit for partition is pending. In one of the rounds, we came before this honorable court. All the properties which is subject matter of the list is stagnating without any returns. This is the problem. So everybody is at loss who are litigating. So what this honorable court suggested is, find out it is possible to bifurcate this property by meets and bounds. That is all the order. Lords, may kindly have a look at that order.
Page number.
At page number 108.
is the operative portion of the?
Operative portion, my lords, is
116.
at page number 116. Endeavor to decide IA number 18 after an inquiry in the light of the court's observations. Because of this, I'll have to take your lordships to the court's observations. Now, this is an exercise which was required to be undertaken. There is no direction to conclude the proceedings. Lordships may kindly see what is IA number 18.
The stand disposed of, calling upon the civil court. This order is passed by the
Pardon me, lords. Lord, this is an order passed page 108, my lords. Lords, an application was filed seeking leave to develop the property. It was an application to section 52 of the Transfer of Property Act. Lords, can I just give a little background to this property, my lords? It may be relevant for this.
You are referring to the order of this court.
Yes.
But then where is the order impugned, I'm saying?
Annexed to A, my lord.
Yes.
At page 20.
Order impugned in the present.
Page 29 is the operative portion.
The report of the court commissioner is hereby accepted.
And lords, if your lordships were to see, draw a decree. Where is any question of drawing a decree? Because it's not a final decree proceedings which was conducted. The procedure of acceptance of a court commissioner in a final decree proceedings is recognized under Order 20, Rule 12 of CPC. Now the direction in this interregnum, because this is something which is not known to the civil procedure court's procedure. Because of an indulgence which was shown, my lords, by this honorable court, there was a requirement to find out, because what we said, there is one property which is having great commercial exploitation potential. All the three were parties to one of the joint development agreements. The sister wanted to resile from this. Now, in such circumstances, what we said, please permit us to develop this property. Why should, there are huge properties which are held by the family. We should not be left in a lurch like this. Section 52 application is filed, IA number 13. Said, you permit us to develop this property. Whatever is property, let her take that property. Now, the court only directed that you find out whether it is feasible or not. Because it's an irregular shaped property.
Let's see the IA, what is that order on the commissioner's report? Commission has already submitted a report.
Lords, kindly have a look at page 20, my lords. It extracts.
It says on order on the commissioner's report.
Yes.
With respect to item number 3.
Whether property in item number 3 could be partitioned by metes and bounds, and if such subject property cannot be divided, whether one of them could buy out the other as part of the property.
You are reading where?
That is all the only exercise to be undertaken. Lords, now something like this. In a suit for partition, the holistic or the whole of the property will have to be taken into account for the purpose of creating an equitable partition. That's the requirement under section 2 and 3 of the Partition Act. The reason why I am submitting this is something which could have been worked out via media, is the reason why we came before the court saying that one property at least permit us to do this. So what was the exercise to be undertaken? Lordships have read IA number 18. Now, you see whether the property could be divided by metes and bounds.
So this is pertaining to only suit
item number 3.
The property.
Only item number 3 of the property.
But to the other, the
Suit is there.
FTP
This is something which we wanted as an indulgence from the court pending the suit. The exercise which was directed to be undertaken pursuant to the orders of the coordinate bench is to find out whether you can divide the property by metes and bounds, or if it cannot be divided, if any one of the person
Now,
is ready.
what does it mean? The court says draw the final decree.
Lords, that's the reason why I said, Lords, where is any direction? Something like this. Now let us assume, Lords, that court, while deciding an application of the kind, in the end says you draw up a final decree. But where is any proceedings preceding the drawing up of? Because a decree, if your lordships were to see.
Be drawn after all the properties.
Lords, kindly, yes, because it cannot be drawn. There cannot be a partial final decree. If your lordships were to see, Lords, if your lordships, this is the classical, because so many litigations cropped up, Lords, in between the period of 1950, 1960s, as to whether there could be multiple final decrees. Then the court said there can be multiple preliminary decrees, but there cannot be multiple final decrees. There should be only one final decree. Nonetheless, I'm not on that question. If for some reason the court at the end says draw a final decree, it doesn't become a decree because it should first qualify to be a decree. Lordships may kindly see the definition of decree. It is the formal expression of an adjudication. It should be preceded by a judgment. There are deemed decrees. Now you don't qualify under either of it. May I just take your lordships to the definition of decree, my lords?
No, not necessary. What do you say, Mr.
My lord, can I request not to kindly look at the objection statement filed and kindly look at exhibit R3 along.
Also accept the fact that.
No,
this
no,
is
I'm
only
just
with
pointing
the-
out, my lord. Kindly first see the preliminary decree. The preliminary decree is at page 75 of the objection statement. Now, my lord, in respect of 7 different properties, a suit for partition is filed. Now, my lord, in respect of, my lord, this particular property, both parties, I say it has to be partitioned. They say, yes, it has to be partitioned. Now, my lord, pursuant to a direction of this court, my lord, kindly see preliminary decree that was passed on 23/3/2023, whereby,
Page number,
my lord, it's at page number 75 of the objection statement.
objection statement.
75 objection statement.
If my lord kindly then looks at page 78. My lord, the second last paragraph is further ordered the decree and decreed that the plaintiff is entitled to 1/3 the share in item number 3 of the Schedule A property. It is further ordered that decree that there is no order as to costs, etc. Then, my lord, in fact, this contention that my learned friend is advancing was advanced by us to say that no, we have to wait till all of these get decided and rights are crystallized in respect of other properties also. But they then seek an order from this honorable court. I'm sorry, my lord got the decree. So there was a preliminary decree that was passed on 23/3/2023. Now, my lord, by the order of the Honorable Supreme Court, as soon as preliminary decree is passed, it is that now the duty of the court trying it to pass the final decree. That, my lord, is
So now, is it your submission that the court will be passing a final decree in respect of item number 3 scheduled property 1?
it's already passed. Court has already passed the final decree. I'll point out. Now, my lord, let me in sequence. So, my lord, after this decree, now kindly go back to the order that my learned friend was referring to. The order at page 108 of this honorable court.
Yes. Yes.
If my lord kindly looks at the judgment, kindly go to paragraph number 6, my lord.
What is this order dated 30/8/2022?
Not order dated
8/2022, which is referred at page 110, with the preamble of the order.
Not order of 38.
2022.
Not, I think it's on IA number, there was an IA number 13 under section 52, whereby they said, no, please permit us to construct on this property. We said, no, you can't construct. I am entitled to a share and I don't want to be part of any joint development that you are proposing. Then, my lord, they came up before this honorable court and said, no, you have to consider that. You have to now direct the court. Then the court says, no. Court then directs, now kindly now look at, kindly go to page number 115.
Yes.
The third line. When queried, the learned counsel for the parties submit that this application could be decided finally, and that if on an inquiry the civil court could opine that the subject property cannot be partitioned by metes and bounds, with the plaintiff being entitled to 1/3 share independently, the parties would persuade the court to pass suitable orders as contemplated under section 3 and 4 of the Partition Act. So, my lord, court 3 and 4 says, if it can't be divided by metes and bounds, then we will sell it and pay. So the court says, all right, so you take up this process, and this is essentially a process in final decree. So now, my lord, kindly see, and then this court directs, my lord, kindly then look at paragraph 8. On a careful consideration of the aforesaid circumstance of the case, given its peculiarities, the court is of the view that the petition must be disposed of with liberty to parties to prosecute IA 18 before the suit is taken up for trial, calling upon the civil court to decide on that application after an inquiry on whether the property could be partitioned by metes and bounds. And if the subject property cannot be so divided, whether any one of them would buy out the other party to the party as part of such inquiry, this court must opine that if the civil court is of the view that the subject property cannot be divided by metes and bounds and none are willing to buy out the other, it must pass suitable orders as would be permissible under the provisions of section 3 and 4 of the Partition Act.
Pursuant to this, an exercise was taken up by the court.
By the court. Then, my lord, since we could not agree, the court appointed a commissioner. Commissioners filed a report. The court accepts the commissioner's report and passes a final decree. Now, my lord, all that I am saying is, at this point of time, they may want to challenge it on several grounds. The correctness or otherwise of a final decree, my lord, has to be considered in an appeal. because it is a decree. And therefore, my lord, the final decree, a writ petition challenging a final order in a final decree proceeding, therefore, is not maintainable, is my submission.
This itself would be a decree.
This is a decree. Kindly see the decree. Kindly see Annexure A. Kindly see Annexure A. Order on the commissioner's report with respect to item number 3. Lord, starts at page 20. In the present case, the High Court, in writ petition number so and so, has observed that civil court has to decide on IA 18 after inquiry as to whether the property in item 3 could be partitioned by metes and bounds, and if the subject property cannot be so divided, whether any one of them would buy out the other as part of the property. It was also observed that this court should pass suitable orders as would be permissible under the provisions of section 3 and 4 of the Partition Act. Thereafter, on hearing both sides on 23-3-23, this court allowed IA number 18 under order 12 rule 6, read with 151 filed by the plaintiff. It was held that the plaintiff is entitled to 1/3 share in item number 3 of Schedule A property. On 13-6-23, this court allowed IA number 20 under section 152 filed by the advocate for defendant for correcting the measurements on the eastern boundary of item number 3. As per the suggestions made by the learned counsels for the plaintiff and the learned counsel for defendant number 1 and 2, by way of memo filed on 27-23, this court appointed Assistant Director Land Records, Arnical, and Assistant Director Land Records, Electronic City, BDA, Bengaluru as commissioners. It was directed by this court that the commissioners shall jointly survey land in item number 3 of scheduled property and find out whether it is feasible for division. If it is feasible, then the commissioners shall jointly suggest their proposal of scheme for division of item number 3 as preliminary decree. If item number 3 is not feasible for division in terms of preliminary decree, then they shall jointly submit their report. The Assistant Director of Land Records so and so have furnished a report this court on 22-4-24. Both court commissioners appeared before the court and submitted records for having made the division of item number 3 of the scheduled property. They prayed time to submit the commissioner's report. Accordingly, on 24-4-24, the court commissioner jointly submitted the commissioner's report to the court. The plaintiff filed objections to the report, stating that the report suffers from technical drawbacks on the ground that both commissioners were absent, the superintendent from so and so, and as they have not complied with so and so. Well, I'll skip that. Kindly go to para 5. Defendant number 5 has filed a detailed objection to commissioner's report, stating that the partitioning the property is impermissible as it would render meaningful development of the property impossible, etc. Defendant number 1 is ready and willing to develop the property and so on. Heard both sides on the commissioner's report. Para 6. The advocate for plaintiff has filed written arguments on so and so. On both sides have furnished citations. Defendant number 5 has filed written arguments, etc. The following points arise for my consideration. Then, my lord, may kindly look at on page number 24, my lord, at the paragraph 9, my lord, last 6 lines. They have furnished 4 sketches showing 4 ways in which item number 3 can be partitioned along with access road. Further, as per the query raised by defendants regarding access to item number 4, they have placed a sketch showing the access path to item numbers. I don't get the number from item number 3. Item number 4 from item number 3, which are adjoining to each other. The commissioners have nowhere stated in the report that item number 3, measuring 2 acres 28 guntas or 7 guntas of kharab, cannot be divided, or nor is it feasible for partition. They have mentioned that the shape of the property, the maximum coverage, the maximum ratio available with the width of the connecting road for the property, and they have equally divided the property as per the preliminary decree. The learned counsel for the plaintiff submitted that they are not ready for joint development of the land as suggested by the advocate for defendant numbers 1 and 2. Further, item number 3 mentioned measures total of 2 acres 35 guntas. Hence, a question of selling the land as suggested by the defendant is not acceptable by the plaintiff. The plaintiff is entitled for 1/3 share in item number 3. Further, the sketch 4, that is so and so road, is shown as 9 meters on one side and 12.4 on the other, or another side, so and so, which is not required as it will cause the loss to plaintiff, and hence such a wide access is not required. On the other hand, the learned advocates for defense 1 and 2 submitted that taking into consideration the shape of item number 3, there will be no equitable partition between the shares. The only way maximum profit from item number 3 can take place is by joint development, by putting up apartment complexes, etc. Then, my lord, at the bottom of that first paragraph on page 26, last 5 lines, in the written arguments, they have stated that it is for the court to decide whether there can be a feasible partition, and it is not for the commissioner to decide the same, etc. Then, my lord, page 27. My lord, kindly see para 15. At the outset, it is necessary to note that the commissioners were appointed to give a report if it is not feasible for partition, and if they are of the opinion that division can be done, they should divide item number 3 by meets and bounds. In this regard, it is observed that in the commissioners' report, the commissioners have nowhere stated that partition is not feasible. In fact, commissioners have partitioned the property into 4 parts, including an access road. At first, it is necessary to note that the sale as envisaged in Partition Act comes into play when the property is too small to divide, etc. My lord, I'll skip that. Then kindly see paragraph 17, my lord, about last 8 lines on that page. In view of the discussions made supra, the sketch 4 proposed in the commissioner's report is accepted. Sketch 4.1 is the access road. Block 2 is allotted to the share of the plaintiffs. Block 3 is allotted to the share of defendant number 1. Block 4 is allotted to share of defendant number 2. Accordingly, commissioner's report in respect of item number 3 is hereby accepted. Hence, I proceed to answer point number 1 in the affirmative. Point number 2, my finding on point number 3 is as follows. What is the order? That is, the report of the court commissioner is accepted. As per sketch 4, the property in block 2 is allotted to the share of plaintiffs. Block 3 is allotted to the share of defendant number 1. Block 4 is allotted to share of defendant number 2. The sketch will form part and parcel of the final decree. Office to draw final decree accordingly with respect to item number 3. So, my lord, when a final decree is passed, irrespective of what complaints they may have with regard to the manner of division, etc., that has to be raised in an appeal and not in a writ petition.
That's objection on the maintainability of the writ petition.
Yes.
Yes.
And now, my lord,
Can
can I just place a couple of judgments on the subject, my lord?
On the proposition that there should be only an appeal against a final decree, I will not dispute it. Section 97 is clear on that. The question is, this is an order passed against an order of remand or specific directions with which this honorable court circumscribed the exercise of jurisdiction by the trial court. Whether the trial court in such circumstances was enabled by this honorable court in the order to pass a final decree or not is the only question. Now, if your lordships were to see paragraph number 15, and then I take your lordships to the orders of the coordinate bench, where the trial court commits an error. Ultimately, the application was saying that no, you will have to either, because the property was going vested.
You are the defendant in the suit.
We were the defendants in the suit. Daughter is the plaintiff. Now, I will also point out, the manner in which the sketch has been drawn. It shocks one's conscience. I don't know why the court's conscience was not pricked the manner in which it had seen the sketch.
My lord, they can agitate the sketch in an appeal.
I will submit, because you have read the order. I will submit everything pertaining to the order.
According to them, the writ petition is not maintained.
Para
You have argued
27.
on that. I will pass orders on that also. Now let him argue on the merits of the matter.
Para 27, page 27, para 15, lords.
Yes.
At the outset, it is necessary to note that the commissioner is appointed to give a report if it is not feasible for partition, and if they are of the opinion that division cannot be done, they should divide item number 3 by meets and bounds. In this regard, it is observed that commissioner's report, commissioners nowhere stated that partition was not feasible, etc. The commissioner's appointment, which the court has in its mind, is not to find out whether it is feasible to create a partition or not, but to give a proposal as to whether this partition should be effected or not. That was never the intent of the orders of the court. What the court said is, find out if the property can be partitioned. If it cannot be partitioned, it is better that one of you buys out, because mother and son are on one side, daughter is on the other side. Whoever bids the highest, they will take the property. It's very simple. If that doesn't happen, then you put it for public auction and anything can happen under section 3 and 4 of the Partition Act. This is all what this honorable court suggested. This intermediary, what is undertaken by the court, was never suggested, because whenever a partition is to be caused, the equitable value of the entirety of the property will have to be taken for the purpose of causing partition by meets and bounds, wherever it is a partition by meets and bounds. Nonetheless, the first part of paragraph number 15 is where the court commits an error. The court feels what is required to be undertaken as per the orders of this honorable court, the coordinate bench, is to cause the partition by meets and bounds in the event if it is found that this is a property which can be partitioned by meets and bounds. Now, if your lordships were to see what is the order passed by the coordinate bench at page 108, this is a consent order. They can't go beyond the consent. Paragraph number 7 at page 114. This is all what we had consented before the coordinate bench.
Yes.
It is submitted that in the light of the undisputed position that plaintiff would be entitled to 1/3 in the subject property, an application I number 18 under order 12 of CPC is filed for decree on consent on this application is pending consideration. When queried, the learned counsel for the parties submit that this application could be decided finally and that if on an inquiry the civil court could opine that subject property cannot be partitioned by metes and bounds with the plaintiff being entitled to 1/3 share independently, parties would persuade the court to pass suitable orders as contemplated under section 3 and 4 of the Act. On careful consideration of the aforesaid circumstances of the case and given its peculiarities, this court is of the view that petition must be disposed of with liberty to the parties to prosecute IA number 18 before the suit is taken up for trial, calling upon the civil court to decide on that application after inquiry on whether the property could be partitioned by metes and bounds, and if the subject property cannot be so divided, whether one of them could buy out the other as part of such inquiry. This court must opine that if civil court is of the view that subject property cannot be divided by metes and bounds and that none are willing to buy the other, it must pass suitable orders as would be permissible under the provisions of section 3 and 4 of the Partition Act. That's the reason why this observation is made is, let us assume that commissioner report comes that this property is capable of division by metes and bounds. In such an event, if we don't go for inter se auction of buying out, then the value of this property or the holistic value of this property will have to be taken along with the values of the other properties for the purpose of causing equitable partition. Because the concept of causing partition in every item of the property by metes and bounds is what is frowned upon by the Honorable Supreme Court. The observation is find out whether it is capable of being partitioned by metes and bounds. If not, then you will have to do this. But no direction was ever given saying that you should cause the partition by metes and bounds. It's just something not permissible. Now your lordships may kindly see the report. I just take your lordships to that report.
Page number.
Let's kindly mark, just note somewhere, my lords, property measures 170 feet by 1000 feet. Lords, this 170 feet is the frontage which adjoins the main road. Lords, there we get the maximum FAR. If the entire property is taken into account, we get the same FAR for a 100 feet main road. That is that 170 feet by 1000 feet. Now what the commissioner does is, the commissioner says, front portion of this 170 feet less 9 meters should be given to the daughter. Right? There is some reason for giving it to her, or you should give an option. All right, I will divide this by 3 bits. I take the valuation of these 3 bits. Now front portion, if you take the front portion, because it is there, there is no Euclid's theorem in this. It is there, my lords, in the guideline values. If it is adjoining the road, it is 6,000 rupees per square feet. If it is not adjoining the road, it is 3,200 rupees per square feet. There is no Euclid's theorem in this. What is that the commissioner is required to do? If you want to divide this by metes and bounds, by bits and pieces, you have to divide this based on the value of the property. Say that on this, if I divide like this, then value of this as per the guideline value is this. Bit number 2 is this, bit number 3 is this. Now you choose whichever you want to choose, you choose. That's because what is required to be done is an equitable partition. The reason why the word equitable partition is used is because equities prevail. The calculations prevail. The manner in which the equities are distributed.
What was
prevails.
the report?
Let's now kindly have a look at this report, how they have done this.
Page number.
No, sir. If your lordships go to see, along with the writ petition, page 117 is Commissioner's report. I think there's one. Was my apologies to us. Can I request your lordships may have this matter tomorrow on this, because the reading of this report may be necessary, because the commissioner says that by dividing the property in this manner, the intrinsic value of the entire property is lost. He's made that specific observation. But my apologies, because I have to file the English translation. Tomorrow your lordships may have this matter. Because
this matter at the top of the list tomorrow.
Then number 2 for orders matter.
Sorry, my lords, I should have my sincere apologies. But serial number 2, my lords, I am appearing for the. So, very, this is a little peculiar case, my lords, of course, arising again to the final decree proceedings. Can I just pursue
What
your
happened to
lordships? May I
this
kindly have a
notice
look
to-
at the family tree?
Notice to R15. R15 not necessary.
There are address
Not
and
required.
documentation.
May I just,
Not necessary, is a formal party.
Yaru?
R15 is a formal party.
R15 can be dispensed with, my lords. I'll get a memo filed.
That a
We'll get a
is
memo filed.
Memo is filed stating that notice to R15 is, R15 may be dispensed with, memo is taken on record, dispensed with at the risk of applicant. Yes. What is the impugned order?
Lords, the impugned order is appointing a commissioner to submit a report regarding the feasibility for division of the properties by meets and bounds. There is one peculiarity to this case. It stands or sinks only on this question. Lords, every partition is required to be carried out per stripe per capita. Now, I will take it as generation 1, generation 2, generation 3, G1, G2, G3. A suit for partition was filed in G2. Suit is decreed. 5 items of properties are subject, 5 items of the properties are there in that G2 litigation, where there is a direction to divide the property by meets and bounds. That final decree is still pending. Decree is not yet drawn. Now, those 5 properties are included in a litigation in one of the branch of G3, saying that there should be a partition by meets and bounds. Now, if a commissioner is to be appointed, because there are multiple items of properties, commissioner should be aware as to which is the property which will be allotted to the share of G3 in the suit for partition in G2. Generation 2 suit is amongst the parents. So now the children are who are litigating in respect of one of the branch. Can I just pursue it, my lords? There is one genealogical tree. This is essentially where the entire dispute arises.
Yes.
Lords, page 3.
Yes.
The first round of litigation which I am referring to is between the children of Veerappa, that is Rudramma's son, Basurajappa, Iramma, Rudrappa and Bakkappa. That is type 1.
What is the suit?
Lord, suit is OS number 149 of 2014.
When was it decreed?
Lords, this is available for your lordship's consideration at page number 255 of the very same paper book. And the decree was drawn, the decree was passed on 30th of October 2014.
Only this family is, this 1, 2, 3, these 4 are the parties.
So Lords, Veerappa, Basurajappa, Iramma, Rudrappa, Bakkappa.
Only these are the.
This is that stripe 1.
Yes.
So now there is a suit for partition. There is a preliminary decree. Final decree is still pending for the preliminary decree which is passed.
Yes. Next.
Now Rudrappa's children are litigating in the present suit. That page number 3.
Father is a party.
Father is a party in the earlier suit. Now the contention is that father will get a share in that part.
So whatever which comes on that, they will have a partition.
Have to get the partition here. So now first thing is properties will have to be identified as to what falls to the share of Rudrappa in the.
What is this suit? This cable.
Second suit. Second suit is that what properties of Rudrappa is there should be divided amongst 1 to 13.
Suit number.
Suit number OS number 26 for 2022. 2010.
And this, who are parties to this?
Milords, these Rudrappa's children, 1 to 13. Milords, I have given the rankings there, Milords, so that.
These are the parties.
These are the parties.
What is the stage of this suit?
Milords, this suit was though decreed, Appeal is filed. In the appeal, it is said that don't draw up the final decree.
When was the decree?
The suit was decreed on 31st August 2023.
August 20?
3.
But how can this suit be decreed?
Lords,
When the dispute
No,
with
no.
regard to
So
what
far
is
as
the joint.
declaration of shares is concerned, that can be adjudicated because preliminary decree will be passed merely declaring the shares. Declaration of the shares, there is no difficulty. It can be declared whether somebody is entitled to a share or not entitled to a share.
No, for example, this 2014 suit.
Yes.
If the final decree proceedings are concluded.
If it is concluded, then of course, it is known that what properties will fall to the share of KB Rudrappa. If properties fall to the share of KB Rudrappa in a suit amongst his siblings, then Rudrappa's property can be brought to partition amongst his children. Now the same principle, Lords, like what I expressed in the last.
No, in this suit in OS 149 of 2014, court has given a particular share to so and so.
Yes.
Then now without that, when that appeal and the final decree proceedings are pending, then how this can be decided?
That is essentially, Lords, what we said, that until and unless there is a demarcation of property by metes and bounds in the first tier litigation, in the second tier, it will not be permissible for them to undertake anything. It will be a futile exercise because commissioner once appointed, Lords, there cannot be multiple commissioners because commissioner who is required to be appointed has to give a holistic report, taking the entirety of the value into consideration and causing the best possible partition amongst
Let us see what is the decree in this OS number 149.
Lords, I was taking your lordships to page number 255. At page 280 is the decree. 1/4 share, page 285.
One-fourth share is
To
granted
Veerappa, Basurajappa, Rudrappa and Bakkappa.
So in this property, Rudrappa has 1/4 share.
1/4 share.
Now, in the suit that is filed by Rudrappa, what are the properties included?
Lords, there are properties which are other than the properties which is subject matter of this suit. So there are about 5 items of the properties which is replicated in both the suits. That is 2023 suit and 2014 suit. 5 items of properties is also included in the second suit. Now, in order to cause a partition by metes and bounds in respect of the second tier litigation.
Part of the properties are concerned. That is nothing to do with the other family.
Not at all, not at all, not at all. It is certainly not at all, not subject matter of this.
First
Yes,
suit,
first
OS
suit.
149.
Now, the question is this, Minos, for the purposes of causing any partition, even for a commissioner to submit a report, if all the properties are not available, where is any question of commissioner undertaking any exercise? Because, it's the exercise which is to be undertaken by the commissioner is to take the holistic, survey the entire property, take the holistic values of the properties, and then say that this properties can be divided and given, this property in its entirety can be given to somebody.
What has happened to this final decree proceedings of?
It is still pending. OS number 149 of 2014, final decree is still pending. If your lords were to see, Milords, at page number 129, Milords, the same paper book. Page 296, Milords, I am sorry, Milords, I stand corrected.
Yes.
The final decree proceedings, judgment and decree in the final decree is stayed. At page 297. Now, Rudrappa having died, they are also parties in the said suit.
Now, please come to the present impugned proceedings.
Please, Milords. What's the order impugned is an annexure E at page number 70. Somebody.
Yes.
The petitioners have filed the instant application seeking to appoint a court commissioner to
That is in the
demarcate.
second suit.
That is in the second suit.
Hmm.
To demarcate the 1/12th share of each of the petitioners in the scheduled properties.
But here-
Item number 1 to 8 and 11 to 27, which are the properties for which the decree is passed.
No, that's true. Which are these properties are part of the earlier suit?
Lords, in this item numbers 1 to 21 to 23.
1,
2, 21 to 23.
1, 2, 21 to 23.
1 to 20, 21 and 20 to 23. Correct, Allah? 20, 21, 20 to 23. Yes, 20 to 23. Stand corrected. 1 to 20 to 23. Now, if your lordship were to see, the last paragraph in para 3 in page 71, last 4-5 lines in para 3. Further, he has raised several contentions with regard to existence of agricultural lands. Contended RSA so-and-so is pending before Honorable High Court. Also, stay is granted. Hence, sought for dismissal of the application. I take your lordships to the details of the application. Then, what the court feels, if your lordships were to see, it's an ipse dixit order.
No,
The petitioners-
that order, after the preliminary decree is passed, what is the present state with regard to the second?
In the second suit, my lords, in the second suit
No,
of,
no RA is filed.
my lords, RFA is filed.
Filed.
In the first appeal, there is a direction that the final decree proceedings can go on, but the final decree should not be drawn. That there is no difficulty, my lords. We have never said that. Now the question is this: if the commissioner is to be appointed, the object is that you will have to get the entirety of the property and find out whether partition can be divided amongst these properties. Because there were days when, of course, that was a question which came about, my lords, when section 54 of the Code of Civil Procedure, as it then existed, said that you will have to go before the revenue authorities and they will cause the partitions. Of course, that was amended by means of a Karnataka amendment which said that no, your revenue officers cannot cause the partition. They can only give a report. The court will have to undertake this exercise. But when this was being done, what the revenue officers did was 1 acre of property, 4 shares, divided 10 guntas, 10 guntas, 30 guntas, divided 4 bits. So like this, everything used to happen. When the matters came up, they said partition by metes and bounds does not mean in respect of every item of property. Equitable partition means you have to take the entirety of the property and its relative values and cause the partition as equitably as possible in a manner that they get the properties proportionate to their shares.
Yes.
That's the law. Now, if your lordships were to see page 72, my lords, no reasons are assigned. The petitioners have filed the present petition seeking to demarcate 1/12 share over the petition scheduled properties as per the preliminary decree passed in OS number 26 of 2010. Some of the respondents have appeared and filed objections to main petition opposing to allow the same. During pendency of this petition, petitions in the instead application seeking appointment of commissioner to demarcate the properties. Respondent has filed detailed objections opposing appointment of commissioner on the ground that other portion of the past in preliminary is in ambiguity without allotting shares to different number 2 to 6,
Yes, sir.
allotting 1/12 shares so on. So RSA. Then what is the reasonings? Just paragraph number 8.
I've seen that.
Admittedly, that is all the reasonings.
We'll ask them.
So let them, I will not say that. Let the trial court reconsider. If the trial court still feels it can be done, then it's a different matter. But the trial court should record a finding, whether it is permissible or not in the teeth of what has been contended.
My lord, appeals have been filed. The same grounds have been taken up there. It is now the trial court, my lord, has passed a decree decreeing the suit for ancestral properties as well as self-acquired properties of Rudrappa. The children of Rudrappa are before the trial court.
1/4 share is allotted to him in the first round of litigation, that is in Moes. Now you are seeking partition of the share in the property in the subsequent suit that is filed by you. How it will be determined?
My lord, there are two sets of property.
Now in the first set of litigation, what is your 1/4 share?
1/12 share.
1/4
share of Rudrappa.
What is that 1/4 share has to be determined?
Has to be.
And that 1/4 share, how are you, the children of Rudrappa, are entitled for that has to be
My
determined?
lord, what is available for partition now? Now, I may not get that.
you have included the properties which are part of the earlier suit and which is pending consideration now. How can that be? How can that be?
That can be left out, my lord. We'll work out our rights in that FDP.
In that case, the order should have been, the order should make a mention
My lords
about
may
that.
say so. I have no problem.
As far as the property is.
I will just say this, my lords. A legal issue is there. When commissioner submits a proposal, because this is some law which is developed over the years, in relation to properties, the proposal to be submitted by the commissioner should include all the properties. That is the law.
No, that is.
I am not getting into this question. The reason why,
No.
let it be considered by the trial court.
Sure. This petitioner has nothing to do with some of the properties which are the self-acquired properties of Rudrappa.
Well, so far as
That exercise.
that exercise to be undertaken, the relative values of the properties.
That is their problem.
Well, that's the reason why I said it is not like that. For the purpose of a procedural compliance, as has been held by this honorable court, the properties which is subject matter of the list for which the decree is passed, in respect of all the properties, there is a requirement of the commissioner submitting a report. Otherwise, there is no way that there could be an equitable partition.
Even that is their problem. Whether it is you are not concerned with those properties of the within the family members.
Within the family members also.
They don't have a problem. Let them decide.
No. I am also one of the family members. We are in appeal. Appeal is passed an order. Don't drop the final decree. But the question is, in the absence of some properties as available for partition.
That is the argument. What I am saying is there are 1 to 21 properties.
Yes.
In respect of only
about 6 items of properties.
1 to 20 to 23.
Yes.
You according to you, that is part of the earlier
correct
final decree proceedings or the preliminary decree proceedings. So what about the rest of it? You are not at all concerned.
No, my lord. So far as rest is concerned, we have raised an objection saying that the preliminary decree stops at saying, if your lordships were to see, what is the contention
that is
raised?
You can clarify whether you are claiming any right in respect of the other properties.
Lords, rights will be there. My lords, the present case, my lords, is not deciding any of the rights. Let me be very clear. This is not deciding any of the rights of the
It
parties.
is not this case. I can understand. Even in respect of the other self-acquired properties of Rudrappa, it is the case of the other defendants that that they are entitled. That is not a self-acquired property. It is a joint family property, and it has to be divided between the parties. Then it stands on a different footing.
Lords, now I would put it this way, my lords. Whatever properties came to Rudrappa in the suit for partition in the earlier suit also forms his self-acquired properties for the reason that this was a partition under section 8. So there is no difference between the properties which comes to him under the partition and the properties which are otherwise also the properties in the second suit.
You are not part of Rudrappa's family.
I am a part of Rudrappa's family.
No, you are not.
I am, lords. That's why. Let's.
No,
Lords,
you are the.
No, we
you
are
the brother of Rudrappa.
No. Lords, is my kindly see. Kindly have a look at page 3, my lords. I'll just explain this.
Page number?
Page 3. Serial number 10. He is the son.
Oh.
He is the son.
No, I was under the impression that you belong to this sector. KB Basappa.
No. We are not. That's the reason why I said the second round of litigation is only amongst the children of Rudrappa.
And you are the son of Rudrappa.
I am the son of Rudrappa. Now, I am not saying that, but the trial court has to apply its mind. Trial court cannot say, I'll consider your objections, or your objections cannot be considered at this stage. That cannot be the reason given. Trial court at least has to say as to whether the contention raised by me is legally correct or not.
No. Even this son of Rudrappa, that is at
serial number 10.
Serial number 10. They should take it to some logical line.
Milords, we have. Milords, I wanted to say this.
It can never be kept pending.
No. It is not about that, Milords. So far as the 10th defendant is concerned, the suit for partition is being fought upon on the premise that these properties has already been given by means of testamentary and non-testamentary dispositions in favor of sons only. These are the documents which has not been accepted by the trial court on some flimsy grounds.
According to you, this final decree proceedings cannot be taken up. The court.
Now the question is
that process. Then you should have sought for an order in the RSC.
Now it is something like this, Milords. In the appellate court, the subject matter is as to whether the preliminary decree is correct or not. Now, whether the declaration of shares, whether it is correct or not, is in the light of the contention that we set up that there are non-testamentary dispositions and testamentary dispositions which disables the other sharers from claiming share.
Whether the final decree proceedings or passing of the final decree proceedings are stayed
Yes. Passing of final decree is stayed.
in respect of the second suit,
Yes.
that is second appeal.
Yes.
So the court has permitted the other proceedings to go on.
Milords, that's the reason why I said I have no difficulty that other proceedings should go on is not the difficulty, Milords. But when I
What other
say,
proceedings, my lord? Only this.
when I say that the commissioner can be appointed only in respect of all the properties where the properties are clearly demarcated and available in the family for partition. This is a contention which had to be considered because the contention which we had raised is that over a period of time, the law has been settled that it is not permissible to take a piecemeal basis of causing partition. You will have to take the holistic and entirety of the value of the property for the purposes of even getting the commissioner's report. This is essentially what we have said.
Yes, heard, reserved.
Lordship's grateful.
Lord, may I submit one submission?
Yes.
My learned friend said so many properties. Only one property is there in that suit.
Not,
Not five.
according to him.
No, I
it
will
was,
just give the survey number.
Page 286 of the paper book they have filed, item number 1.
He said 1, 2, 20 to
I'll just
20.
point out,
no,
can I,
it is not, sir.
I'll just do one
20,
thing, Milord. I'll ask my, my advocate on record to draw up the list of comparative tables and then give it before the Honorable Court. I'm not, because yesterday night we have verified and then
Serving
making a
a copy on
statement.
us, my lord. He doesn't serve a copy on us. He,
Yesterday
Whatever.
also, no. Yesterday also I asked him, how are you serving the papers? No, when you have it, you should serve it. You should have given it to them yesterday itself. They would have the advantage of looking at it.
Very well, Milord. Milord, only this much. If they want to dispute that these are all the properties, let them stand guard because I'll give the list.
No, you please, no. Let him, whatever that he is giving it to the court, he will give it. And looking at it, whatever you want to, you please give it, both give it to the court officer.
Milord, I'll just give the comparative list of the properties which I said is
Whether
the
it is correct or not, you can file a memo.
Let them say that it is correct or
That is
not.
pending in that final decree proceeding, where we are now parties, father having passed away.
Milords, I have one difficulty, Milords, one nimsha. Milords, this practice of keeping the parties present, of course, your lordships will not be influenced, but this thing is something where your lordships will have to
Lord, I
frown
have
upon.
told them
No,
100 times.
no,
I
it's
don't
not about
see
that.
them in office.
No, I did not see
They
because
come-
I never look at my back. Lord, this is some practice which
My
your
lord,
lordships,
may I ask
because
them, my lord, I asked them not to come to
lords,
office.
it is not about that. Whenever such
have a
things
right
are there,
to come to court.
lords, this is not the way. Because there are several instances where the courts have frowned upon the practices of keeping the parties present. It is not proper. The council should stand guard for
I
this.
am
They
not
should
aware
ensure.
of any such law or practice, my lord.
I will place
Parties
the
are
judgments.
allowed in court.
Lords, one of the judgments of the Supreme Court said, there the parties stood up and then folded his hands. The court observed that his gestures indicated that he is trying to impress or gain sympathy from the court, which practice is deprecated. The lawyer was also reprimanded. If he wants it, I'll give the judgment.
Maybe
Lord,
in that
these are
case
all
it
the
is so,
things.
my lord. I am.
No, very. This
My lord,
is,
I have appeared in so many cases. I have never kept parties
Counsel,
present.
leave it there.
I will leave it at that, Milords.
Yeah.
But I'm just saying
My
as a
lord,
matter of.
But my point, my lord, one submission.
Because whether.
No.
As far as
Very
this court
unfair.
is concerned, advocate, senior advocate or party doesn't matter. I'll go by what it is. But still it is not required. Their presence is not
My lord,
required in the court.
my lords may ask them.
I'm
my
not
lord.
saying that you ask them to come, but generally ask them not to come
They
to
have
the
been
court.
coming
It
from
doesn't
4
matter.
days. I have been telling them you are getting good oxygen from Kaban Park. My lords may ask them. I asked them to not to come to court.
Yes.
Lord, one submission. That is where my, what happens, Lord? They have filed an RSA. That in that RSA, in the earlier suit, in the second generation, there is an FDP pending. In that RSA, the proceedings have been stayed.
I've seen that.
In that FDP. Now, only one property is pertaining to that. Only, my subject, even
whatever.
Now, what happens, my lord? There is a throttle on our. We can't proceed in this case. We can't proceed in that case. And we are ladies who have filed this suit. We have obtained a decree.
That's essentially what I wanted to say, that they wanted to keep them present to get the sympathy of the court. Law should not be decided on the basis.
I am sorry again. My lords may ask them, my lord, I'm not,
I think.
my learned friend knows me, my lord, I have never done something
Both
like,
of you-
No, no,
I
I'll
will
take it
never
back.
do such a thing. I will never do
Because
such.
when Mishra comes,
Both of
I'll
you
have to
have
take
to
it back.
understand the
He's a good
court's
friend of
time is
mine.
valuable and I'm waiting for this matter to get over. I
That
don't
is,
want any more
I am
further
only
outside.
submitting on the merit.
Yes.
Now what happens, my lord, there is a throttle, I can't proceed any further. If one property that is there in the previous thing, I leave it open for decision in that FDP.
Yes.
We are parties there also,
I'll
because
consider.
our father has passed.
I'll
Is
consider.
item number 20 in
My
the
lord, may I-
present case, please. Lord.
Please, my lords, great.
Item number 20 in the present writ petition.
What
It
is
is
that?
earlier suit, please lordship. It is item number A.
Oh, for that, a note is being, now they will give a note. If you have anything, you please give.
Please,
My lord, may I
please, great.
submit? My lord, I appeal for respond number 12. My lord. So respond number 12 stands on a completely different footing. He's not a family member of K. Rudrappa. My lord. And even his property is concerned with only with respect to item number 17. My lord, I purchased the property from defendant number.
No, your case can be decided independently.
I'm not deciding. My lord. My only request, my lord, I purchased item number 17 from defendant number 4.
Whatever their, the rights that are, of your vendor, you will get a share in that.
My lord, may I submit? I'll not take more than 2 minutes. I understand. My lord, I purchased item number 17.
As far as this application is
Please,
concerned,
with respect to that, I
your
have.
case will not at all be considered on a different way. Whatever the defendants are selling, you will be selling with them.
Please, ma'am. With respect to that, I have a difficulty. Ma'am. Lord, item number 17 I purchased from defendant number 4. With respect to demarcation of share to defendant number 4, my lord, there is no demarcation with respect to defendant number 2 to 4. And the trial court has not decided as to what is the amount of share which will be going to defendant number 2 and 4
Find any, have you questioned that?
in the FDP. My lord.
No, here.
Lord, I filed wakalat, no objection I filed.
Then, not wakalat. You are agreed by the order of the
Please.
court. You have to prefer a writ petition. You have to file a writ petition against that.
I'm not.
That means when you are supporting the order of the court.
No,
Yes, next.
Name,
please. Great.
hearing on interlocutory application, cell number 3, Nataraj Ballal, for petitioner.
Yes.
My lord, I have filed an IA to replace the Annexure D, Annexure
I
B.
have 1 for 2026 for permission. What is this permission?
My lord, we have filed an order sheet instead of impugned judgment that can be allowed
And
to
you got a
replace.
stay in this.
Not sure.
When was the stay granted? Without filing the impugned order? What is this? Where is the interim order and why is it, where is it stated? Ask her to correct that order. Yes, what is this IA?
For the to replace the Annexure B, my lord.
To replace annexure?
B.
What did you file annexure B?
We have filed an order sheet instead of impugned judgment, my lord.
Then why should we allow it? If that is the impugned order, according to you.
No, my lord. It was
As-
by it was a bona fide mistake, my lord.
I number 1 of 2026 is filed. I number 1 of 2026 is ordered. Yes, next.
Cell number 4. Cell number 4, Nataraj Ballal.
I appeal for the petition. My lord, it's a suit for injunction declaration, my lord. I'm the defendant in the suit, my lord. I had filed an application under order 18 rule 17 for recalling and for marking of documents by
When
defendant.
was
my
the
lord.
suit? Which year is the suit?
My lord, the suit is of
2004.
2004, my lord.
When was the evidence completed?
My lord, the evidence was completed in the year 2020. My lord, by
When was the application filed?
My lord, the application was filed in 2025. My lord, it is.
Too early.
My lord, not because of that, my lord. But
Come to your affidavit. Nothing more to argue on that. You can come to the affidavit. What did you say? Why you want this?
Similar application has came to be rejected earlier.
See, what did she say? Where is your affidavit?
My lord, the application which I filed. That page number 35, my lord.
35.
Yes, sir.
Affidavit, I am referring to the affidavit. At 36, yes.
Yes, ma'am. 36. Lord, in this particular case, it is.
Let's read from your affidavit. Let's understand why you
I'll read
wanted this.
from paragraph number 2, my lord. May I? Yeah. May I?
Where is the impugned order?
Lord, the impugned order is in page number 15, my lord. 15, page number 15.
Reasoning it from 19 on.
The reasoning is from page number 19, my lord. Yes. Court has only given reasoning telling that sufficient time was given, and that is why, my lord, I would like the honorable court to go through the order sheet once, my lord, when the exact things happen. The order sheet I have attached, my lord. Lord, in this particular case, the number of dates after the suit was filed, number of dates the plaintiff itself did not appear, my lord. Subsequently,
Plaintiff not appearing before the court cannot be a
that is
reason
not.
for you to file.
Yes,
So
my
we'll not
my
go
lord,
into
no,
that.
my lord, I'm not.
I have looked
Then
at the affidavit.
subsequently, they have
No,
gone
I have
into.
looked at the affidavit.
Yes.
Why you wanted this, why you filed this application? There is nothing. Just you say that initially I have not prosecuted the matter, so you should be open. That cannot be a ground
My
to
lord,
open.
because these two documents are very relevant for this particular
Why
case.
did you not file it at the earliest?
My lord, in this particular case, plaintiff themselves have filed this particular documents as exhibit number P13, my lord. Subsequently, they filed a memo and it was discarded by the honorable
When was
court.
that?
My lord, that was in page number 90.
Which year?
Lord, that was in the year 2010. My lord, subsequently, after that, the evidence was valid. This was, my lord, in 2020, the earlier counsel passed away. Subsequently, I came on record. My lord, that is
This
not
kind
the
of
reason. But
applications can't be allowed.
these two documents are very important documents, my lord, because without these two documents, we cannot adjudicate the matter itself. My lord.
Dismiss.
My lord, there are two, my lord, may I submit, my lord, two reasons, my lord. My lord, this application we filed in the year 2021 also. That the court rejected again with the same ground, telling we took 39 adjournments. Lord, it was not we who took 39 adjournments. Court took 2 years to pass an order on our IA, my lord.
So now you're finding fault with the
Why
court.
no, my lord. My lord, I'm not finding fault because I'm just telling how the 39 adjournments came. That's all.
Even
My
if
lord.
you file the application in 2022, then also this is not a
My lord,
case
but
to be allowed.
that is when we came on record before the honorable court. my
Whenever
lord.
a new
My lord,
advocate comes on record, that's not it will not start from the day.
Lord, subsequently, then D1, we filed an application to summons
no,
D1. My lord, give last one opportunity for,
No.
my lord, expeditiously, we will not drag the matter, my lord. Kindly tell the honorable court to
Dismissed, I don't see any reasons. Yes.
consider the application, my lord, and give us one opportunity to.
Yes, next matter.
Bill number 5, Venkatesh Prasad R for petitioner.
Order will follow. Dismiss.
Narayan.
This file.
I represent
In this case, appear for the
respondent.
petitioner. Lord, in this case, the petitioner had filed a suit in OS number 2816 of 2023 for site number 5.
What is the suit for?
Suit for injunction, my lord.
What
My
is the
site is
IA?
5.
What is the IA?
IA, the trial court has passed an order for clubbing 2 suits, my lord, which I'm disputing. Lord,
What is the one suit is filed by you?
I filed the one suit.
For injunction.
Injunction.
What is the other suit?
They have also filed a suit for injunction.
Which year is your suit?
My suit is of the year 2023, my lord.
Their suit?
is also 2023.
He shouldn't be clubbed.
No, that's the reason. My site number is 5, my lord. Site number is 5. And they claim that they are the owner of site number 6. I have disputed that they are not the owner of site number 6, and the owner of the site number 6 is also a different person. And I have both of us, my lord, even the defendant, the respondent also purchased a property from the same predecessor title is the same, my lord. Kamama is a person who has sold the properties. For me, she has sold site number 5. For the respondent, she has sold almost 17 sites.
No, that I understand. What is the difficulty if this both?
My lord, they are not the owner of the property at all. First, in the injunction suit, they have to read that they are the owner of the
So in your suit, he is a defendant.
Yes, my lord. Since they are trying to identify.
In his suit, you are a defendant.
Yes, my lord. They are trying to.
Reasons are required.
My lord, they are trying to identify my property as site number 6. It has been clearly demanded. I have produced the. Kindly come to page number.
Come to the order of the court.
It is not a speak. Kindly come to.
Order of the court.
Please, my lord.
Number 28.
Page number 25, my lord. Relevant pages at page number 27. My lord, I produced all the substantial documents.
Read paragraph number.
Yes, ma'am.
28.
Reason is page number 28.
Yes. Both.
OS number 2816 filed in respect of site number 5, carved out of survey number 6/1 of Kathurguppe, Uttaralli, Bangalore South Taluk, stating that plaintiff purchased said property under registered sale deed dated 9/9/1971 from his vendor Srimati Kamama. Defend number 1 in OS number 20. It's not 2816, it's 1670. Defendant has filed the OS number 1670. The defend number 1.
Your property is 5, his property is 6.
6.
Now, what is the dispute you have with him?
My lord, my first contention is that he is not the owner of site number 6. And site number 6 owner is different. I produced sale deed before the trial court also.
No, why you wanted injunction against?
Since he is trying to identify site number 5 as site number 6, and he was interfering with my purpose.
What is this case?
His case is that I am trying to interfere in this case, in this site. So under those lines, I have filed the case. I have produced all these documents which clearly says that as regards site number 5, I have produced sale deed. As regards site number 6, present owner.
If you have produced all the documents, court will decide. So that is not a reason why.
My lord, there are the documents which is in Kannada. I'll produce the translate copy also. No, the thing, my lord, the problem is that if at all, if the owner of the site number 6 is proved, then the question arises for him to maintain the suit for injunction.
He is alleging that he is the owner.
But I've produced a document, I've produced all the title deeds.
Considered what is the difficulty if it is if the suits are clubbed? What's the difficulty that I'm not able to understand?
My lord, if the case is club, my lord, I've already filed a CRP. I've filed a 7-11 application before trial court that came to be dismissed by the same trial court. I've challenged before the Exam court is pending for consideration. In the status court order was passed in my case. Subsequently, they have challenged that it's pending in MFA, my lord. Again, this clubbing application was filed by them, contending that there's a common evidence has to be laid. My lord, if you kindly come to page number 9 of the petition, man.
Understand.
There are differences. The differences which is there.
That is on the merits of the matter.
Kindly come to page number 9, madam, of the petition, madam. The differences that I've clearly mentioned.
It won't make any difference. If you want to take time, I will look at all the papers. But I have a view on
I've
this.
produced voluminous documents, my lord, which clearly shows that I'll file the translate copy and convince the court, madam.
Maybe still the court that it has to be clubbed. This must.
No, my lord, I'll convince the court, my lord. Substantial documents are there, and when they're.
Yes, convince the court now. Take it. Yes, you convince.
Kindly come to
when I
page
indicated to you, then if still you are not understanding, I can't help.
Page number 9,
yes.
my lord.
Yes. Yes.
My lord, there's no common thing which is property number 5, my lord, and the defendant is for property number 6, site number 6.
This common is dispute.
Common in dispute is that I'm trying to interfere in their property and they're trying to interfere in my property.
Not sufficient.
But the property is
seeking declaration of title.
Let there be the separate evidence. I have no issues, my lord. I'm not telling that in this case. I'm not telling that it should be dismissed. All I'm saying is that
your contention is everything. What are all different? You have stated here.
Yes, ma'am.
In that view of the matter, that there cannot be the suits can't be.
Let there be 2 evidences. That's all I'm saying.
Yes, this was. This next.
Serial number 6. AS Udappa.
My lords, for modification and production of document.
What is this clarification by advocate by what is the clarification?
My lords, status quo was granted. My lords,
No,
My
don't
lords,
worry. We'll hear the other side is served. We'll now hear the matter and
Please,
decide
please,
the petition. No clarification is required.
please, my lords.
Yes, please.
Lords, sale, my lords, I purchased a scheduled property, my lords, on 12th of November 2024.
What is the suit for?
Suit for bare injunction, my lords.
What is the IA?
IA, my lords, order 39 rule 1 and 2.
Granted?
It is not granted, my lords. Therefore,
What
oppose
happened
this,
to the appeal?
my lords.
What happened? Haven't. It is
Order
not-
39 rule 1 and 2 filed, my lords. It was not allowed.
It was dismissed.
It was
Then it-
emergent notice was issued, my lords.
Where is that? Page number?
Annexure A, my lords, page 15.
Page number?
Page 17, my lords.
Page?
Sorry. Page 18, my lords. Issue emergent notice on IA. IA number 1 and suit summons to defendant
When is it is returnable by?
27/4/26, my lords.
No, what has happened after that?
My lords, it is pending, my lords. Notice is issued to the defendants. It is pending, my lords.
Is notice served on the defendants or not?
Please, my lords.
Then let the court decide.
My lords, my only submission is, my lords, my predecessor, that is the vendor, he has a interim injunction.
First of all, you are not entitled for a status quo before this court. Go before the trial court and let the trial court decide your IA.
My lords, my predecessor also has an interim injunction, my
Court
lords.
decide. Why should the High Court decide your case? Please come. Where is that notice issued? Page number?
Page number 17. My lords, may I please request my lords to please take page number 14, my lords, for an instance.
Without
Page
going
number
into page
21.
number 14.
Please, my
On an IA that's filed by you, listen to the court. On an IA filed by you, court without passing any order issued summons to the
Please, ma'am.
respondent. I will set aside that order and ask the court to decide your application. I will not be sitting here and deciding what the trial court has to do. Again, it's not where you have an appeal.
Please, my lords, I agree, my lords. My only request is, my lords, till the IA is heard, let there be an order of protection. The only reason I'm saying that, my lords, my predecessor in the title from this very
Immediately decide.
no, my
And
lords,
you have been-
my lords, with respect to the same property,
When April, when April was the date, until June, your matter is
my lords,
pending here.
on 25th, my lords, on 25th of March, the impugned order was passed.
What happens is, by
On the very
giving
next
these
day,
kind
I'm
of
here.
orders before this court, we would be unnecessarily complicating the litigation.
My lords, all that I'm requesting is, let the matter be sent back. I have no issues. Till the trial court decides, let there be an order of protection.
There is already, you have a status quo.
Lots of problem is, my lords, I'm only explaining, my lords, I may not be able to convey properly. My predecessor in title, with respect to the very same scheduled property, had filed an injunction suit before the very same court. And with respect to the very same property, the trial court, after hearing both the parties, has granted an order of injunction. On parity, it had to be extended to me, which the court has not done. The reason, my lords, is now if the order is not extended to me, some rank strangers I've mentioned in my petition are demanding 30 lakhs from me.
Court to decide the matter within 1 week, whatever interim order earlier granted by this court, which you were enjoying or which you are happy with it from the long time, let it be continued.
Please,
I will not alter that. This,
The interim order was granted by this court.
Status quo.
Please, my lord, with respect to possession.
I don't know, whatever it is, it will continue.
Please. No, the reason I had filed for clarification is.
No, we will not clarify. Without any, this thing, why should the High Court do this exercise and keep the matters pending before the court, staying all the suits?
I've not requested for a stay of suit. It is my own suit against which I filed an appeal.
The present writ petition is filed. Where is that order?
Page number 17 minutes. 18, I'm sorry, it's page 18.
The petition is before this court, questioning a notice issued, the summons issued to the defendant on I number 1, where petition has sought for ad interim injunction. A coordinate bench of this court, when the matter came up for preliminary hearing, had granted an order of status quo, that is pending the granted status quo, and notices were issued to the respondents and the same were served. The land counsel of the petition submits that when the petitioner sought for injunction, the court ought to have granted the injunction and ought to have considered the IA that is filed without issuing notice. And if the petitioner is not entitled, court ought to have dismissed the IA. But without passing any order, court cannot issue emergent notice. He has not relied on so and so. And it is submitted that till when this court has expressed the view that the matter will be remanded, it is submitted that till the IA is decided by the court, the possession of the petitioner, so that there may be a protection order. There may be an order protecting the interest of the petitioner. Next part. This court had disposed of several writ petitions, relying on the judgment of the apex court in case of, relying on the judgment in case of, that is, the other day PKN has taken, asked him, so and so. And in the light of the same, the order impugned, the order date 27/4/2026 is set aside. The court shall consider the IA number 1 filed by the plaintiff as expeditiously as possible, within 1 week from the date of receipt of the copy of the order, till such time the interim order that is granted by the court, that is an order of status quo, shall continue.
There was an order of status quo with respect to possession, my lords.
What did the court say?
Order of status quo, my lords. The reason, my lords, because possession was not mentioned, they were not allowing me to enter the property. That is the reason.
Let it continue after 1 week when the court passes the order, then you can have. Yes.
Grateful.
Cell number 7, Shiva Prasad Shantan Gaudar, for petitioner.
Appearing for petitioner in cell number 7, my lords.
Petition in 7.1. You are in 7. Who appears? You appear for.
For respondent number 2 and 3 in item number 7, and for 2 in 7.1, your lordship.
Respondents have to file
Actually,
object.
there are 2 matters.
Your lordship. I appear for 2 and,
Where is the third matter?
my apologies, respondent number 2 and 3 in item number 7,
Hmm.
and only 2 in item number 7.1, your lordship.
Notices are served on all the respondents?
Please.
Yes. You are ready?
No, your lordship, I seek for a short accommodation to file my objections, your lordship.
What objections you will file?
We are awaiting technical comments in this
Order
matter,
in your
lordship.
favor?
Please, ma'am.
Interim order granted is extended at the request of Land Council respondent. This is matter in the month of August. Yes.
Cell number 8. Preliminary hearing 8, G.R. Lakshmipati Reddy.
For respondent number 6 and 7, my lords. This matter, the WP 25/991 Ali, an application is filed by the defendants 2, 6 and 7 to transpose themselves as the plaintiff number 2 and 3. That application has been allowed and against which this writ petition.
What is the second one?
Pardon me?
There are 2 writ petitions. What is the second one?
Second one is I have filed an application to withdraw the plaint with a liberty to file in a fresh
You want to withdraw the
plaint itself. So that has been,
Want to withdraw the suit?
Suit.
With the liberty to file a fresh suit.
yes, my lord.
That was dismissed.
That was the,
When was the suit filed?
the suit was filed in the year 2009.
2009 suit, you want to withdraw in 2026. Why?
2000. The facts is this, my lord. When the suit was filed,
Come
by
to
the,
your-
by the first plea,
Come to the affidavit that is filed by you. Which writ petition is that with regard to withdrawal of the suit? Which writ petition pertains to withdrawal of the suit?
withdrawal of the suit, that writ petition 25/924.
Give that. Let's see your affidavit, why you want to withdraw.
Yes. my lord. Annex D, my lord. Page 53.
Page?
53. My application,
Why you want, let's see.
and I'll kindly refer to the affidavit filed with from para 2. I filed the above suit along with the defendants 6 and 7. In view of the certain complications and disputes between me and the defendant 6 and 7, they have been transported as defendant number 6 and 7. The above suit is filed for the partition of 1/5 share and for possession, and also for a direction to the defendants 1 to 3 to pay a sum of rupees 1,18,000 rupees towards the rent realized by the defendants 1 to 3. The suit is in respect of property bearing old so and so and so. Then the defendant,
The original suit filed,
my lord,
what is the suit?
original suit. See, in the original suit by the plaintiff and defendants, see, the defendant 6 and 7 was, there is an empirical that she,
For the plaintiff in the suit.
I am the plaintiff.
What is a prayer in the plaint?
For a partition, that was suit against the defendants 1 to 3. They are the brothers and sister in respect of a particular property. So here the conflicting interest in the defendants 2 and 3 alleged to have been adopted by the first plaintiff.
That will also be decided by the court.
Adoption. And then subsequently in the proceedings, there is a dispute regarding the adoption between them.
No, that will be decided eventually, whether if the court has to decide whether they are entitled for any partition or not.
No.
In that process, they will also decide whether they have any nexus with the joint family property or not.
No, the test is the defendants 2 and 3 have been they're transposed as the defendants 6 and 7, plaintiff 2 and 3. They are the adopted children of the plaintiff number 1, and there is a dispute regarding the adoption. They would, that apart. Now, in view of the transposing them as a defendant 6 and 7, the entire format, the pleadings has been, the case has been set up, it will differ. The defendant 6 and 7, they filed a counterclaim, and they have paid a court fee also on the counterclaim. Issues have been framed, and it is at the time of where they have to cross-examine the plaintiff in this matter. Now they wanted to again retranspose as the plaintiff number 2 and 3, and so in spite of the having already transposed
Come
by
to
the
the order. Please come to the impugned order. In this writ petition. Para number 17. Para 17.
Para 17 of the order, my lord. Further, it is contended that a suit for partition is peculiar in that all the plaintiffs and defendants are of the equal status. All defendants are plaintiffs and all plaintiffs are defendants. The plaintiffs and the other defendants actions are suppresso et expresso falsi. The plaintiff and the other defendants has filed PNDC number so and so without disclosing the material facts about the rights of these, or at least their existence and dispute. Plaintiff is barred by Article 23 Rule 1 bracket A of CPC from withdrawing the suit without the consent of the other plaintiffs and defendants. So plaintiffs have not sought the permission as mandated under 23 Rule 1A. The plaintiff has sought to withdraw the suit after close to 15 years. At such a belated stage, after her evidence, cross-examination, and after contesting this case on her and her adopted children's on 11/1/2024, the court was dismissed the IA 6 Rule 17 CPC, amended the plaint, and thereby transport the objectors as defendants 6 and 7, and they have filed a written statement, and the court has framed the additional issue on 6/6/24. Further, it has been contended that defendants 1A and 1B.
Yes, I have seen this order. Yes. What do you say?
Pardon me?
Anything further you want to submit? I've seen this order. I've seen the impugned order.
Ah.
Yes.
So therefore, when in view of see, now in view of, see, the plaintiff is in view of the transposing the past plaintiffs 2 and 3 to the defendant number 6 and
When he
7.
was transposed as a plaintiff, when was that order passed?
They have been transposed in the year 20. There is
That order is questioned along with this order.
No,
Which
that's
year
not
is
question.
that?
That's not question. That is 13/6/25 is when that, 13/6.
No, in the other.
That's not a part of this, the documents, my lord. On
25991.
13th June 23,
That's
we
what I'm
were
saying.
originally the plaintiff number 2 and 3. We were transposed as 6 and 7 due to dispute among us. When we sought for an amendment, the court felt that since there is a dispute among the plaintiffs, we cannot be sailing together. Hence, they placed us as defendant number 6 and 7. Once that is done, we were given an opportunity to file a written statement wherein we have made our claim that we too have a right.
It was
Once
done.
that was done,
It
issues were framed, burden was placed on us to prove the case. Now
wa-
plaintiff now, since she is coming alone, she filed an memo of withdrawal saying that you can allot this property to the defendant 1A and 1B. But that aspect has been challenged by me and an issue is framed on that. We filed an IA number 9, which is not challenged. It has attained finality.
IA number 9 seeking?
IA number 9 is not been challenged by them, my lords. I may be permitted to file
Earlier
this.
transpose was on 11/1/1924, my lord.
That was not questioned.
It was transposed as a
That was
defendant.
not questioned.
That is transposed by me. Then we are not,
Hit with that.
they have not. Again, they want to be retransposed as the plaintiff number 2. It was transposed because of the conflicting interest between the mother and adopted children. Therefore, they have been transposed. So now again, they want to join the mother. Now there is a total dispute between the adoption. Adoption has been seriously disputed. And they have deserted and
Defendant
the
number 6
children,
and
they are
7
not
are the
taking the
adopted
care
children
his
of the
mother.
plaintiff, who is a petitioner. She has set up her case, she has proved the adoption also.
And
Now she wants
they
to
are-
go
and
back on
in
her
fact,
own.
They are not the necessary party. They cannot question and comment in this partition suit. This partition suit is by the first plaintiff against their own brothers and sisters in respect of their personal property. And if he has to independently, if you prove his adoption and he is if he become the adopted children, then they can claim a right in respect of the property of the adoptive mother. But this property is not the adoptive mother's property. It is the ancestral property of the plaintiff.
What is that?
Well, this is with respect to the order. If
Judgment?
yes,
Pass.
there is a direct on the question of this whether in a suit for partition
You're right.
a plaintiff has
Responded to. Yes, I'll go through that. Look, both of you pass on the judgments. Yes. Heard reserved. Yes, next 9. Yes.
All it is, sir. Sir, in first matter that he may be directed to take notice, connected.
In 25991 of 2025,
Prakash.
Mr. Vaidya Prakash submits that he has instructions to. You appear?
I am for respond number 3, my lords. A Madhusudan take to file Wakala.
yeah, but respondent number 3 has not even filed an objection in the trial court. It is between us.
Copies have been served.
No.
Yes.
In serial number 8, you represent whom? You have not filed wakalat in.
I filed wakalat, my lords.
Your name is not there in.
My name is there. I filed wakalat. I have the acknowledgement.
8.1 it is there.
8.
8 also you.
I'll check, my lords. If not, I'll file the wakalat.
It is submitted that they'll file the.
On 6th
instructions to
April
file
and,
wakalat.
On 6th April and 4th March, I've already filed, my lords.
It is submitted that both the counsels, both of you have filed.
I did not file, my lord. I will file.
In 25991, I filed on 6th April.
Yes. Yes. Next
So
9.
number 9, Raghu Prakash. Raghu Prakash for petitioner, KH Pradeep.
Yes.
The suit for partition, my lords, the plaintiff had filed an application to perform a DNA profiling test between the LRs of the plaintiff and LRs of the deceased defendant number 2. My lords, the suit is for partition. Only when there is when there is no evidence to come to a conclusion in any matter, only then this right to be exercised, my lords. But in this matter, the plaintiff has already relied upon Exhibit P1 to P14, wherein his birth record, his college admission test, admission card, and SSLC marks cards have already been placed before the court.
Court has allowed that application.
That application has been allowed, my lords. My lords, my only submission is that, my lords, in absence of any other evidence to prove, only then it is necessary. Now, the original plaintiff is also not there.
If it is done, what is the prejudice to you? It's a scientific proof.
Here, the question before the court is not proving the paternity of any child, my lords. It is only related to a suit for partition of immovable properties, which can be decided by means of documentary evidence.
Let's see what is the IA and how the court has allowed it.
My lords, if I may take your
Page number?
The trial court has heavily relied upon this judgment, my lords, passed in.
Here is the order.
29 page. No. The order is at page
submission.
18, my lords.
My lord, one submission. They have served the petition only. They have not served the copies. That is through WhatsApp.
I will serve a copy, complete copy, my lord.
This is matter. Next week. Yes, 10.
Cell number 10,
Or number 2.
Angadi, SV.
This matter may please be passed over.
Pass over. Yes, 11.
Cell number 11,
I press for a short accommodation, my lord.
Does this matter in the month of July? Yes, 12.
cell number 12,
Could there be a date fixed in the matter because it's emanating out of execution? 2020,
It is there.
and they're taking
My lord,
rents,
sir,
they have to deliver possession. Now, my lord,
There is no stake. Tell the court that no stake. Court should proceed.
No, my lords, there is a stay by defer the matter, my lords. On previous
Where,
date, there is
11, there is a stay.
the court had asked, my lord, that the
for
matter
defer
be
the
deferred
matter in
till
trial
the
court,
next
my lords,
date.
in execution.
It's a 2020.
Order.
It was a deference, my lords, that the matter be posted on so and so date after this.
Interim order.
Maybe listed tomorrow only.
Then
my
why
lord.
are you asking time?
No, my lords, it may be listed tomorrow only, my lord, due to some personal emergency. Senior is not in.
Tomorrow is
What about the court's inconvenience? Every matter to become tomorrow and everyone will be ready with
Due to
100
some
memos.
medical emergency. my lords.
This is matter on 17th of June, no further adjournments. Interim order earlier granted is extended. Yes, 12.
Grateful,
12,
Your
Manjunath.
Here for the respondent. Respondent. The petitioner not being the plaintiff, filed this suit for specific performance agreement dated 87, 25th and 1987.
I will take up this matter after. It will start from me and all FASOs and 230 matters I'll take up at 4 o'clock. This list will continue.
Yes.
And no mentionings now. Show her and change it. No, change it in the. And all the stenographers, how many orders are pending, which are not from our chamber, who have come from the court, find out. No. How many matters are pending with them to type?
For 230 yesterday matter.
Sir, reserve matrix positions to follow. Reflection of pending revenue estimated ಅಂತ ಒಂದು ಲಿಸ್ಟ್ ಬೇಕಂತೆ ಮೇಡಮ್. ಆ ಬುಕ್ ನೋಡ್ಕೊಂಡು ಒಂದು ಬರ್ತೀವಿ. ಅಲ್ಲಿಗೆ ನನ್ನ ಹತ್ರ ಬುಕ್ಕಲ್ಲಿ ರೌಂಡ್ ಆಫ್ ಆಗಿಲ್ವಲ್ಲ. ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ರೌಂಡ್ ಆಫ್ ಮಾಡ್ಕೊಂಡಿದ್ವಿ.
ಟಚ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲೇ ಸರ್ ರಿಸರ್ವ್ ಆಗಿದ್ದು ಯಾವ್ದು ಪ್ರನೌನ್ಸ್ಮೆಂಟ್ಗೆ ಬರ್ತಿಲ್ವಲ್ಲ ಒಂದು. ಈಗ ಇದು ಬೇಡ ಇದು. ಇದು ಫೈಲ್ ಅವ್ರಿಗೆ. ಝೂಮ್ ಮ್ಯಾಟರ್ಸು ಅದೇ ಅದು ನಿಮ್ಗೆ ಡೌಟ್ ಆದ್ರೆ ಒಂದು
65. Myself filed impleading application. My name is not shown in the cause list. Myself filed impleading application, but wrongly shows that the counsel for the petitioner filed impleading application. No, no, myself, Chandrakant R. Patel, filed impleading application. Kindly, my lord, my name may be shown in the cause list.
When, what happened to that? Whatever it is, no, what is the consequence? Well,
But
the
my
matter
other
is-
side told me today matter is listed. I don't. My name is not.
Anyhow, that will not reach that matter, so let's not go to that at all. Yes, call the list.
The list number 3, one first matter that is morning.
It's not there.
Is there. List number 3, serial number 1.
For the petitioner, sorry.
What is the liberty of seeking? Why do you want a liberty and what for liberty? Counsel for the memo is filed.
As
Stating
part
that
of
the dispute between the parties is amicably settled and then the petitioner wants to withdraw that petition. However, a liberty is sought, but why they want the liberty is not stated. The petition is dismissed as withdrawn. Memo is taken on record. Yes, next, call the list.
List number 2, serial number 12, list continued.
This settlement, my lord, I made a mention in the morning.
That I will take at 4 o'clock.
4. Well,
Yes.
Serial number 12,
Upper for petition.
Anjunda Swami, yes.
This matter, my lord. The petitioner is the plaintiff before the trial court. He filed suit for specific performance of the agreement, earlier agreement dated 25/10/1987. When the matter was set down for evidence, my lord, plaintiff evidence. At that time, lord, the plaintiff filed an application seeking amendment to the plaint. Lord, the Honorable Trial Court, lord, after considering the, lord, in page number 43, my lord, page number 43, ink page 43, the point for consideration, my lord, number 1, whether the proposed amendment is proper and necessary for complete adjudication of the
It's allowed.
case and which is affirmative. And my lord,
Where do you get that order?
order, my lord, order at annexure F, my lord, page number 40, my lord. Page number 40.
I think the wrong, which case is this?
9688 of 26. So number 12.
Page number?
Page number 40, minute. Annexure of page number 40. Page number 43, minute. 43, minute, point for consideration whether proposed amendment is proper and necessary to complete adjudication of.
Hereby dismissed.
It is affirmative. The trial court, my lord, held that the proposed amendment is necessary. But, my lord, it is negative in, my lord, it is not due diligent.
You get that?
Ink page number
What are the
43.
issues that are framed?
Issues as framed, issues already framed.
No, with regard to this IA. Whether the proposed
Yeah,
amendment
43,
is proper and
43,
necessary.
minute.
Whether plaintiff has shown due diligence in filing the present application.
The-
So first issue is held in affirmative.
One in affirmative,
Hmm.
first one is affirmative, though, my lord, trial court held that, my
Please
lord,
of the, which year, 2013?
2013, my lord.
Let's see the first issue.
Kindly have this claim, my learned friend has not produced the original claim when the suit was filed.
Really,
He
let-
has only produced the amended claim. This is very crucial. He wants to seek specific performance of an
No,
agreement.
let me look at this.
First, trial court held that, my lord, the proposed amendment is proper and it is relevant.
Let us read the order, why the court said it is proper.
Order, my lord. In the case, point number 1.
Now you are seeking the additional paragraph with regard to adverse position.
Adverse position. Adverse position.
Suit is for specific
Suit
performance.
for specific performance.
Both are inconsistent with this.
Yes.
That is, my lord, because, my lord, the agreement, my lord, first agreement in the year 1982 and second agreement in the year, my lord, 87. subsequent agreement. My lord, he has filed suit, somehow he filed application, my lord, for adverse position, seeking adverse position. My lord, the honorable.
What is this finding of the court?
Finding of the court, no, that is the reason I am coming. The finding of the court, just a minute.
Paragraph
Sir,
number
please.
6, finding.
Finding of the court, the trial court.
That, but what is that finding? How can it is there? How is it necessary in a suit for specific?
Necessary,
performance?
para number 5, my lord, page number 43. It is the case of the plaintiff for specific performance of the contract based on an alleged agreement of sale dated 25/10/87 and 29/2/88, wherein the plaintiff has filed present application under Order 6, Rule 17 of CPC, procedure seeking amendment applied by insertion of additional paragraphs, and the relief with regard to adverse position against the possession of the defendant over the suitable property. It is the contention of the plaintiff that the
That can't be
plaintiff.
allowed. I've seen it. How can it be allowed?
When
You
the-
file a suit for specific performance.
Performance.
Suit is of the year 2013.
13.
Now in 2025, you realize that you have perfected the title by adverse position, and now you seek the prayer to amend the prayer and by including. Is it permissible?
My lord, according to my submission, my lord, is permissible under law, my lord, and also, my lord,
So
it is
whenever-
relevant.
No,
it is
whenever you
relevant.
remember something, you can file a petition and it is relevant, and you can introduce a new case.
It is
You
not
never
a new
sought
case,
for-
my lord. It is not a new case.
No, suit, what is the stage of the suit now?
Stage of the suit is not cross-examination of PW1. My cross-examination is there. Yet to commence. Yet to commence. Cross-examination not yet commenced, my lord, as per my instruction.
He has not turned up for 3 days. That also has been, may not, for a moment, take the.
Let him complete, I'll ask you. Yes.
My lord, the trial court, my lord, once
What is the
come,
due diligence?
regarding due diligence, my lord.
What did you say in your affidavit?
My affidavit, my lord. Affidavit at page number 32, my lord.
Yes, let's see.
Page number 32. Para number 2, my lord. I state that now the case is set down for my cross-examination. In other words, in real sense, the trial is not yet begin. I have traced out the cause of action for this suit basing on the indenture and unregistered agreements to sell dated 25/10/1987 and 29/2/1988. Since that date, and as on this date also, my father and after his demise, I am in settled, continuous and lawful undisputed disturbed possession of the plain scheduled property. As such, my possession is not disturbed by the said Madappa and his LRs. That is the defender.
Anything with regard to due diligence? Why you have not sought for this relief? Or just like that, you file an application and court will not allow it. After how many years?
Suit filed after 20 years. 87 is alleged agreement. Suit filed in the year 2013. First amendment in the year 2017-18. Now this amendment when cross-examination commenced. My lord, kindly see that plaintiff, my lord.
But-
He has not sought possession at all in the earlier plaint. That came to be amended. And he says, when he was searching in the house, in one almirah, he got a paper that is 25/10/1987, allegedly executed by the father of the respondent in favor of father of the petitioner.
In that agreement, possession has been handed over to the plaintiff. We are in possession.
Specific performance of the.
Why do you want to argue when the court is with you? It's for him to argue. Let him argue, Mr. Counsel. Let's not waste the time. Yes.
I'm not. Para number 4, para number 3.
No, whatever it is, you-
Once
your-
the
your-
trial court come to a conclusion that, my lord, the proposed amendment is relevant and to it proper to adjudicate all the issue between the parties, my lord. My lord, it is the trial court had to have, my lord, allowed the application, my one submission. Number 2, my lord, I'm relying upon, my lord, that I have already earlier court. ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್ ಲಾಸ್ಟ್ occasion. In the case of my lord Arinath Tilar, Justice Allah Baksa versus Mohammed Hussain, I have already produced
Where is that?
last date of hearing, my lord, when I argue with
Supreme Court judgment.
ನಮ್ಮ ಅವರ one high court judgment.
Who is the author of the judgment?
Author of the judgment, my lord, ಇದು ಹರಿನಾಥ್ ತಿಲಾರಿ.
You read what is the proposition?
Propositions, my lord, para number 23, it is well settled that the decision of the Privy Council and Supreme Court mentioned about that possession of a person under invalid deed of transfer after entering into possession of it, prima facie becomes hostile and adverse to that of the real owner when the transferee claims ownership on the basis of that invalid deed, and that on completion of continuous possession for the required period of 12 years or more.
On the merits of the matter, we are on the point, how you have filed this application, at what stage it is filed, and why you couldn't file it at an appropriate time, and where is the due diligence? Neither there is an averment in your affidavit.
In the averment in the affidavit, my
Nothing
lord,
you said, I've read your affidavit. You have not stated anything. Just saying that.
they are
I have to
saying that
protect
it's
my
necessary.
possession
It is
and I have
necessary and
protected
relevant.
that.
It is necessary and relevant.
Yes. Dismissed, order will follow. Yes, next.
Then number 13. 13. Reattach.
No, I said no matters will be passed over on this count. If senior counsel comes, he'll argue. Otherwise, you argue. I'll not pass over. Yes.
The petitioner challenging the impugned order passed by the trial court on IA number 50, my lord, which is at page number 143, my lord.
Where is it?
143, my lord, at annexure P. Filed by defendant number 2 in the suit, my lord, under order 8 rule 1A of CPC. My lord, suit is between my lord stepmother and the children of first wife of the deceased, my lord.
Suit for partition.
Suit for partition. My lord, in the year 2014, she has filed a suit. In the year 2015, my lord, defendant number 1 filed a statement, written statement, my lord. In that written statement, he did not aware about the existence of any will. Later, my lord, in the year 2016, he filed amendment application with regard to the existence of will, but he did not produce the copy or original copy of the will along with the written statement, which is mandated as per order 8 rule 1A of CPC, my lord. My lord, the trial court has framed the issues. All the parties except defendant number 1 led their evidence. At the stage, my lord, in the year 2026, he came up with an application under order 8 rule 1A of CPC stating that he is now seeking permission to produce the copy of the will, which was not produced. My lord, all the parties are already led their evidence. Now we sought to produce the alleged will, my lord. May I request your lordship to take his IA, my lord, for a moment.
Where is it?
At page number 130, my lord. I request your lordship to take page number 130, affidavit.
Yes.
My lord, paragraph number 4 is the relevant, my lord, relevant portion. I submit that I am producing the original will dated so and so, and which was not produced earlier because of confronting the said document in the cross-examination of the plaintiff and also defendants, claiming that the plaintiff Srimati Lakshmi so and so have not admitted the said document in the cross-examination, and at last, when it is confronted and on 6/2/2026 to the DW Ramesh, he also did not admit the document, and thereby now I am producing the original copy of the will. My lord, my contention before the trial court, my lord, I beg your lordship to take my statement of objection, my lord.
Not necessary. We'll go to the order.
Order at page number 143, my lord, at annexure P.
Yes.
Trial court, my lord, casually passed allowed the application filed by the defendant number 2. 143, my lord. Annexure P. My lord, I relied on up to 8 judgments of Honorable Apex Court and other high courts, my lord, without considering that, my lord, casually allowed the application and allow the defendant number 2.
Let's read the reasoning. How casually the court has dealt with it.
Please, my lord, reasons at page number 148.
Yes.
From from paragraph number 8, my lord.
When were the issues framed?
Framed in the year 2015, soon after filing of the return statement.
Read.
After completion of all the parties' evidence, at the belated stage, now he sought to produce the alleged will, my lord.
Yes.
Now I beg to take your lordship kind attention to Order 8, Rule 1A of CPC, my lord.
Order 1, rule
Order 8, Rule 1A.
8.
My lord, may I read? Duty of the defendant to produce the document.
On there, I kind of keep it. There are so many other books. This one here.
May I read, my lord?
Yes.
Rule 1A, duty of defendant to produce document upon which relief is claimed or relied upon by him. Where the defendant bases his defense upon the document or relies upon any document in his possession, my lord, it was in his possession, my lord, that is admitted fact. In his possession or power in support of his defense or claim or set off or counterclaim, he shall enter such document in a list and shall produce it in court when the return statement is presented by him, and shall at the time deliver the document and copy thereof to be filed with the return statement. Where any such document is not in possession or in power of the defendant, he shall wherever possible state in whose possession or power it is. 3. The document which ought to be produced in court by the defendant under this rule, but is not so produced, shall not, without the leave of the court, be received in evidence on his behalf at the hearing of the suit. My lord, this exception is relying upon, my lord, is based on this exception. Nothing in this rule shall apply to the document produced for the cross-examination of the plaintiff or the witness, or handed over to the witness merely to refresh his memory. My lord, I beg your lordship to take 5, my lord, which is Karnataka High Court amendment. The defendant shall endorse on the return statement or annexed to the list of documents on which he relies, whether he in his possession or power or not, or as evidence in support of his defense or case, and the provisions of sub-rule 2 and 3 of Rule 14 of rules order 7 of this court shall as far may apply thereto. My lord, now my lord, I request your lordship to take Order 13, Rule 1, my lord. Order 13, my lord.
Yes.
Production, importing and return of document. Original document to be produced at or before settlement of issues. The parties or their pleaders shall produce on or before that settlement of issues all the documentary evidence in original where the copies thereof have been filed with the plaint or return statement. My lord.
Order 13 rule.
1. My lord, Order 7 rule, my lord, Order.
Yes.
My lord, Order 8 Rule 1A, Order 13 mandates the defendant to produce the all original document which is in possession, my lord, which is relying upon. He did not produce those documents, my lord. After completion of evidence of all the parties, all of a sudden, my lord, he sought to produce those documents, my lord. I relied 8 judgment before the trial court, my lord. None of the judgment was discussed, my lord. My lord, I already submitted apex court judgment, my lord, in Sugandhi's case. On the last previous date of occasion, my lord. I said,
Sugandhi.
please, my lord, Sugandhi.
Which paragraph?
My lord. My lord, in the Sugandhi's case, my lord, same order 8 rule 1A was discussed, my lord, from paragraph number 7. The Honorable Apex Court has extracted the provision of order 8. Then, my lord, I beg to take your lordship to page number 4. Sub-rule 1 mandate the defendant to produce the document in his possession before the court and file the same along with his written statement. He must list out a document which is in his possession or power, as well as those documents which are not. In case the defendant does not file a document or copy thereof along with the written statement, such a document shall not be allowed to be received in evidence on behalf of the defendant at the hearing of the suit. However, this will not apply to the document produced for cross-examination of the
That
plaintiff.
is all repletion of that.
Please, my lord. My lord, in this case, my lord, the Supreme Court allowed the application. In that case, my lord, the document was in his possession. My lord, kindly take page number para 10, my lord. Coming to the present case, the defendant have filed an application assigning cogent reasons. Here, there is no cogent reason, my lord. The possession of the document is with the defendant number 1. And they have stated that these documents were missing and only traced at later stage. That cannot be disputed that these documents are necessary for arriving at a just decision of this court. Now we court below have granted produce the document. My lord,
To rely on this judgment.
my lord,
Why do you want to rely on this judgment?
my lord, in this judgment, my lord, kindly take paragraph number 9, my lord.
Yes.
It is often that procedure is not handmade justice. Procedural and technical ideas shall not be allowed to come in the way of court while substantial. It is the procedural violation does not seriously cause prejudice to the adversary parties. Court must lean toward the substantial justice upon procedural.
Should have cited by them.
My lord, in this case, my lord, they have cited before the trial court. I have distinguished this judgment, my lord. Even Delhi High Court, my lord, distinguished this.
Whatever judgments you're relying on, please pass on, so that we can save some time. Take that. Yes. Yes. What about Delhi judgment? Which paragraph you're relying on?
My lord, I will. My lord, even in Andhra Pradesh High Court, my lord, 2003.
First, come to this Delhi judgment. You don't have a copy of it?
One more judgment.
Where in this judgment also, this Sugandhi judgment was
yes, my lord.
discussed by the
Sugandhi
court.
judgment, and also one more judgment was discussed, my lord. That judgment also they are relied before the.
What did it say?
In that case also, my lord.
Here the distinction that is drawn is no reasons are stated.
Please, my lord. From paragraph number 6, my lord.
Yes.
The Honorable Delhi High Court has discussed about the Sugandhi's judgment.
Para number 16
my lord.
is relevant.
And also, my lord, 10, my lord. Levaka Pedda Reddam.
This is, I have seen the judgment. Next.
My lord, then, my lord, ultimately, my lord, Honorable Delhi High Court, my lord, dismissed the application filed by the.
In that. Then come to the Himachal Pradesh judgment. Which paragraph?
My lord, in Himachal Pradesh judgment also, my lord, on the same point, they did, on order 8 rule 1A CPC, Ultimately, at belated stage, my lord, dismissed the application, my lord.
Para 15.
Please, my lord.
Yes, next.
Next, my lord, Andhra Pradesh High Court judgment I have produced, my lord. 2023 SCCI AP 2638.
Where is this judgment of Karnataka High Court?
Karnataka High Court, my lord. I
WP
have
number 23634 of 2025.
Here also, my lord, the production of documents at the belated stage, my lord, even though it is the suit pertains to commercial courts act, commercial suit, my lord, this honorable court, my lord, in detail discussed the matter and held that, my lord, the document which are there in the possession of the parties must be produced along with the return statement. That is the view taken by this honorable court, my lord.
Para 9.
Please, my lord. Even this honorable court has discussed various judgment of apex court, my lord.
Yes, I've seen that.
And more importantly, my lord, the exception which they have relied upon, my lord, not applicable.
In this problem. Yes.
One more judgment, my lord, Supreme Court, my lord.
Yes, Andhra Pradesh High Court. Which paragraph?
My lord, my lord, that is also on order 8 rule 1 year CPC. And the
Paragraph
same
number.
issue, my lord. Ultimately, my lord, the honorable Andhra Pradesh High Court, my lord, dismissed the application, my lord. Para 13, my lord, important. Para 14.
Para 18.
13, 14, 15, 16. From 13, my lord.
Yes. Yes.
My respectful submission, my lord. Even the exception which they are claiming under order 8 rule 4A, rule 4, order 8 rule 1A sub rule 4, my lord, will not applicable because at that time of confronting, they did not file any application before the court. My lord, the rule says, my lord, by way of application, they have to confront. And that stage is also exceeded. After exceeding all the stage, my lord, it is not permissible for them to file the additional document which is after 9 years from the date of filing the written statement. My lord, this is my respectful submission, my lord.
Yes.
Lordship, can you see? The equation itself is not interval. Lordship, can you see the prayer, the equation? Page 19. That's seeking question of the order. First prayer.
Yes.
My lord, one more, my lord. After completion of senior proceeding.
It is order dated 24 to 2026. Then the second prayer, issued in the nature of an.
No, unfortunately, in all the writ petitions, these kind of prayers we see every day. What he is not entitled, we will not consider that. So as far as the first prayer is concerned.
Because what happened in this case is Lordship already the document was bought. 90 pages of cross-examination was done by that.
There is no interim order in this.
My lord, what happened, my lord? My lord, I will convince your lordship. My lord, on 24th of February.
And the question of questioning this direction to Lordship will see. And how can they discard the entire evidence?
My lord, on 24th to 2026, the trial court was passed an order allowing the IA number 50. They did not upload the order in the e-courts and they did not issue me the certified copies. My lord, then my lord, in the month of March, after one month, my lord, I have filed application under section 151, directing the registry to issue the certified copies of the order passed on
Was it issued to you?
28/3/2026. By that time, my lord, the trial court proceeded with the order. Even I have made oral request, my lord, to upload, at least upload the order so that I can challenge before the High Court. They did not issue. When the formal IA is filed, my lord, they have uploaded and 2 days after, my lord, they have issued me the certified copy. I have stated in my writ petition also, my lord.
No, the evidence is concluded.
The evidence of defendant number 1 is come to an end, my lord. He has also relied on additional evidence, my lord, that is going on, my lord.
No, only the respondent.
Yes.
Additional.
Yes.
Your Lordship grants it the judgment of the Honorable Supreme Court. Put up. On the April 1, the fact that the High Court as well as the High Court has ruled the hereditary law in not permitting the defendants to produce documents. The relevance of this can be examined by the High Court on the basis of the evidence to be made. But to deprive a party to the suit not to file a documents even if it is delay will lead to denial of justice. Next, it is well said that the rules of procedure are a handmaid of justice and therefore even if there is some delay, the trial court should have imposed some cost rather than the declared provision.
You can't consider it as a precedent. What is the ratio that laid down by the court in there? That we will see, but there is nothing to be considered in this judgment of the Supreme Court. That's not on merits. Some order is passed. Yes. Which order?
Even in Sugandhi case, even the Karnataka High Court order that my learned friend is like, Para 5 was also gives it, that court is allowed.
Yes. Anything?
My lord, one more aspect, my lord. During the cross examination, my lord, the trial court yes restrained me from asking certain questions.
Because that you can't argue before the court. Now, what is the issue is with regard to that application filed by them and being allowed, nothing else.
My lord, even my lord, my cross examination is challenged. My
The
lord.
written statement, we have taken a condition that the witness is saying. And when we have confronted the document at the time of cross examination, they deny. Then thereafter we.
Heard reserved. Next point.
My lord, till the pronouncement of judgment, my lord, let the trial court will shall not proceed with the trial.
List this matter on Tuesday for pronouncement of judgment.
Yes, my lord.
Yes.
Cell number 14. Cell number 14.
For the petitioner, my lord.
H. Manjunath.
Defendant's repetition, my lord. The suit before the trial court filed by the plaintiff for the relief of declaration against the document and for the relief of permanent injunction, my lord. The impugned order on the application for amendment of application allowed by the trial court made by the plaintiff. And in this regard, my lord, the amendment application, the plaintiff has sought for the relief of declaration and possession in addition to the permanent injunction.
Affidavit filed.
Affidavit annexure E, my lord.
Page number.
Page number. Page number 74, para number 15, my lord. May I read, my lord? I affirm at the time of filing of the suit, I had also filed interlocutory application against the defendants, restraining them from interfering, alienating, and not to change the nature of the suitable property. In fact, after the objections filed by the defendants on all the above said applications and the arguments heard on the both sides, and after the Honorable Court posted the case for orders in the said application, that is during dependency of the suit, the defendants have colluded each other and illegally entered into peaceful possession, occupation, and enjoyment of the suitable property, and have illegally constructed the house on the suitable property without having valid right, title, and interest on the same, with rowdy elements based on the forged documents. Since the defendants are very influential persons with money and muscle power, the plaintiff, without the aid of this honorable court, cannot protect the suitable property. The copies of photographs and complaint given to the positive police commissioner, Bangalore, of the present illegal structure constructed on the suitable property by the defendants are produced herewith and marked as Annexure A series. In this regard, my lord, according to the plaintiff, during the pendency of the suit, possession was being taken illegally. And in this regard, my lord, may I kindly come to the plaint at page number 24, my lord. My lord, this suit is filed in the month of January 2023, and in the year 2023 itself, defendants have filed the written statement with a counterclaim saying that they are in physical possession of the property, and a permanent injunction counterclaim has been sought. My lord, may kindly peruse the page number 46 next to the writ petition, my lord. 46 and also 65, my lord. Defendant number 1 as well as defendant number 3 and 4. The moment they have filed the written statement, they have also claimed the permanent injunction based upon their possession. And for this counterclaim is really concerned, my lord, the plaintiff did not file any rejoinder or reply to this counterclaim relief sought by the defendants number 1 and defendant number 3 and 4, my lord. And
1 minute. What is the initial suit for?
suit for declaration against the document regarding the gift deed and sale deed is declared as null and void
Let's see
document.
that plain.
But page number 24, my lord. 24. Prayer. Cancel the registered gift deed dated so and so. Prayer B, cancel the sale deed dated so and so. And C is the declare the compromise decree in so and so degree on the file of the court is not binding. And prayer number 4 is the restrain the defendants from interfering with the plaintiff peaceful possession, occupation, and enjoyment of the suitable property in any manner. And my respectful
The
submission.
plaintiff in the peaceful possession and occupation of the suit scheduled property and declare that the plaintiff is the absolute owner of
Yes,
the
ma'am.
property.
In this
Now
regard,
what-
my
Now the prayer, what he is seeking?
prayer, the prayer number,
And declare the plaintiff is the absolute owner
yes,
of
my
the
lord, prayer
property.
E and F. Now presently he is seeking the prayer E, put the plaintiff in a peace.
How it is going to change the nature of the
My
suit?
lord, here, initially the plaintiff has come up with the pleading that he is in physical possession of the property. And in the year 2023 itself, the defendants have appeared and filed the written statement saying that,
Even here also, what he said, please look at it. Put the plaintiff in peaceful possession and occupation of the house scheduled property.
yes, my lord, in this regard, my lord, as on the date of plaint, he claims that he is in physical possession of the property. And in the year 2023, we filed the written statement saying that we are in physical possession of the property and permanent injunctions to be granted against the plaintiff. That is
Filed
the
a counterclaim.
counterclaim. For that, he did not file any reply.
Chair,
2023, my lord, page number 46,
Mm.
28 to 2023 itself, we have filed the written statement saying that we are in physical possession of the property.
And
in
you say
this,
that you are the owner of the property.
yes, my lord.
Huh?
We are the owner of the property and we have sought the declaration relief also against the plaintiff related to the very same suitable property. And my respectful submission before this honorable court that keeping the prayer of restraining the defendant from interfering with the peaceful possession and enjoyment of the suitable property, he cannot make out a case for possession relief. The plaintiff cannot make out a inconsistent pleadings in the plaint. That is only.
Third, I'm not able to understand. This prayer E is already here. E is as it is.
My lord, this is the amended plaint.
No, I'm looking at page 24.
Yes, my
That is the amended plaint.
amended plaint.
Where is the original plaint?
Original plaint, I have not. This is already filed. That is the reason I have come up with the amended plaint, my lord.
No. We
Now
have
the
to
present
understand-
stage of the case,
We have to understand what is the original. Now this E and F are now substituted.
on 9/4/2026.
There are two E, D, E, F.
26 page. In,
Yes, I'm looking at 24.
yes, ma'am. My lord, may I kindly come to the page number 101, where the order sheet amended plaint is filed on 9/4/2026. This is the amended plaint I am reading. My lord. 101 order sheet.
So original prayers are till
Prayer D.
prayer D.
Yes, my lord. My lord, amended application also, I will take your lordship kind attention to say that this is the amended prayers. Page number 69 may kindly be pressed, my lord. Amendment application.
Please come.
69, my lord.
Then counsel to the petitioner submits that the original suit is filed, seeking to cancel the registered gift deed along with the other prayers. And it is a case of the plaintiff that he is in possession of the property. Defendant has filed a written statement, also a counterclaim that he is the owner of the property and also sought for an injunction against the plaintiff. That is in the year 2022. 2022, petitioner has kept quiet. And now he has come up with this application seeking amendment of the plaint, and the court, without considering any of the grounds that are raised by the petitioner, has allowed the application. Considering the submission, they shall stay of all further proceedings pursuant to the order dated so and so. Same notice to the respondents. In addition, hand summons memo shall be filed by 2nd of July, or else a stay granted by this court stands vacated. Yes, 15.
Number 15, S.T. Muniswamy Gowda.
Appear for the original defendants. My lord, this order, the suit was filed by the plaintiffs for two reliefs, namely production of statement of accounts and an interim order by way of mandatory injunction payment of 25% of the suit decretal amount by way of an interim order. These are the two IAs. Those are reproduction of the same prayers. The original prayer sought was, this is a money suit. Annexure A at page 21, my lord. Mandatory injunction has been granted for 25%.
1 minute. Let me look at the prayers. Where are the prayers? Where is the plaint?
The plaint at page number 39. $38, ma'am. Apologies.
This is the prayer.
This is the main prayer.
Then where is the IA?
The very next annexion, my lord, at page number. Look, IA number 1, copy of IA number 1 is at page number 52. IA number 1 is for mandatory injunction.
To release, pay an amount of rupees 5 lakhs as an
50 lakh.
interim maintenance to the plaintiffs pending disposal of the suit.
IA number 2 is at page 61.
I'm not able to understand what is this suit itself.
The suit is for money. The background of the suit is, if I may explain the
But it doesn't say
relationship
about
between the
any recovery
parties.
of money.
They're
It
claiming
only
this out of a will.
There is a defendant, direct the defendants to pay 2 lakhs towards maintenance expenses.
Maintenance. They are claiming this out of a will. If I may explain the relationship between the parties, the original defendants are siblings, and the plaintiffs are the children of the brother of the siblings who has since passed away. There was a will made by the parents of the defendants, who was the grandmother of the original plaintiff herein, saying that they will.
There can be a prayer of this nature.
There cannot be a prayer of this nature, my lord.
Direct the defendants to pay sum of rupees so and so to the plaintiff.
There is no reason given.
What is that? It's not about the bank statement. What is the suit? In what is the nature of the suit? I'm not able to understand. Why should they pay? Why should they pay 2 lakhs? No, there should be some relief. There should be a declaration. There should be some. There is a way to file the suit. It is not a writ petition. That you will seek some direction.
Maintain someone claiming maintenance. As per the will, depend as to take care of the minor children. But from there, 2005 till today, they are trying to take care of the grandchildren as per the terms, conditions of the will. Para 5 minor. As per para 5, it clearly is will.
No, please come to the IA, understood.
Page number 20.
Where is the IA order?
Page number 21 onwards.
Court grants it.
The court has granted. If I may make this mention, my lord, this IA was under challenge before the coordinate bench of this court earlier. This is the second time it has come up. During the first time, I was ordered to pay 25% of the suit decretal amount within 30 days. Now, this time I've been asked to pay the entire amount within 15 days, and no reasons have been adduced. The learned trial judge also acknowledges the fact that the will itself is in dispute, but still states, but due to certain hardships that they face, which has not been proved, which has to be put through trial and evidence, because they may face certain hardship, 25% of the suit decree has to be mandated by way of a mandatory injunction in the interim within 14 days. This is the order the learned trial judge passes.
That's it.
Reasons are on page 23 onwards.
where from the court has got this? The present suit is filed with the plaintiffs claiming right over the suit scheduled property on the basis of a will alleged to have been executed by their grandfather. Where from the court is getting this?
Hello?
The court says the present suit is filed with the plaintiffs claiming right over the suit scheduled property on the basis of the will alleged to have been executed by their
But
grandmother.
that is the question of cause of action, because according to the will, we are the custodians of the properties. They have access to all of these properties and more once they attain the age of 30. They're 27 right now. They do not have any cause of action to claim any maintenance or amounts. And the word used in the will is welfare. They are claiming close to 2 crores and 4 crores by way of business expenses and even marriage expenses as in the name of welfare and maintenance. There is no provision under the CPC to grant such a relief. And no reasons in law have been adduced.
Where is the earlier order of the court?
Page number 71. In the earlier round, they sought the same relief without producing any statement of accounts.
What is the age of these respondents?
24 and 27 respectively.
27 and 38.
First plaintiff is aged about 29 years. Second plaintiff is 27 years.
No, that's a wrong submission. They're 24 and 27 respectively.
What is this amount? 50 lakhs.
50 lakh.
The defendant shall pay the amount of rupees 50 lakhs as per the will dated for plaintiff's maintenance and their welfare within 15 days. What is this order? No, it is for you to prove it. You have to prove so many things. How can there be an order of payment and amount of rupees 50 lakhs? And what is the basis? And where is the discussion by the court? Which court is this?
Fifty-eighth edition.
Page number 58. Return statement.
Keep this Ross copy of this. Yes.
Page number 58. Return statement filed by the plaintiff. Para number 5. Admitted execution of the will is admitted. They have received a rent from the respect of the property from 25 to 35 admitted. But they have admitted not paid till there they have not paid single payment. Bank, they have produced bank statement as per bank statement from 2005 to till today they have received 2 crores 3 lakhs. The property is as per the will, property belongs to the plaintiffs. From day one, they have tried to take care of the minor children. The mother of the plaintiff is taking care of the children by raising personals. They have need money.
What did you say in your written statement?
My written
Page number 2.
My written statement, I have stated that the execution of will, even though in question, all of these payments were made. I am the custodian as under the will and I'm operating under the will since the past 20 years. And I've admitted that.
What is the material to show that you have paid something to them? Or you have been taking care of them?
We had paid all their expenses and school fee, and if I may just make this submission, they've stated that they've taken hand loans and other loans here and there, and they've not produced a single individual in their witness list nor a single document to show that their expenses have been covered. If I may take your lordship to page number 34 of their very own plaint.
About the fact that the will is executed as per the will, they have certain rights for that and the will need not be proved.
Please.
You are accepting it.
Sorry, my lord.
You are accepting the will.
I'm accepting the will to the extent, and even under clause 5 of the will, it states they'll attain all these rights under the will once they turn 20, once they turn 30.
Till
The
30,
second-
what should be done?
He's not 30.
What should be done till 30?
Well,
What is your responsibility till 30?
my responsibility is to take care of the properties, to make sure they're not alienated, and to collect the rents accordingly, and to maintain the property to the.
What about their maintenance?
I'll just produce the will, my lord. If your lordship may have the language of the will.
Take that.
At page number 6. Clause 5.
What is the name of these respondents?
MP Shreyas and MP Chaitanya.
Chaitanya. So the property at Jayanagar was bequeathed in their favor, subject to various covenants relating to the deed.
The daughters are the petitioners before your lordship.
No, even serial number 2 is also bequeathed in favor of these people.
Yes.
In the building shop number so and so. Again 3, then 4. To my daughter. So 1, 2, 3 properties in the will are bequeathed in favor of these grandchildren. They will have an absolute right once they attain 30 years of age.
The very suit is itself is in question because they do not have a cause of action to claim anything.
Let's see what it says. Only Chaitanya attains 30, both the grandchildren can take that. That's absolute owners thereof. Read it. This is the only copy.
I have a copy.
Read it at 5. Till Chaitanya attains 30 years. At
The
point number
bequeathed
5.
schedule A to C property shall be managed jointly by my daughters Shashikala and Suma. They shall be entitled to lease A to C properties, collect the rents, and generally maintain the property in the best interest. Maintain the properties in the best interest of the minor children. From out of the rentals received, the property tax shall be paid. The property shall be maintained, and surplus shall be used for the welfare of my grandchildren, which are the respondents herein. And any surplus left after meeting day-to-day expenditure shall be kept in an appropriate security deposit by my daughters in their discretion decide. I have maintained those accounts. I have maintained those properties.
You have to take care of the welfare of the minor children. So show something to the court that how you have taken care, how you have spent, and what is the amount you are receiving, and how did you spend it.
Lord, with respect to their welfare, they're living in a property out of which which was bequeathed in the will. They're allowed to stay there.
That property now you are like a trustee to that.
They are residing in a house owned by me. They're residing in a house owned by me, and all their day-to-day expenses are being taken care of as of today, as I submit before your lordship.
That money you cannot, that doesn't belong to you.
No, they're living in my house, not unconnected to this will, unconnected to any properties in the will. They're residing in my house, and they refuse to leave that house. Even till this day, their expenses are taken care of. They have not paid a single bill pertaining to the house so far. All of these living expenses and others
how long they are residing in your house?
Since the date of the will, since the passing of the executor of the will.
What is the date?
2009. 2005. 25, 2005.
$2,005 is the will.
No, my lord. 2005 is the date of death of the executor of the will. Since then, they've been residing in my house.
How old were they at that time?
20 years ago, my lord, approximately. They were about 7 and 4 respectively. And their mother also resides in the house.
What are they doing now? No education, not studied. Now, why are you opposing this?
Your Lordship, there's no remedy in law to claim a percentage of suit decretal amount, that too by way of an interim order, by way of mandatory injunction.
Forget about that. Forget about what has been done by the court. Now, by virtue of this way, you're managing the affairs of all these properties, and the amount is credited to an account, and you have nothing to do with it except paying the property tax and taking care of their welfare.
Please.
What is your difficulty if that amount is given to them? Forget about the technicalities of the suit.
One difficulty, as per based on my instruction, is that since they're residing in my house, if they're willing to vacate to this very day, we'll hand over those properties. They refuse to do so. The house which they're living in right now, as of today, they refuse to vacate. And they say they'll contest and continue to stay there, as well as to contest this suit. If they're willing to vacate it, based on instruction,
If they're willing to vacate, everything you will hand over.
The will, as per the will. We'll hand over in due course.
Where are you residing now?
And reason is,
Huh?
the plaintiffs defense sold the property of the father of the plaintiffs in the year of 29/12/2005, stating that they are defense are the owners of the property and sold the property to the third person. In this regard, the mother of the plaintiff filed a suit complaint against this defendant. The said complaint is still pending. Due to filing of the said complaint, they are not. The property also sold.
No, I'm asking where the defendants are residing now. Is that property belongs to you or belongs to them?
Property belongs to the plaintiffs.
How?
Ground for property allotted to plaintiffs.
Allotted.
Allotted by whom?
Allotted by me. I own the property. They're not staying in the will property. It is my property.
Who has allotted it to you?
As per the will.
Show that. As per the will, where is it? If you're residing in this property,
Property of the plaintiffs.
show it. Where is that? Where is that bequest in your favor? What do you say about the settlement? What they say is.
They are demanding to withdraw the complaint filed by the mother of the plaintiff.
So you want a settlement or not? You don't want settlement.
My lord, this was offered during the time of institution of the suit 3 years ago.
Why you don't want settlement?
As
You don't
per
know.
the will, you have agreed to.
Whatever you are asking, that you are going to get it, then why don't you want? Why are you not willing for that?
As the plaintiffs are issuing their own property, it is not property of belongs to the plaintiff.
Is it stated? So which property is it stated in this?
Residential property.
Let's see. Let's see the cost title. Where are you residing?
The page number
62F, first floor, 6th main, 5th block, Jayanagar. That is what it is. That is what it is.
Is one?
This is what is number 1 at point number 1. That is the property which is
Residing in, they've chosen that address to file that suit. I cannot change the address of the cost title that they've chosen. They're choosing to stay from that property and they're filing the suit from that address. I cannot change their cost title, my lord, by any means.
According to you, where are they residing?
They're residing in my house.
Your house has a number.
In a different area, my lord.
That's what your house has a number. Your house has something else. What is that? You are also residing in Jayanagar.
Please.
Yes.
The agreement that they produce is not the same one. They're saying they are the owners of the property. They're not. They're saying plaintiffs reside in. They're saying plaintiffs are the owners of the property. They're not. They can't simultaneously claim they're living under the will.
What is the amount that is there in that account?
In the account, it's approximately. Just a moment.
2 crores is there.
2
crores.
2.3 crores approximately.
1 lakh 1 crore 40 lakhs deposited recently deposit, and this is 63 lakhs is in the account.
Other is in the fixed deposit. 63 lakhs is in the account.
They don't dispute any tampering with the amounts. The amounts have been kept safely. All these amounts accrue periodically through rental property.
No, if they require the amount for their purpose, what's the difficulty for you?
Well, it cannot be granted in law. This relief itself is not sustainable. They have to lead evidence.
That is a different aspect. You cannot have any claim on that. It's not your money.
I'm not claiming on their property, but also they do not have any claim on this property right now. I am the custodian under the will under which they claim. I am the custodian of the will as of today under the very.
He's already 30 years old.
He's not 30 years old.
That's what he's saying.
He's not 30 years old. He's 27. He's not 30.
27 and 29 years.
No, 24 and 27.
In the year of 2000.
No, he's only aggrieved as far as you are not taking care of the maintenance of their maintenance.
If your lordship may
If you
turn
can
to page,
show-
if your lordship may please
No,
have
no.
page 34.
No, so and so amount you are getting from that properties. What you have spent towards their welfare, you can show it.
That is for them to prove during evidence and even rebut it during cross-examination, not to ask it by way of an interim order. If your lordship may turn to page number 34, my lord. Their own plaint, page number 34.
Bank statement they are producing.
What is that he's paying? What is that he's contributing towards your maintenance?
From day one till today, they have not paid any single payment. The mother of the client, they are taking care.
From 2005 till now, that is the only amount they are getting from that property. Only the 2 crores 60 lakhs.
Actually, they are receiving 5 lakhs per month, my lord, two properties, but as per the documents shown, they have only 2 crores. They are receiving 2.5 lakhs presently per month, as per statement.
Please come.
My lord, page number 34, if your lordship may have, why they need that welfare is given in their very own plaint. Those are not expenses for welfare.
Property situated for Jayanagara 4th flat. One property is let out to the water, Paradarshini. Another property is let out to the Nagarjuna Shivani. They are receiving per month 2 lakhs 50,000, more than 2 lakhs. As per the will, as per the document, executed registered document, they are receiving 2 lakhs.
Page number 34, my lord, paragraph 14.
Yes.
If I may read the expenses as laid out by the plaintiffs. The plaintiffs submit that the first plaintiff has come. They said he's uneducated. They've admitted he has a BE degree, and he's interested to start his own business by investing more than rupees 50 lakh. And the second plaintiff has also completed his BCom degree, and he is intended and interested to starting his own business with a tune of 50 lakh. It is further stated that the first plaintiff is intending to get married, which he needs more than 50 lakh towards marriage expenses. Both the plaintiffs intending to purchase new cars for 25 lakh each and motorcycles for 1.5 lakh each. These are not maintenance expenses by any stretch of imagination. And more importantly, I've produced a judgment. If your lordship may have a look at the compilation along with the will.
That's a record.
Your lordship's there.
Whether it is
Well,
maintainable
a mandatory injunction can only be granted to restore status quo ante. It cannot be used to create a new state of affairs. And it is not their case that we have paid 50 lakhs to them before. There is nothing that is being restored, or there is nothing that is being restored in that.
There is no harm to you in this. And you are not, they are not selling the
Well, they have no cause of action to seek it at this point in time. They have no cause of action.
What is your grievance or the problem?
My grievance is in law, this relief cannot be granted.
And you will use their money and you will enjoy that.
I'm not enjoying anything. All of that, they admit all of it has been locked up in fixed deposits and even interest in those properties. It's kept in bank account. I produce it. They do not dispute it in any manner. If that money is kept in, it's all theirs after 3 years. But if they seek that money right now by way of an interim order decreeing 25% of the total amount, that cannot be done by way of mandatory injunction is my humble submission before your lordship. Because it can only
somehow the court do not find any bona fides in the conduct of the defendant.
Sorry,
that's the reason why the court wants to pass an order. There is something appears to be not correct. There is something fishy in this. Because otherwise you wouldn't, where is the reason for you to be aggrieved by any of it?
Well, because they do not have any cause of action to claim this amount.
It's
because the
their
bill
money.
clearly states
Their money.
They do not dispute the will. This is a matter for evidence.
They cannot deal with the properties till the age of 30, and you are asked to maintain it and also maintain them
And they're not asking for maintenance for daily sustenance or welfare for any small
That
measure.
means that you will
They're
give
asking
them
for
a-
exorbitant
No,
expenses.
you will give them money to, for 3 times a meal. That's not
That is
maintenance.
not my submission, my lord, because what they are asking for are exorbitant expenses,
You
and they're
can-
not minors
you
by any
can-
manner.
you
They're
can
24 and
question this order.
27
Please come.
respectively.
The present writ petition is filed. Agreed with orders passed in I number 1 in OS number 7137 of 2023 dated 30th April 2026, whereby the court has directed the defendants to pay an amount of rupees 50 lakhs as per the will dated 22/3/2004 for plaintiff's maintenance and their welfare within 15 days from the date of this order. Agreed thereby the defendant is before this court. Learned counsel for the defendant submits that this order is unknown to law and the court cannot pass an order directing the defendants to pay the amount within 15 days. Earlier, when an order of this nature has been passed, the petitioner has carried this to this court by filing a writ petition, and this court by order dated, what is the order? Has set aside the
26th
order
February.
dated 26 February 2025 has set aside
26
the
months.
26 has set aside the order and remanded the matter to the court for fresh consideration. After remanding the matter, the court has passed this order. It is submitted that there is no cause of action for the plaintiff to file the suit as per the plaintiff. After the age of once they attain the age of 30, then they are entitled for the possession of the properties. Until such time, the defendant shall manage the properties. It is submitted that as per the will, he has been managing the properties, and whatever the income that is derived, he has deposited it he has been depositing it in the fixed deposit, and some amount is kept in the bank account for paying the taxes and and also taking care of the expenses of the defendant. It is also submitted that the expenses what are stated by the petitioner, by the plaintiff, cannot be considered as the expenses for maintenance, and for all the luxuries they cannot seek that kind of amounts. Even if they require any amount, the court by way of an interlocutory order cannot direct the defendant to pay the amount without even determining the dispute that is involved and whether the suit is maintainable or not. Anything else?
Hello? I've cited a judgment, my lord,
Where is that?
in the compilation I've given along with the will, at page number 22.
It's not. He has relied on. It's not here.
I've given along with the will, my lord. Durabji Kawasi Kutu.
It's not here. You have a copy? Copy of the judgments which
My lord,
he
I
has
gave it
relied on.
along with the will just before I passed it.
Oh. He has relied on the judgment of the Apex Court in Dorab Kawasji Vardhan versus Bhumi Saurabh Vardhan, reported in 1992 SCC 117. He relied
Paragraph
on
16,
paragraph
17,
number,
18.
Paragraph?
16, 17 and 18.
He has relied on paragraph number 16, 17 and 18 extracted. Relying on this, it is submitted that the court went wrong in passing such an order. Next, parallel counsel appearing for the defendant plaintiff submits that when
I may interrupt, Your Lordship may record that the appropriate remedy for them to seek is attachment before judgment in
appropriate
case.
remedy is to seek attachment. Land counsel appearing for the plaintiff submits that their grandmother has executed a will bequeathing the properties in their favor, and in the year 2005, at the time the will was executed, they were aged about 7 and
4.
They were aged about 7 and 4 years. It is submitted that as per the will, the entire amount that is right, the defendant has to take care of the properties and shall safeguard the properties properties, the amount derived from the said properties can be utilized for paying the tax and also for the maintenance of the respondents. It is a case of the plaintiff, maintenance of the plaintiff. It is a case of the plaintiff that the defendant is not taking care of the welfare of the plaintiffs. Now they are aged about 29 and 27 and 29. Then they are 7 and 5 years old. 7 and 5 years. Now they are 27 and 29 years old. It is submitted that the defendant is not taking care of the welfare, taking care of the maintenance of the plaintiffs. It is submitted that there is no dispute with regard to the will, and when they are admitting the contents of the will, and an amount of rupees 1 crore 60 lakhs, 2 crores, 16.
Total 2 crores 3 lakhs received rent, out of which 1 lakh, 1 crore.
What is there in the fixed deposit now?
1 lakh, 1 crore 40 lakhs.
1 crore 40 lakhs is in the fixed deposit, and an amount of 63 lakhs, is lying in the account. Considering all this and the purpose for which the will is executed by the grandmother, the court has rightly granted an order, and there are no grounds to interfere with the same. Having heard the counsels on either side, there is the material on record. Initially when this court there is the order passed by the court, the court could not understand on how at an interlocutory stage the court has directed to pay an amount of rupees 50 lakhs to the respondents. Then getting into the facts and circumstances of the case, where the will is executed by the grandmother and the aunt is managing the affairs of taking care of the properties, and the grandchildren are before the court saying that as per the will, their maintenance is not being taken care of by the defendant. In this case, the defendant has nothing to do with the amount that is lying in the bank, which is derived from the said properties, and ultimately that belongs to the plaintiffs. It is a contention that the plaintiffs cannot file a suit because they are not 30 years old. No, they are not seeking any. They are not seeking possession of those properties, but they are seeking for their maintenance in the light of the will executed by the grandmother. Any of the order that is passed by the court, the petitioner, the defendant no order passed by the court will cause any prejudice to the defendant. Ultimately, it's a money belonging to the plaintiff, and there is no dispute about this. There is nothing to be proved whether that belongs to the plaintiff or to the defendant. That the defendant himself is accepting that the money belongs to the plaintiff. However, the case is that they are not 30 years old. There is no cause of action, and there cannot be an order of this nature, and he relies on the judgment of the apex court. In the considered opinion of the court, when the court is looking at the facts and circumstances, in the light of the undisputed facts, when the court has considered and granted an amount, even in case as that money belongs to the plaintiffs and for their maintenance, this interim order is passed. Hence, this court is not inclined to go into the technicalities, as it would not cause any hardship to the defendant.
So at least the quantum of maintenance that they've asked, at least the quantum of maintenance they've asked may be reduced, because they're not minor children by any nature. They are unemployed by choice.
Then instead of 50 lakhs, it is reduced to 30 lakhs. Yes.
Cell number 16.
To the petitioners, my lords.
Yes.
There are two matters, my lords,
Hmm.
arising out of two applications in the same original suit.
Yes.
Suit is one for declaration, my lords.
Hmm.
Relationship between the parties are the siblings, and respondent number one is the father. That instituted earlier a suit which came to be decreed by 1/4 share. Total survey number of 41 was the subject matter of the said suit.
You tell me what is the IA, then I'll understand.
Please, my lords, agreed with an order dated 2/5/2026. My lords may kindly come to the order.
There are two writ petitions. What
There
are
are
those
two writ
IAs?
petitions. The first petition, my lords,
What are the two IAs?
two IAs. One is to restraining the respondents, one application. The other application is to alienation,
Not injunction, restraining them, and the other is not to alienate.
not to alienate.
Hmm.
Please, my lord. The
What
first,
happened to that?
my lords,
What happened to the IA?
the court, they have filed, before the trial court, they had filed it, trial court decreed in my favor. They rejected the application
injunction.
of the plaintiff, stating that the share which has been allotted to the plaintiff is 22.75 according to the original judgment which has attained finality, which went to the Supreme Court and came back. Now he has filed a suit claiming 35 kuntas, which is not the subject matter of the suit, and he is not been entitled. To that effect, he has filed a declaration, and he relies upon an MOU. Trial court comes.
What did the trial court do?
Trial court dismissed the 39 rule 1-2. Agreed by that, he preferred an MEA.
Two IAs were dismissed.
Two IAs were also dismissed.
Appellate court has allowed it.
Appellant court has not allowed it, my lords. There is an ex parte interim order granted under MEA that is only filed for 39 rule 1 and 2. Interim application is filed under that, seeking a same relief of a final order. Final order of the MEA is not to restrain. He seeks an ad interim order, which inter alia it is one and the same, allowing the final order also. Same order is passed. If my lords kindly come to Annexure A, and the first appellant courts grant an order which has been not sought in the application at all. Annexure A, my lords, page starts at 29. The IA, my lords may kindly find the IA at page number 242. The application is at.
No, there is an order.
Please, order that, my lords, Annexure 29.
Let's see that first.
Please, my lords. 31, the starts. I may be permitted to read the entire or the reason.
Come to this page number 34, last paragraph.
Please, my lords. Prior to coming to that, my lords may kindly come to page number 30 for a moment.
No, let me.
I may, my lords.
I'm
I
reading
may.
it. Please complete it.
I'll come. On this day, Sri HLN advocate, one of the
End
children,
of it, the learned counsel so and so, fair enough to admit.
admit the fact about the MOU and also the proceedings of the RSA, but he is unable to answer in respect of the fact as to what promoted the children of Ambegowda to take/mention the share of beyond 35 kuntas in the granted land, and what promoted them to violate the terms and condition of the MOU referred to in the proceedings. No proper answer is forthcoming by the learned counsel. Therefore, this court is following orders is passed. The children, that is the defendant respondents of the OS, are hereby restrained from alienating the scheduled property, that the subject matter in OS so and so, and are further restrained from interfering with the possession of the Ambegowda in respect of the share of 35 kuntas referred to the MOU.
This interim order shall be enforced till the next date of
Why
hearing.
the court cannot grant an interim order?
The final relief is also one and the same, my lords. It might be.
When the
Prior
notice
to
is
that,
not-
my lords may
when the
kindly come
notice is
to.
not served on the respondent, if the court feels that there is a.
The relief is not been sought by them. One application is with respect to interference. The court passes a common order in both the IA giving an alienation. The prayer is not sought by the applicant at all.
There are two IAs, as you're saying.
There is only one IA in one MA, my lords. Same orders on the passed on both the application mechanically. If my lords kindly come to the IA of the said.
Question in the MA, alienation or injunction?
There are two MAs. The first is questioning against the interference. The second MA is against the alienation.
There are two MAs.
There are two MAs.
So technically you are saying that they are both in one order.
Both in one order, my lords, which has been not sought is one.
No,
Secondly, my lords. Secondly.
Let's not go into those technicalities, how the.
No,
is
please.
bad.
My lords may kindly come to page number 204, the OS order, wherein the operative portion of the order I name page number 220, my lords. Paragraph number 37. That apart, it is to be noted that the judgment and decree passed in OS 552 of 2003 dated 17/2/2012, though the challenged in RSA so and so, however, the said RSA was dismissed as withdrawn. Therefore, it is clear that the judgment and decree.
What is this?
Page number 220, my lords. Operative portion of the order passed by the trial court.
Yes,
Please. 37, my lords, paragraph.
yes.
That apart, it is to be noted that the judgment and decree passed in OS 552 of 2003 dated 17/2/2012, though challenged in RSA number 291 of 2022, however, the said RSA was dismissed as withdrawn. Therefore, it is clear that the judgment and decree passed in 552 of 2003 dated 17/2/2012 has attained finality. It is necessary to mention that in the judgment and decree passed in OS 552 of 2003, it has been declared that the defendant number 1 to 3 herein along with the plaintiff number 1 herein are entitled to a 1/4 share each land bearing survey number 41 of Hadguru village, measuring 2 acres 11 kuntas. It implies that out of 2 acre 11 kuntas of the land in survey number 41 of the Hadguru village, the plaintiff number 1 and the defendant number 1 to 3 are entitled to an extent of 22.7 kuntas each. When this being the case, to which the plaintiff is entitled, the claim of the plaintiff that he is acquired the right title and.
For that, 22.75 guntas.
My lords?
To that relief is entitled,
He's really entitled to 22.7 kuntas. I may read further.
I've read it. I've read the order.
Please, my lords. Accordingly, they have rejected it. Now he wants to claim something under an MOU, which is signed by the parties. But pursuant to that, there is an alienation. If my lords kindly come to the gift deed, what has been.
No, where from you're getting that 32 guntas?
30, he should answer that, my lords.
Where's that MOU?
MOUs.
Court also refers to this MOU being filed before the court in the RSA.
Please. Under that is itself, my lords. Annexure B for that, for a moment.
Page number.
Page number 50, page number 24, my lord. Order, operative portion of the order is at
this 35
39.
Of land. If you see, the court says
he should tell answer under what did he acquire 35 kuntas, my lords?
By taking share beyond 35 guntas by violating the terms and conditions of the MOU referred to in the proceedings undisputed RSA.
That document intentionally they have not produced today.
RSA is dismissed.
No, that's RSA has been withdrawn. Parties have settled.
Where is that settlement?
That settlement, that is the MOU. According to MOU, that's the parliament said
It should have been placed on.
Oh, my lords, the aspect is he claims that he is entitled for 35 kuntas out of 2 acre 11 kuntas.
Let us look at the RSA order. Where is it?
RSA order, my lords. Please, my lords. That is available at my lords. Page number annexure D, page number 102. $112 is the operative portion. Agreed by this, they preferred a review. That is available at 113. Agreed by this, they went to Supreme Court, my lords. If my lords kindly come to page number 118, the Supreme Court order, they remind that the question of law is not being framed during the proceedings of RSA and the matter came to be remanded to this court.
No, in this RSA, where do you find the mention about this memorandum of understanding, this 32 guntas.
There is nothing, my lords. Memo of withdrawal is at page number 130, which has been filed by the plaintiff. 130 is the page number memo of withdrawal.
I'm not able to understand. 102 is the order.
Please, my lords.
This is the order passed in RSA.
Please.
What it says?
The matter was remanded back, the matter was remanded
Order
back to
is
the
set aside and the matter is remanded back
to the
court.
trial court.
Where
Agreed
is
by
this
that, we
withdrawal?
prefer to Supreme Court.
Yes.
Supreme Court said the question of law is not being framed by the High Court. Accordingly, the matter came to be remanded. The matter was reopened. During the interregnum, he files a memo for withdrawal. That has been withdrawn. If my lords kindly come to the memo for withdrawal, that is available at 130, he refers to an MOU. Based on that understanding, I have withdrawn the MOU. There is nothing which has been forthcoming under the memo for withdrawal which has been filed by him. So, the pendency OS 552 of 2003 has attained finality by virtue of the withdrawal.
The appellant has filed the above appeal challenge, so that's not interested to prosecute the appeal.
And the judgment and decree passed by the court below additional senior civil judge. Now at this stage, the appellant has not interested to prosecute the appeal. Therefore, this honorable court please to permit the appellant to withdraw the appeal.
Where do you get that the memorandum of understanding? In this order.
That's after the matter has been remanded to the Honorable High Court, that's the Supreme Court. Then that's memorandum of understanding entered into between the parties.
Is it recognized by the court?
Yes.
Where is it?
Subsequently, this Honorable Court has given direction to the plaintiff to file a suit in support in view of the memorandum of understanding, in view of the direction issued by this court. We have filed the suit before the court.
Where is that?
That document has not been produced before the court.
It can't be document. There should be an order. There should be an order recognizing your memorandum of understanding. Show that order.
Has not been produced.
Pass on.
This is the order. Both the MOU and these orders, both orders they have not produced before the court. It's in RSA 291/2020.
Which he is referring to an order dated 16/2/2024. Where is that?
Yes,
Where is that?
That is the order passed in the second appeal. Page 112.
Where is the mention in 16/2/2024 order?
This order attained finality to the Supreme Court.
I am asking a very simple question. Here, what the judge refers at 19 order dated 19/9/2025 is when the matter stood thus among the parties there was a settlement and the terms of the settlement was reduced into writing in the form of memorandum of understanding. In view of the said memorandum of understanding reached among the parties, a memo came to be filed by the appellant which was extracted in the order passed by the coordinate bench of this court on 16/2/2024. I am looking at the order passed on 16/2/2024, which is, there is nothing like that.
But in view of the MOU, the appeal has been, second appeal has been withdrawn. But we have not.
Civil proceedings cannot be in this manner.
Because there is a direction from this court.
Who said this? Who said this order?
Yes,
It says it's
subsequent to this RSA. Let's kindly this document.
My lords may kindly refer to
If
pursuant to
both
the
of you are
withdrawal.
not interested to
Pursuant to
understand
the
what is. It is no submissions are required. First, I have to you have to clarify what I am asking. No, this order which you are referring refers to an order dated 16/2/2024, which has extracted the memorandum of understanding is what is written in this order. And where is, I am looking at, come to page number 131. This is the order dated 16/2/2024. Where is the memorandum extracted? That I want to know.
But it's in 16/2/2024. Let's just read memo first. Appellant has filed the above challenging the so and so. Then let's say the IA number 1 so and so degree passed by the court of the second and so and so. In RSA, OS number 5 is so and so. Now at the state of it is not interested to prosecute the appeal. Therefore, so prior to that, let's 13/2/2024 is the MOU. After the MOU, let's we have filed the MOU, the appeal has been withdrawn.
I think we cannot, none of your submissions that are making cannot be judicially taken note of. Because it is, you say something has happened, we have withdrawn. If then that withdrawal, it should find place.
Why we have not mentioned this MOU is, let's see the RSA, that the brother of the plaintiff, he is the party to the suit. Then let's only the father and children, they have let's entered into.
For the best reason known to you, you have not mentioned, and we cannot, we can't consider that.
A finding. Let's
That finding is contrary to the order dated 16/2 that I will not consider.
they have a finding, let's see.
The suit is one for declaration, my lord. If at all that, if the title is attained finality, they would have not attained, they have not filed a suit for declaration only. The suit is only for declaration to declare them as a owner. When the possession and the declaration is only not attained finality, on what ground are they asking for a possession, my lord?
Execution of the MOU is not in this court because they have filed the written statement. Let's admit the MOU. Now their contention is.
That is not a part and parcel only, my lord. That was already considered before the court below.
We'll set aside this order, we'll remand the matter to the
Please.
appellate court, let the appellate court decide.
Please, my lord.
Let's still the MEA is pending. Let's against the interim order now the writ petition has been filed. Last occasion, let's they have addressed the arguments have been appealed. Now it is, let's post it for respondent arguments on 16. Only an interim application, let's they have filed this writ petition. Still the MEA is pending.
And what is this finding of the court?
Let's till
Without
next
any
date-
basis.
Till next date of hearing. let's
Anyhow,
review.
let this be, but I will, because 32 guntas you're claiming, basing on what you're claiming, no material.
35 guntas, let's be allotted to the plaintiff and 35 guntas allotted to the petitioner.
You're talking about a memorandum of understanding which doesn't find part of any of the orders.
Let's been referred to all MOUs. Let's that document painting, let's, they have not produced this MOU.
This is, this MOU is referred, that it is extracted in the order dated 16/2, and on what basis this order is passed, I don't know.
But that is not in dispute. MOU is not in dispute because of the reason that both the parties have agreed that MOU is executed.
They are disputing, who says that it is
Now,
not
let's
in dispute?
kindly see, let's see the order. Let's para 2. Let's second para. Let's see, before that, let's the grievance of the appellant is that after the appeal came to be withdrawn as per the memorandum of understanding, 35 guntas of land to be given to the appellant has not been given by the respondents and they have encroached on the portion of the 35 guntas of land that was not to be given to the share of the appellant. Wherefore the appellant.
Are you represented in this case?
My lords, I am not represented. It is some other council, my lords.
When I'm
I
saying.
mean, my
argument,
party
not the council.
was there, my lord.
What is this then?
My lords, my lords may kindly come. That is what, my lords, I am making my submission. He claims that there was a part of MOU. I am disputing that the MOU has not been entered by me at all. Even under the only thing, the trial court would.
Read this order. You
Please.
can't dispute it.
No, my lord, it's not in that way. What is entitled according to the law?
Yes.
No, my lord,
Yes.
according to the law, he is entitled for 22.75 kuntas. Under what ambit is he claiming 35, my lord?
Parties are not permitted to take the course of the, just for, you can't take it for a right and take it for a.
Lord, my only
You are represented by an advocate. Advocate accepts the memorandum. Where from all this has come, I don't know. But there is an acceptance by your advocate.
16/2, there was no such memorandum of understanding which has been put forth, my lord. The judgment of the RSA is also produced at page number 131.
No, what do you say? The submission of the councils appearing on behalf of you, they made a wrong submission before the court by accepting it?
My lords, in that way,
What did you do to clarify this?
my only submission is this, my lords, that according to 35 kuntas, what is claiming cannot be claimed because 552, the court has already declared it has attained finality. The Supreme Court has also drawn a finding to that conclusion.
Make some reasonable submissions.
My lords,
When I'm asking you a question, you just leave it there, both of you. Both of you go on something else and you submit whatever is, in favor of you.
in respect of this, I need to seek instructions with my client itself, my lords.
This matter as parted.
My lords, my only submission, my lords, in this, the matter might be remanded back because the interim application and the final goes together itself, my lords.
Anyhow, do it, but at the
Please.
same time, you are making these kind of submissions, being a party to those proceedings and accepting the MOU.
No, my lords,
Before
this is
the-
my instruction.
Before the learned judge and making these submissions, saying that there is no MOU, that conduct can't be appreciated.
No, my lords.
Please
anyways,
come.
Please.
When counsel for the petitioner submits that, the petition is claiming 35 guntas basing on an MOU. There is no MOU executed by the plaintiff. And the petitioner is entitled to only 1/4 share as per the judgment and decree. Learned counsel has placed before the court the judgment of the order that is passed in the review petition. It's in the review petition.
Second appeal review.
Review in the review petition, wherein the court has recorded that there was an MOU between the parties and the petitioner's counsel, the petitioner before this court and the respondent were represented by counsels, and where the petitioner counsel has accepted, has also submitted with regard to the MOU. Court has observed that if there is any the violation of the said MOU, a suit can be filed by the by the party who is agreed by it. It is a contention of the respondent counsel, but by virtue of that, it is filed. The petitioner shall get specific instructions, whether they were represented before the court and whether such a submission is made. That can for that no.
I cannot dispute what I am. I'm bound by the order, my lords. I cannot dispute that.
That order holds good.
Please,
that order holds good.
My lord, I am bound by that. I cannot dispute at this point of time.
That's why that order holds good of the appellate court.
Lords, ultimately, now he cannot travel beyond the suit. This is what, even the trial court findings also, that is what I am telling it, my lords.
No, that 32, because it is as per the MOU, and he is questioning that because there is a violation of that. So in that, he is entitled for 32. That's why the court said, as far as 32 is concerned, there shall be a status quo. 32 or 35, whatever it is.
Please.
As far as that is concerned, there shall be status quo and not to injunction and not to alienate.
Alienation will not come, my lords, because he is sought for a suit for declaration, my lords. It's not a suit for injunction. He himself doubts that whether he is there. In fact, my lords, may kindly come to the plain prayer for a moment. Just to the plain prayer.
It is submitted that the petitioner has come before this court, questioning an order that's passed in IA number, in MA number, so and so. Then counsel submits that in one IA, the court has granted, in one MA, the court has granted the reliefs that are sought in both the MAs. And when pending interlocutory order, the court has virtually granted the relief that is sought for in the MA, and the court ought not to have granted injunction, restraining the respondents from interfering with the plaintiff's injunction in respect of 35 guntas, and also an injunction restraining the defendants from alienating the property. Then counsel for the respondent defendant submits that. The respondent plaintiff submits that. After the orders are passed, after the defendant has entered appearance, now the main MA itself is being heard, and at this juncture, there may not the court may not interfere with the order impugned. Next, considering the fact that the MOU that is referred in the order, and as per that, the defendant is the plaintiff has given the 35 guntas of land, the 35 guntas. The court prima facie, considering the same, has granted injunction, also an order not to alienate, and this court do not find any reasons to interfere. Accordingly, the writ petition is dismissed. However, the court shall consider the pending, expeditiously shall hear the matter, shall hear and pass orders. Yes. Not it. Yes. Shivshankar case, I have to take notice on this. No, there is somebody else has filed. Yes. Next.
Sale number 17 adjourned. The passovers matters.
Completed.
Sale number 18.
My lord, I am for the petitioner, my lord. My lord, order at annexure M is under challenge. My lord, the brief facts are like this. My lord, there was a dispute between the petitioner and respondents 5 to 9. My lord, matter was taken up to KAT. KAT, my lord, dismissed my appeal against an order of conversion. Then the matter was taken up before this honorable court. My lord, kindly come to page number, my lord, 70.
Where is the order?
Well, the order is now, in spite of the status of order granted by this honorable court, they say this order is not binding on department, so therefore we grant the license. They accordingly grant the license.
Where is the status quo order?
First, kindly come to paragraph, page number 70, my lord.
Page number?
69, my lord. Roman 7, my lord. Roman 8, page number 69, my lord. My lord, find it, my lord.
There are so many directions.
My lord, kindly come to 8, my lord. Roman 8, at page number 69, internal page
Application
number
filed under section 5 of the Limitation Act is set aside. The matter is remitted back.
My lord,
Conduct a
Roman 8,
spot
my lord.
inspection or survey
Roman,
report.
Roman 8, my lord.
Tribunal must conduct a local inspection. With the so since the parties are represented by so.
Roman 8, my lord.
Pending the final adjudication of the
Yes.
appeal by the KAT, both parties are
Parties are
directed to maintain
the status quo
status quo. No
as
further
of today,
construction.
and no further construction or
So
creation of
what
third-party rights shall
happened?
be undertaken. Now, my lord,
What
kindly see
happened?
this. My lord, I state in this case, my lord, the deputy commissioner was also a party. Kindly see, my lord, page number 53, respond number 2.
Page number?
53, my lord, respondent number 2. He is a licensing authority. He is the one who grants the license. Now, my lords, what happens, my lord, after this order, we give a representation. My lords, kindly see annexure F, and legal notice also, my lords, given at annexure G. Kindly see, my lords, page number 70.
What
76.
happened to your appeal? What happened to your appeal?
I did not. Which appeal, my lords? This is not appealable order.
No, not that order. You are saying that there was an order of status quo. That status quo order is violated is your submission. When you look at this order dated, this order at page number 55, operative portion at page number 69, it
Yes,
speaks about a pending adjudication of the appeal. Parties are directed to maintain status quo.
That appeal is pending before KAT.
Even till now.
Yes, my lords, kindly see page number 69. My lord, this order came to pass. My lord, kindly see this order. This order came to be passed, my lord, on 24 February 2025. Kindly see page number 53, my lord. My lords, finds it, my lords?
Yes.
Yes. Now, my lords, immediately after this order, we give a representation as well as legal notice to the respondents, saying that please don't grant a license. There is already an order of status quo. Please don't grant a license in respect of respondent number 10, who entered into an agreement of lease with the respondent number 5 to 8 in spite of the order of status quo. Now, my lords, kindly see, then what they do is they recommend to the Commissioner of Excise that my lords finds a translated copy at page number 82. My lords, kindly see the date, 27/3/2025. Within not even a month of the order, he recommends for grant of license, and Commissioner gives the approval on the basis of that. And my lords, kindly see the endorsement what they give.
No, that is.
They're contesting respondent.
Oh, that is correct. Now he is questioning the order of the second respondent. You are a party to the writ petition. There was an order of status quo. They don't serve the papers in advance.
No, we do, my lords. Otherwise, matter will not be
And the
listed
papers,
before.
what is the purpose of serving the papers in advance? When the papers are served, you are supposed to get instructions. And for that reason, we don't adjourn the matter again. It's a simple issue. He says when there is an order of status quo, how come it is recommended and an order is passed on the face of it? Please come. Then counsel for the petition submits that when there is an order of status quo till the disposal of the appeal.
The third
Appeal
respondent.
in 18360 of 2021 dated 24th February 2025. It is submitted that when the appeal is still pending and the status quo order is still operating, the impugned proceedings are issued by the respondent number.
My lords, 2 and 3, my lords.
2025 is issued by the third respondent, considering the submissions and considering the fact that it's an order of status quo. The respondents are directed not to take any further steps pursuant to the order dated 8/4/2025. AGA takes notice on behalf of respondents 1, 2, 3, 4. Notice to respondents 5 to 9.
For 19. Till number 19, Najib Ahmed.
What is this? That. Hmm.
The vehicle is due from 6/4/2036, and the state has to pay the objection.
No representation on behalf of the petitioner. This is matter in the month of August. Till here we'll complete admission matters, then we'll take up.
Cell number 20. Hangame Shadbi, petitioner.
Arguing counsel is not well, keeping well, kind of 2 days accommodation.
IA filed for early hearing. This is a matter on 8th of July. Accordingly, IA is ordered.
Cell
Yes,
number
21.
21.
Next week.
Ramesh Chandra.
Yes.
21. Press for a time minute, counsel.
This is matter in the month of July at the request of non-counsel petitioner.
Cell
Yes,
number
22.
22. VD Raviraj.
Petition in this. The petitioner is the second defendant before the trial court. We are challenging the order of restoring the compromise decree. Compromise petition was allowed and decree was passed. Then on the application of the plaintiff, the matter has been restored. The plaintiff filed the suit.
We'll hear it tomorrow. It takes time. I have other matters to take up. This is this matter in the second list tomorrow on the top of the list. Yes, 23.
Cell number 23.
I have a copy for the petitioner, my lord.
Yes.
My lord, the suit is for partition and recovery of possession, my lord.
Yes.
The initial suit is instituted against only dependent 1 and 2. I have subsequently impleaded. Later, my lord, against 1 and 2, it got deleted, my lord. He is pursuing against only respondent number, dependent number 3 petitioner herein, my lord. The cause of action is, my lord, ink page 27 of the plaint, my lord. Para 7. The cause of action arises to file the suit on 11/6/2000 when the
Page number.
defendant,
Page number.
page number 27. Last para number 7.
Yes.
The cause of action arose to file the suit on 11/6/2017 when the defendant too started to dig the pits, the suit property with the help of his labor. So suit filed today is in time. The suit property is situated within the jurisdiction. It is cause of action against only defendant 2 and 1, my lord. When they were deleted only, they cannot pursue against only defendant number 3 who is petitioner herein, my lord. When the suit is dismissed,
It is a party dependent to the suit.
my lord, after commissioner report, during the pendency of the file, my lord, they appoint a commissioner report without my presence, my lord. In the commissioner report, it was found that defendant number 1 and 2 were not encroached. Defendant 3 is encroached the property, my lord. Subsequently that I am being impleaded, they got deletedly conveniently, my lord. Now there is nothing against me in the pleading or in the cause of action, my lord. The suit does not.
They got deleted.
They got deleted by the plaintiff itself, my lord.
What is deleted?
The defendants themselves, they got deleted. Defendant 1 and 2 are deleted, my lord. Only against me is the suit is pending. My lord,
For-
suit is for, my lord,
To
prayer
direct
at,
the defendant number 3 to demolish the construction made in
please, my lord.
and hand over the vacant portion of the same.
Please, my lord.
To the plaintiff.
Please, my lord.
You are making the construction.
No, my lord, it is 37 years, my lord. 19 constructed way back in.
What a declaration and a mandatory injunction.
Please, my lord.
Why
lord,
is it not ended?
My lord, the cause of action is not against me at all, my lord. Please see the cause of action. It is against defendant 2 when suit is filed in 2017.
And what is the relationship between you and the defendant number, other defendants?
No, my lord, the common vendor, I am purchased from the common vendor, defendant 2 and defendant 3, my lord.
How you are impleaded? Where is that?
The impleading application at ink page G, my lord. Annexure G 57.
57?
Page number 57, annexure G, the impleading order.
Yes.
And that has also been challenged before this honorable court in the separate writ petition, my lord.
Where is that? What is that number?
Writ petition number, next page I have heard, annexure H.
List along with so and so.
Cell number 24.
On 7th of July.
Cell number 24.
Give the number, write the number and give it to the court officer.
My lord, it is there in the annexure. I made annexure.
Write it on a paper and give.
10181 of 2024.
Yes, 24.
Jai Mahadev.
24, my lord. My lords, I have filed this above civil division petition challenging the order passed in IA number 1 of 2026 in OS 26080 of 2013, my lords. My lords, the present matter deserves immediate interference of the Honorable Court for the simple reason, my lords. The trial court is proceeding on a suit which on the face of the plaint itself is barred by the
What is the suit for?
I'll brief the case, my lords.
Yes.
My lords, the plaintiff filed OS 26080 of 2013 for partition and declaration, claiming the suit schedule property to be an ancestral property, my lords. My lords, the plaintiffs have filed this case, has a chance litigation, I'll tell you, 2 years after the property was sold by defendant number 1. My lords, in the case, in the trial court, defendant number 1 is the father, defendant number 2 is the purchaser, and I am the petitioner is the defendant number 3, who is the subsequent purchaser, my lords. The plaintiff has filed this partition suit 2 years after the sale of the property, has a chance litigation only to, try and extract some more money, my
File an
lords.
IA for rejection of claim.
Yes, I'll come to it,
On what
my
ground you
lords.
have filed, please come to your affidavit.
Yes, my lords.
Yes.
My lords, I have filed an IA for rejection of the plaint on the reason, in fact, the plaint itself admits.
It's barred by law.
Yes, my lords. The plaint admits that it's barred by law. I'll come to it, my lords. The plaint averments themselves state that the suit property was allotted to the share of defendant number 1 through a registered partition deed dated 6/6/2003, my lords. And further, the plaint admits that defendant number 1, who is the father, has executed a registered sale deed dated 19/5/2011 in favor of defendant number 2, my lords.
Now, please come to the order impugn.
Yes, my lords. Once the, we filed an application for order 7 rule 11, stating that once a partition takes place, my lords, the property becomes a separate and a self-acquired property of the defendant, the sharer, and the defendant number 1 had every right to alienate the property, and also that the plaintiff had no vested rights during the lifetime of the defendant.
Paragraph number 10, and we'll read the order.
Yes, my lords. The learned trial judge failed to appreciate that an application under Order 7 Rule 11 is maintainable at any stage of the proceedings.
Page 22 of the impugned order.
Page 22,
paragraph
my
number
lord. One moment. I'm sorry. Point number 10, page 23, my lords. The plaintiffs have filed the present suit for relief of declaration to declare that the sale deed dated 19/5/2000 executed by defendant number 1 in favor of defendant number 2 is not binding on the plaintiff, partition separate of their 1/3 share, the suit schedule property, and also prayed the permanent injunction restraining the defendant from interfering with the plaintiff's portion enjoyment of the suit schedule property. Am I on the same page, my lords? My lords, here the
13.
My lords, here in the trial court, the judge has taken into account a few matrimonial allegations and emotional accusations, and since the grounds taken for rejection of the application under Order 7 Rule 11 is that the trial is already commenced and also that evidence is recorded. But my lords, Order 7 Rule 11 for rejection of plaint can be accommodated, can be accepted at any point of at any stage in a proceeding. It is an accepted fact of law, my lords. Earlier in many proceedings, like we have seen that Order 7 Rule 11 can be.
What is the present stage of the suit?
My lords, it is for defendant evidence, and that is on day after tomorrow, my lords. And my lords, the petitioners has the balance of convenience, and no prejudice will be caused to the plaintiff, even if the proceedings are stayed for a short period of time, my lords, until the adjudication of this revision petition. So I humbly pray for a stay order on the proceedings until this revision petition is looked into, my lords. The core issue before this honorable court is whether a trial court could reject the application uh, under Order 7, Rule 11 of CPC merely because trial court had commenced despite the plaintiff itself disclosing that it is barred by law, my lords.
In the though the plaintiff stated that the suit scheduled property given to the share of the husband of plaintiff number 3, that is defendant number 1 in the
Defendant.
family partition, but not at all admitted that the suit scheduled property is a self-acquired property of deceased defendant number 1. She has not admitted.
My lords, the defendant number 1 has obtained this property onto his share through a registered partition deed, my lord, and the larger portion of the scheduled property was divided between himself and his brother. So this scheduled property becomes an independent self-acquired share of him once the partition is done, madam. And children cannot claim for a, they cannot claim a share in this particular property during the lifetime of defendant, right, my lords? And I have also cited citations of Supreme Court, one AC 877, one Angadi Chandrana against the others, wherein, it is 2025 SEC Online AC 887, Angadi Chandrana versus Shankar and others, where the Supreme Court clearly states that once a partition takes place, the particular property becomes a separate and a self-acquired property of the sharer, my lords.
Dismissed. Order will follow. Yes, next. Call the, not take up the remaining list. Call the passovers. 230 matter. First 230 matter. 230 matter.
Matter moved at 2:30.
Only that some settlement and other 230 matter I will take up some other day. Other 230 matter listed on 16th.
Serial number
89.
My lord, I may be allowed to make a submission regarding serial number 205 in list 2 regarding the paper publication, my lord.
Please wait, please wait. Yes.
89.
Yes, much obliged.
Settlement for settlement 89, sir. 57. List 357.
Where is the settlement? Take that. Take that.
Neither party do not have any monetary claims against each other. That is the comments of state of the settlement. Matter is there before the trial court, will file the compromise on that.
No, that will be recorded before the commercial court. Yes. So in the light of that, we'll dispose of this petition.
He has given us all arrears of rent and they have agreed to give us 60-day possession. That terms has been.
You have given up that claim of and a joint memo is filed stating that parties have entered into a compromise whereby the landlord is ready to pay the entire arrears of rent and the tenant is ready to vacate the premises within 60 days from the date of recording the compromise by the commercial court. In that view of the matter, the writ petition is disposed of. Where any date to be given to record this before the, as it is submitted that the matter is coming up on 18, on the day, the court shall record the compromise. Yes, dispose. Both the matters. Yes, next. One more matter.
Serial number 89.
Listed to 18.
89.
I have
Give
filed.
that, give that file, give the list.
230.
No, no, cause list, it has come along with the other file. 89 in second list.
89 in list number 2.
Please.
What is this?
My lord, this petition was disposed of in the 20.
Huh?
I am the auction purchaser, my lord. This writ petition was
Extended the time beyond the statute requirement.
up until 30th May
3 months more time.
on medical grounds, my lord. I have affixed the medical documents as well, my
The
lord, in
impugn
the IA.
communication dated passed with respondent with the petition shall pay the remaining amount by 30/5/2026, or else the respondent bank is at liberty to forfeit the amount that is paid by the petitioner.
Please, my lord.
What is the amount?
My lord, amount due is now 50 lakhs. Total bid amount was 1 crore 22 lakhs, my lord. Now I have paid 70 lakhs, my lord. Now balance is 50 lakhs, my lord. 50 lakhs, 50,000, my lord. Now I am seeking extension on the medical grounds, my lord.
What are the medical grounds?
My lord, he is keeping ill health, my lord, due to severe fever, my lord. He has been admitted to the hospital for more than 15 to 20 days, my lord.
Where are the documents?
Documents at annexure at page number 9, my lord. IA which is filed by me. 9, 10, 11, 12, all the medical documents, my lord.
Where is that IA? This is the one.
3rd of June, I have filed IA.
Mr. here has not come with clean hands, my lord. He's a proxy to the borrower. The 40 lakhs check is issued on 28th of May, my lord. It is that of the daughter of the borrower. Anasa P. Is P. Anand's daughter.
My lord, I am not getting to all those things, my lord. I am the purchaser. I am the bona fide purchaser, my lord. Highest bidder, my lord. I am not in that way coming in what my learned friend is submitting, my lord.
And the check paid 40
When you're going to pay?
My lord, 3 months I was out, my lord. At least 15, this end of this month, my lord, I'll pay, my lord. Because due to the ill health, my lord, my lord, we know our limitations, my lord, before your lordship, but
He is suffering with fever, that is illness, and you will, 35/2026 is the day when you have to pay.
Please,
Now
ma'am.
you say you require 3 months. No, the court will grant, for 15 days, the court will grant 3 months time.
No,
And
my
why
lord,
did you accept? Let them forfeit the amount. I'll not extend the,
my lord, the reason is that, my lord,
please wait. I do not find any bona fides in this application. At least had you asked for another 15 days, 10 days, I could have understood. But
Lord.
not this 3 months time,
my
I
lord,
will not
my
grant.
lord, 3 months, the reason is that, my lord, he has been admitted to the hospital, my lord. Otherwise, we know our limitations, my lord. There is no point in filing this
What
application
is,
as well, my lord.
for
My lord,
fever,
no.
he is admitted in the hospital and he'll be there for next 3 months.
My lord, he has been admitted for the dengue fever, my lord. The platelets have been come down, so he has been admitted to the multi-specialty hospital at Bangalore, my lord. Earlier, he has been admitted at Dobbulapur, my lord. So there, the treatment, he couldn't suffice to that, my lord. Then he has shifted to Bangalore, my lord. That's the reason I have filed this application, my lord. Even on 28th, deposited 40 lakhs
Where
rupees
are the
check, my
medical
lord.
reports to show that?
My lord, it's page number 9, my lord.
Where do you get the platelets come down?
Lord, that blood reports have been, those are confidential, my lord.
All,
My lord,
if it is really, it is what you say is correct, you would have filed all that.
my lord, I annexed
Not
the
find any
application. My
reasons.
lord, I have recorded, I have put all the medical documents as well, my lord.
What medical documents? Some doctor
Lord.
to whomsoever he is suffering with fever.
No, my lord, another doctor, my lord, kindly come to page number 11, my lord.
Viral fever.
Please, my lord. There they have diagnosed viral fever, my lord.
Hmm.
Then after the blood test, the platelets have been come down and he has been admitted to the
Where is
multi-specialty.
that? Where did they say so?
My lord, no, he's still at the hospital, my lord, because up until his discharge, we are unable to get those
At
medical
least you can
documents, my lord.
show to the court. The court is, you have placed before the court the prescription.
Please,
How
my
where did they say so?
Lord, these are the prescriptions at the earlier hospital, my lord. Now he is still at the hospital at Bangalore. Up until his discharge, we are unable to get those documents, those medical documents, my lord, because the file is still at the hospital, my lord. That is the reason I am asking
You're
for
telling
extension.
as if that it is some kind of a criminal
Lord, no.
record which you cannot have
Lord, because
access to.
Lord, the doctors are treating the patient, we are unable to get
Those
those
kind of
documents, my lord.
indulgence.
My lord,
IA is dismissed.
at least, my lord, at least end of this month, my lord, 15 days will
It
pay
is-
the amount.
Please don't bargain with the court. Please wait. Please don't bargain with the court. If you have, you come up with an affidavit saying that you require 10 days. I can grant you at best. What is, already you had enough time till now from 30, 15
least-
days is already over. And at best, will grant you till 30th of June.
Please,
You come up with an affidavit tomorrow.
Please, my lord.
Tomorrow, if the affidavit is filed, we'll grant till 30th.
Please, my lord. I'll file affidavit.
Ultimately, you have to get the money.
My lord, more than 70% have paid, my lord. More than 70 lakhs have paid, my lord.
Parava's daughters is depositing that 40 lakh rupees.
My lord, amount has to be credited to the bank, my lord. Moreover, she is the wife of the borrower, my lord. I am not getting to all this.
Yes,
I'll
yes,
have it
next,
tomorrow, my lord. I'll
next.
file affidavit.
Tomorrow,
Please,
this is matter, tomorrow on the top of the list, in the second list.
please, obliged.
230 minutes.
Top of the list in second list. Yes, next.
Pass over.
Huh?
Serial number 59.
Huh.
This number. Tomorrow we have a date of.
No, I'm still hearing the matters. Please wait. Yes,
I will call up to that 2:30 movement.
2:30 is over. No, 2:30 mood matters, Super. Yes.
2:30. That 2:30 movement, serial number 59 in this two.
Time for the petition. My lord, under the dispute of a public charitable trust among the trustees, case suit is instituted. And in the year 2023, defendant has concluded
What is the suit for?
suit for declaration and injunction, my lord,
Suit is of the year 2017.
17.
You are the plaintiff in the suit.
I am the plaintiff.
What is IA?
IA is for appointment of administrator, my lord.
Let's see that. What happened to
20,
that?
my lord.
Page number?
Page 20. The reasons for rejection of my application is that para starts from page 19, 8, para 8. The suit is registered in the year 2017. There is specific allegation against the defendant that they have no right to continue the office bearers of Karnataka Seva Samiti Trust. They have deliberately defaulted and they have no right to administer and possess office bearer. The plaintiffs have filed this suit on 9/11.
Now the respondent is managing the affairs of this temple right from 2014
Please,
and till now.
till now.
What is the necessity, what is the grave necessity to appoint a receiver now?
The committee has committed a fraud from the year 2004 to 2009. That is based on that allegation should.
That will be taken care of in the
And
suit that
my
is
lord,
pending.
That's true, my lord. That about my lord, when defendant adduced his evidence, he suppressed these books of accounts for the year 2004.
No, as per the order of this court,
Please.
what is the time limit that is fixed to
No, my
dispose
lord.
of the matter?
It directed expeditious disposal. It so happened, my lord, the defendant wanted to examine the one of the plaintiff as his witness. That application came to be rejected. That was challenged before this honorable court. During the admission of the time, stay was granted, and that stay was subsisted 2 years, my lord. Last year only it got
No, when was the order of expeditious disposal?
25.
25.
25.
How much time is granted?
No time.
It just said
No,
expeditious
no
disposal.
time. So since when that
That, because now it's at the fag end, let it be decided. Why should at this point of time a receiver be appointed?
No, my lord.
Virtually, like you wanted, whatever you want, you will achieve it by this.
No, my lord, if we are unable to procure the materials for the year 2004 to 2009, the very purpose of filing this suit itself is going to be defeated. Defendant conveniently, because he is under the care and custody, he has taken care.
Seeking for appointment of administrator to
Interim.
take over the management. That is what the purpose you have filed.
Please.
Uh,
At least we can able to summon the documents in relation of.
So at this stage, it won't, already the evidence is completed.
Since they have not produced, that came to light in the evidence stage.
Achieve directly, you can't achieve indirectly also.
So it is not direct or indirect. The very purpose of the suit is
The
for what?
suit itself is going to be disposed of when the whole purpose of it is that you filed it under section 92 of CPC.
Very simple sentence, my lord. See, fraud committed for a particular period and those materials were not placed before this honorable court. And how can we expect that?
17 to 26, you have not sought for anything. But the fagend of the suit, we will not pass any order. And the court was right. Dismissed. Order will follow. Next.
Cell number
Please.
63.
60?
3.
Petitioner.
63.
Petitioner was is
Yes,
aggrieved
yes,
by
Amma.
the dismissal of its application under 7 Rule 11 for rejection of claim. Your lordships on the last occasion, 63. Your lordships on the last occasion had indicated, my lords, that you would like to dispose of the matter itself.
Notice to now in this matter. There is some documents also need to be filed.
My lords, the only difficulty is this, my lords, that matter was listed before the trial court today. And the trial court has adjourned the matter for the 17th, my lords, for final arguments itself, my lords.
17th.
17th.
And all the more reason you have a lot of time.
My lords.
This is a matter on, this is a matter on 15th in the second list, top of the list. Yes.
Great.
Yes.
Cell number 68.
68.
Vivek is
68.
Suit for declaration and possession, my lords. An application was filed by the petitioners under Order 7 Rule 11.
When is the suit coming up before the?
Tomorrow it's listed, my lords.
When was the order passed?
Order was passed in 29th May 2024, my lords. In fact, matter was listed on several occasions, but it was not reached, my lords.
You mentioned about a case where an impugned order is of the year in the month of March 2025, more than almost 1.5 years. And you say that there is urgency for this.
In fact, matter was listed on several occasions, my lords. It did not.
That is the whole difficulty. All the matters are listed on several occasions. Office objections, it's on 31/7/2025. It came up on 22/8/2025. That's it. Later it has come up before me.
So even in September 2025, it was listed, my lords. It
Only
not
once it has come up.
And even in
Once
April,
office objections overruled, second time it has come up. Then after that it has come up before.
even in April, it was listed, my lords, but it did not reach. April 28th or 29th.
What is urgency now in this?
Matters posted for dependent evidence, my lords, before.
Nothing will happen. Notice to the respondents. Petition is permitted to take out hand summons on the counsel appearing to the respondent.
Notice to respondent number 7 may be dispensed with, my lords.
Give a memo. Memo is filed seeking dispensation of notice to respondent number 7. Dispense with the risk of apply. Yes, notice to the respondent, list this matter after service of notice. Or the petition is permitted to take out in addition and shall file a memo to that effect. Once the memo is filed.
Permitted to take out hand summons also on the.
That's what I said. Yes,
Cell
next.
number 90. 90. Suresh.
Moved by the
The petitioner
injunction was refused by the trial court. They filed a writ petition. Therefore, I filed there's an order of status quo on 29/4.
No, I'm only entertaining it if the matter is any urgency, if it is coming up before the court.
No, the
5
reason,
acres of land I own.
That is not the urgency. That is urgency for everybody in all the injunction matters. Urgency is if the matter is coming up before the trial court. Morning, somebody mentioned saying that it's coming up before the trial court.
Tomorrow is before the trial court. The reason is, in 5 acres, they are claiming an injunction suit for 6 quintas. And based on this status quo order granted by the Honorable Court, they are now
This
declaring.
is matter on the top of the list tomorrow in the second list. Yes, next.
no, actually in this matter, there is status quo, my lord. This honorable court has granted a status quo. We are not interfering today, they are not
I show
interfering.
the photographs.
My lord,
Yes, next.
205. Cell number
Appearing for the
205.
petitioner, my lord, with
There
regard
is an
to.
IA.
Yes,
IA is
yes.
there for paper publication.
Substitution.
IA is filed seeking substitute service of notice on respondent number.
For respond number 7,
On respondent number 7 by way of paper publication. Accordingly, ask for that IA instead again coming in. IA is ordered and the so and so is permitted to take, give the dates, permitted to take substitute service. Yes. Next.
much obliged, my lord.
List number 3. Serial number 96. List number 3. Serial number 96.
serial number 90, interim stay has to be extended. Serial number 90, interim stay has to be extended.
Interim order will be, yes.
96, my lord. This matters to an execution petition wherein.
What is
my
the
lord,
urgency in this?
Page number 97, my lord. There is a direction to use bulldozer and the SP Madkeri has been directed to give assistance.
90?
Page number 96, 97.
Hmm.
IA under 9, section 151 of CPC filed by the applicant DHR is allowed. Decree holder number D is permitted to take assistance of Devi earth movers Madkeri to remove the obstruction.
You're reading where? I'm not able to see that.
Last page number 97,
Yes.
orders.
DHR and his counsel present. Dated?
Ink page 96,
That's where I'm.
96, 97.
Date of the order.
IA number 9 under section 14(1)26.
That is page number 100. Yes.
IA number 9 under section 151 CPC filed by applicant is hereby allowed. Decree holder number D is permitted to take the
Let's see
assistance.
the order. What is this? The HRS file I am trying to direct the.
The JCB is permitted with number.
In spite of issuance of court notice, the judgment letter number 1 remained absent.
My lord, these are villagers they are not able. No, I understand, my lord. On that point, no, my lord. What has happened in this case is it is not an order of declaring the easement right. It is only an injunctive order where the house of the applicant is. In fact, there is an observation, my lord. So I'll just point out, my lord.
What is the decree?
The decree is at, my lord finds at page number 41. It is further ordered and decreed that by means of permanent injunction, prohibitory injunction, dependents, their men, agents, power of attorney holders, or any other persons claiming to them
Yes.
are hereby restrained from blocking the suit schedule property.
It is a case that you have blocked it and now they want it to be
No,
removed.
this, my lord, the decree is of 2008. Execution is filed in 2019. And
When notice is issued to you, you don't respond to what particular court?
no, they have appeared, my lord. This application they have not objected because there is a direction to demolish the house. So even, my lord, may kindly see, may kindly
Was
go
an
to-
injunction in the year 2009. When did you construct that?
after the decree was passed.
Then how can you do
My
it?
lord, he has slept over the matter and he has used.
No, if there is an injunction against you, how can you say that I even after a judgment,
No,
after
my lord,
suffering
my lord, that's why I was submitting, my lord. It is not a declaration of easementary right. The decree holder is also under permission. I'll just point out, my lord.
you have blocked it. That is what is the contention.
No, after that, he has used an alternative road. Then these people have built the house. My lord, may kindly go to page number 36. I will just show the right of the decree holder. It is only a permissive right that has been given.
Are you bound by this or not?
My lord, there is no dispute on that.
If you are bound by this and having suffered a judgment and decree, can you do it contrary to this?
No, my lord, but it cannot go beyond the decree is my
Yes,
submission.
not going beyond the decree. Where is it going? There was
My
a
lord,
direction to keep it, not to block the road. For whatsoever reason you have blocked and constructed. Now, then you don't even go before the trial court when the matter is listed.
My lord, may kindly read this page number 100, my lord.
Interference of
No,
the
I'll
court.
just point out one thing, my lord.
Not, which we can't.
No, my lord, if it does not impress, I won't pursue, my lord. Just one, my lord. Page number 100. I was just reading that order. That is 90.
Yes.
Commencement, the second paragraph. In the affidavit annexed to the application, the decree holder has stated that the judgment debtors have constructed a house on the decree schedule, which is the only approachable road to the decree holder property. To remove the obstruction which are caused by the judgment debtors, the JCB is required. The concrete constructions cannot be removed through manually. Machinery like JCB is required. Therefore, he prays the direct Devi Earth Movers Madkeri to assist the court Amin to execute the warrant. Now, the house is being demolished. And even there is a direction at page number 90.
Because there is no
Page number
nothing
103,
wrong
my
with this
lord.
order. You have done something contrary to the judgment and decree. And how do you seek protection from this court?
My lord, it is going beyond the decree, my lord. I can understand if that was, it's an only,
What exactly do you mean by saying it's going beyond the decree?
well, it's only an injunctive order. It is
What is
not,
that order? You're injuncted from making any construction on that, on the said road?
I'm only in injunction order not to block. And he
And
sleeps
by
over,
constructing a house, the road will not be blocked.
no, for he sleeps over the matter for 11 years.
I'm sorry, I'm not impressed with that document. Yes, dismissed. Yes, next.
That's the matter moved at 2:30. Submit test.
Which is? Yes.
Moved it. I've served the standing councils, my lord.
Where is he?
I've informed him also that it will be Mr. Devraj. I've served him, my lord. So I'm just passing on that.
Yes.
I've served. I'm challenging the erection of high tension tower lines on my property, my lords, without following the due process of acquisition and in complete violation of the SOP, my lords, issued by the Ministry of Power, on the strength of an order passed by the District Commissioner, my lords, in terms of Section 16 of the Telegraph
Ultimately,
Act.
you're entitled for compensation.
Please, my lords, the compensation must be paid upfront as per the guideline, my lords. There is absolutely no notification. They just prefer a petition before the Deputy Commissioner, my lords, for an order against me, injuncting me from
No, you
obstructing.
do not know what is the procedure that is followed.
My lords,
You have no, because you may
my lords,
not be knowing.
the Deputy Commissioner gave me notice of this particular proceeding, injuncting me, my lords. Then subsequently, I participated in that proceeding and I have taken a specific ground, my lords, that as per this particular SOP,
Why
it is not
should it
for.
be stopped? What is your grievances with regard to the compensation?
Please, my lords.
That they are bound to pay it.
Now, my lords, as per the Ministry of Power's own guidelines and the standard operating procedure, my lords, the compensation has to be assessed first, and thereafter, my lords, upon my NOC and looking after where the tower is going to be erected in the property, insofar as the tower bases are concerned, my lords, subsequently compensation has to be assessed, an NOC has to be obtained, and thereafter, my lords, the work has to commence. May I just pass on the SOP, my
So
lords?
that's, because by doing, if there is any requirement, urgency for when the larger public interest, they have to do it.
I understand, my lords.
And ultimately, you can't, under the Telegraphic Act will apply, and you have no right to stop them.
My lords, insofar as the Telegraph Act application itself, my lords, the Honorable Supreme Court in Kalpataru's case, as recently as 2025, has observed that there is a lot of lacuna, and it has referred to the Law Commission, my lords, for when the compensation has to be determined. Against that, my lords, on 14/6/2024, there is a clear standard operating procedure published by the Ministry of Power, my lords, which is applicable to
What
all.
is happening?
Guidelines have been issued. But so far as the work is concerned, not that we have a right so far as the
So what happened to his compensation? Have you followed the? No, according to him, as per that SOP, first you have to give the compensation, then you have to lay the road.
First, not that Deputy Commissioner will assess the compensation. After assessing that is the 2 times required to be paid. This is the method that is the subsequent notification which has been coming before. The scheme is earlier, so far as that is concerned, already assessment was made. That by virtue of that assessment, we request to pay that we are already assessed 3 lakhs and a half, so far as that they are engaged in the tower trees as well as the Karnataka. That they are definitely engaged. But I got so far as that.
What he's saying is, before you erect the towers, there should be determination of the.
That has been determined by the district magistrate. Determined. I will place it on record.
My lords, in fact, the Deputy Commissioner's order is silent, absolutely silent.
If it is determined, doesn't he have a right to know about it? What is the compensation?
The compensation we entitled that already determination was there. I'll place it on record.
Does this matter tomorrow?
Please, my lords.
In the first list. By the time you please get all the documents.
In the fresh matters list.
First list will come.
I'm grateful, my lords.
Pass over matters in list number 1, serial number 9.
My lords, in this matter, I have served the copy, my lords, to the council for respond number 3, my lord.
You have any instructions in this?
Note.
Oh.
The notice has been issued in the month of March itself.
My lords, there is a serious threat of disconnection now, my lords.
What are you doing from when notice is issued to you in the month of March? What did you do?
My lords, the petition was filed on 27th Jan, my lords.
26/3/2026
Subsequent, my lords, because of the vacation, it was delayed, but there is a serious threat of disconnection, my lords.
What are your
Without,
instructions?
Reply to this notice.
Huh?
Reply to this notice. That big consideration that.
You will not disconnect the power supply, subject to paying of,
please, my lord.
please come. The, so and so takes notice on behalf of respondent, all the respondents,
Which they were right.
takes notice, that is the order of the
Respondent
docket.
one and two. Third respondent is Panchayat Development Officer.
Panchayat Development Officer who appears. Any notice to him is not necessary in this. The respondent, so and so takes notice on behalf of respondent, accepts notice on respondent number 1 and 2. Next, the present writ petition is filed in the following prayer. When counsel for the petitioner submits that. By way of a partition, through a partition deed dated 12/12/2024, an extent of 1 acre 4 quotas in survey number 145/1116 fell exclusively to the share of the petitioner. And she applied for the conversion of the Deputy Commissioner, Bangalore South District, via official memorandum dated 17/7/2025, passed a deemed land conversion order under section 95(2) of the Karnataka Land Revenue Act, converting the specific share of the land for shops, industrial for purposes, after she remitted the necessary conversion and layout fees. And a five-story building was constructed on the scheduled property. After submitting all the required documents, including approvals from the electrical inspectorate, respondent number 2 sanctioned and provided 15 distinct electricity connections under the LT1 residential tariff on 29/3/2025. And ever since they have been paying the usage charges and are enjoying the services. Basing on a frivolous complaint filed by a third party, a notice is issued dated 16/2026. The basing on delete the date, basing on said complaint of the third party, a notice dated 26/3/2026 is issued. What did they say in that notice?
Produce all the document to the
Asking the petitioner to produce all the documents within a period of
7 days, my lords.
What are you doing from then?
My lords, we have produced, my lords. We have produced the document, my lords.
Have you submitted your explanation that I shall, then I'll ask them to pass orders, if that's
Please,
okay.
my lords.
26/3/2026. Huh? But he's saying, so whatever you have, you pass orders. 26/3/2026, they have submitted their explanation to the show cause notice with all the relevant documents. It is a submission that without passing any orders on the said explanation submitted by the petitioner, the respondents are taking steps to disconnect the power supply, which made the petitioner to come before this court. Next para. Learned counsel appearing for respondents 1 and 2 submits that it is stated that the petitioner has submitted his explanation to the show cause. It is if submit that he has submitted his explanation to the notice dated 26/3/2026 with all the relevant documents. It is submitted that in that case, they'll consider the same and pass appropriate orders, and till such order is passed, they will not, they'll not disconnect the power supply, subject to the petitioner paying the regular consumption charges, regular consumption charges. Accordingly, the petition is, this court is passed the following order. The petition is disposed of, directing the respondent 1 and 2 to consider the explanation dated 26/3/2026 in accordance with law within a period of 10 days from the date of receipt of the copy of the order till such time the respondent shall not disconnect the power supply subject to the petitioner paying the consumption charges.
Submitted to the notice dated
26/3/2026, if a notice, explanation to that notice, if any. Yes.
Great.
Number 10, Sudhati.
If the petitioner, if the petitioner has not submitted any, even the petitioner is at liberty to submit his explanation to the same by tomorrow.
Then number 10,
I can
Sudhati.
understand that the petitioner might have not submitted from your submissions. Yes.
10, Sudhati.
Item 65, my lords, may be picked up.
65 also.
It was heard yesterday, yes. All are same, the word by word, the notice documents.
So where is that affidavit?
Yeah, affidavit, my lords, maybe. Copy,
You have
sir.
given him a copy of it?
Please. Sir, warning on it.
I will not be taking any other matters. All matters will continue tomorrow. All matters will continue. Interim order will be extended. Any urgency for the matter tomorrow, if the matter is coming up before the trial court, you can mention tomorrow. I will take up at 2:30. And all the matters, interim orders will be extended, and a request not to make any mentions now. Yes. Huh? Which one?
Details has been coming. It will be repeated, Milord.
Now, whatever, wherever from that matter, second list will start. Whatever is the last, what is the last case?
Serial number
Second list.
from 25.
From 25 second list, the matters will continue tomorrow.
Yes.
And all other matters, wherever there are interim orders, they will be extended.
Yes.
Yes. Yes, please.
Wrongly posted in the B group. That's
Which
why
one?
Serial number 32, Milord. It's been tagging behind. We have been waiting for almost.
No, it will come tomorrow. Tomorrow it will come because it will start from 29.
My lord,
Yes.
one indulgence, my lord. I'm sorry, my lord. Serial number 41 list, there is a direction from the apex court, my lord. To dispose the matter in 6 months.
40?
Serial number 41 list 3, my lord. Direction from the apex court to
We will
dispose the
see.
matter.
We will see Monday.
My
Let
lord.
it be there in the
First-
list.
First list, my lord. First list, top of the
Not
list.
tomorrow. There is so many matters. Let us complete Monday.
Monday, top of the list.
Monday, we'll see on Monday. Yes. Yes, where is the affidavit, you said?
Right, my lords, before
Have you
reading,
seen the affidavit?
yes, my lords. Before reading the affidavit, if I can narrate my couple of facts from the paper book, it will be, my lord, or I can read the affidavit also. I covered
See
it.
the affidavit.
Yes. May I read, my lord, then? I state that I have presented this writ petition questioning the order dated 21/8/2025 as per Annexure D passed by the respondent directing me to shift the location of the licensed business in 90 days thereof. The reason was the objection raised by an organization that it is opposed to rules. I state that the license for the current year is renewed as per Annexure A on 1/7/2025, keeping it valid up to 36/2030 by respondent after satisfying that the licensed premises is not objectionable in terms of the relevant rules. But on 12/8/2025, after the lapse of 42 days, a show cause notice was issued directing me to reply in 3 days as to why the business should not be directed to be shifted on.
I think this
The ground
paragraph number 2, the date of 7/9/2025.
Yes.
In paragraph number 3,
Yes.
21/8/2025, I think there is no.
My lords,
some-
There's a
I?
gap,
The
there's a
dates.
gap, yes.
My lords, the dates are relevant, my lords, with respect to both the petitions. I'll apprise my lords, kindly make a note of the dates, my lords. I request my lords.
If I
My
can-
lords, in both the petitions, my lord, that is writ petition number 17043 of 2026 and
Yes, yes.
17049.
Give the
Yes, my
dates.
lords.
The dates are same in both cases.
Please, my lords.
Three
12
cases.
One second,
One more
one
is
second,
yet to
one
come.
second, sir. 12/8/2025, my lords, in both writ petitions, notice was issued to the petitioner to shift for shifting of the shop, my lords, in violation of Rule 5, my lords. 21/8/2025, they gave the reply. And in another petition, it is 19/8/2025, they gave the reply to the said notice, my lord. And my lord, and 21/8/2025, time is granted for them for shifting the shop, that is 90 days, my lords.
21?
21/8,
Same day of the
2025.
reply.
No, on 21/8/2025, immediately after
That,
looking
that is,
at,
that is in one writ petition, 17043, my lords.
no, I'm asking, have you passed this order after considering their explanation or before that?
No, 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 my lords, we have consulted them. We have,
Same day.
or they have been heard, my lords. They have given the reply.
1 minute. What is the procedure contemplated when you have issued a show cause notice? They submitted their explanation.
Reply.
Reply. That reply you will consider, or there is a personal hearing as per the act.
I'll come to that, my lords. I'll come to that, please. And again, my lords, they request of 90 days, my lords. And
How they requested? Any form orally? By
no,
writing?
by writing, my lords, in way of reply, representation, rather, representation, my lords. 19/8/2025 in writ petition number 17049 and 19/8/2025 in writ petition number 17049, my lords. And on 21/8/2025 in writ petition number 17043.
They sought for?
Time, my lords, to shift the shop, that is 90 days, they wanted time. We granted them time to shift the shop, my lords. And later on, my lords, they did not do so. None of them, my lords, did not do so. And again, on 14/5/2026, we gave the notice, my lords, in both the writ petitions.
14/5?
14/5/2026.
So here the question is, from 21/8/2025 till
Well,
14/5.
I'll come to, my lords, I'll come to that. Again, they replied, my lords. They gave the reply.
Forget about the reply. Now here, what were you doing from 21/8/25 to 14/5/25?
We gave them sufficient time, my lords.
So it is not called sufficient time. When somebody is running the business according to you, within the prohibited limits, is it not the responsibility of the state to
My lords,
act on that?
I'll come to that.
You are not here to show any charity to them.
No, my lords. I'll come to that, my lords. On 5/3/2026, we were preparing the report.
No, 14/5/2025, again you issued a notice.
Yes. Before that, my lords, on 5/3/2026, we are preparing the report, my lords.
What report?
A report is given by Excise Inspector to the Deputy Superintendent of Excise to take action under Section 29 of the Excise Act to suspend the license. And thereafter, that same.
Report is dated 5/3/2025.
Yes, 5/3/2026.
You gave a notice on 14/5/2025.
First report was prepared and then notice was given, my lord. And then again, the same report was forwarded to the Deputy Superintendent of Excise.
This report is this 14/5/2025 notice is given by whom?
DC Excise.
Excise.
Yes.
DC Excise.
Yes. DC Excise, Deputy Commissioner of Excise, my lord.
Yes.
And again, in one petition, one of the petitioner gives the reply. In another petition, he doesn't give reply, my lords.
Reply what? What he says by way of a reply.
Sufficient opportunity should again be granted for shifting of the shop, my lords. 90 days again he
They
sought.
do not question it is bad. That is bad.
And on 26, my lords, an order is passed in both the writ petitions, 26/5/2026, my lords. In both the writ petitions, an order is passed by the.
Now again, from 14/5/2025, it has now come to 26/5/2026.
10 days, my lord. Administrative reasons, there'll be, my lords.
You said
14/5/26,
26, then the order is.
10 days.
Say suspending their license.
Yes, my lords. Now again, over this order, an appeal is preferred by them, both the petitioners. That is appeal number.
Appellate tribunal.
Yes. That is under section 61 of the Act, my lords. Alternative remedy.
In
That
both
is,
the cases, appeals are preferred.
yes, appeal are preferred.
Suspension of their
Licenses. One second, sir. That is appeal number 44 of 2026 and appeal number 45 of 2026, my lords. They have preferred an appeal. And on 1/6/2026, interim order is rejected in that appeal. 1/6/2026, interim order is rejected in the appeal.
Those that was not questioned.
Question.
They have not questioned that. One second, sir.
Question
And
before the tribunal.
my lords,
Tribunal.
and here is the part, my lords. On 8/6/2026, this writ petition is preferred, challenging the order dated to 21/8/2025. When already they have participated in the.
Now here, when you have passed an order on 21/8/2025, asking them to shift because that is within the prohibited limits.
Please.
Then what is the remedy under the Act?
My lords, we are supposed to give some opportunity, my lords. Opportunity is given to them.
No, you have passed an order.
Please.
After that, what is the remedy available to them?
They should prefer an appeal.
Appeal to whom?
Appeal to under section 61 of the Act, Excise Act.
Commissioner.
Appellate authority.
Yes, yes.
Commissioner.
Commissioner,
Excise Commissioner.
which they did not do so. Even further opportunity was given to them. There's no violation of principle of natural justice at all, my lords. Now, after they preferred an appeal under section 61 of the Act, when an interim order was rejected, my lords, now they have preferred this writ petition challenging the order
of
passed by.
shifting.
Please, my lords.
Clear order of shifting.
Yes, that is not permissible, my lords. That is not my humble submission.
Yes.
Estoppel will apply, my lords. Doctrine of estoppel will apply.
I will take your lordship with the relevant, I read the affidavit. Before that, only relevant rules. What should happen when the premises is found to be objectionable? My lord, he renewed the license. I was having the business earlier in a different place. It was objectionable. I came to this place by order of the same officer. Deputy Commissioner permitted me to come to this shop. He renews the license. Within a 42 days time, Karnataka Excise licenses general condition.
Tell them to continue with the meeting. I'll come and join.
After 42 days from the date of renewal of the license by the same officer, he thinks that because somebody pointed out, an organization pointed out that it is objectionable, he issues a notice. When renewal of the license, it was not objectionable. There is no change in the proposal. It is a objection. Objection is
No.
Yes.
If this is a situation, if this is what you're pleading,
Yes.
then whatever is your difficulty, when an order was passed for
Yes.
shifting on 21/8/2025,
Yes.
without questioning it, why did you ask them to grant another 90 days time for shifting?
I have produced in this case, I have produced the copy of my reply, which is shockingly, my lord, normally the replies are given in a plain paper. This department insists for a stamp paper, non-judicial stamp paper, 100 rupees stamp paper, and affidavit is taken. I was sworn to in the affidavit today. Normally, when we make a complaint against the authorities, we should be very careful because we have put to proof. Now, my lords may be permitted to read the rules. What is required to be made when the order of shifting is to be made? Relevant rules, my lord.
No, we'll go to the rules.
Yes.
I am asking why on 21/8/2025,
Yes.
when they have asked you to shift,
Yes.
why did you not question it on that day?
On that day, my lord, the reply was given stating that there is no objection. That's what I filed the affidavit today.
Oh, when they have passed an order, there is no question of giving a reply.
I understand that, my lord. What happens is that, my lord, it's a very, my lord, I am in a very bad condition. My legs are not so strong today in this case. I can submit. But for the reason that we are license holders doing the business
Order,
of.
one minute.
Yes.
The consequential order of this, of non-compliance of this,
Yes.
is the order of your suspension.
205 days thereafter.
Whatever it is.
It was
It's a-
open for him to
No,
enforce
no,
the
no.
order.
No,
Yes.
this is the other order, which
Yes.
is before the appellate tribunal,
Yes.
is a consequences of this.
Please. Yes.
In that case,
Yes.
how will you question this order independently?
Because
Now, this has culminated.
consequence of this means,
This has culminated
Yes.
into that order.
but the commissioner says that earlier order you have not complied, so I can't grant an interim order. Appeal is pending in both authorities.
So, taking a clue from what he say,
Yes.
you come and file a writ petition.
Yes, because what happens is, normally the advice, once it comes to the advice of a lawyer, they are guided in a proper way that now you have no chance of survival unless you go for the.
They should have challenged the interim order itself.
I will come, sir. Please help me. Allow me to submit. So my submission is that, my lord, the first step of authorities I have made.
On this affidavit, on the main issue also, let them come up with objections.
Please.
Difficulty will
Interim
be
order
that-
should not be granted, my lords. That's
My
a humble
lord,
request.
My difficulty will be that, my lord. My difficulty, my lords, only 1 second, my lord, may permit me to read the rules. Relevant rules. Opportunity of hearing is not given.
Whatever are the rules,
Yes.
you keeping quiet from 21/8,
I understand that.
2025 till now,
Yes.
and having, at
Yes.
least we can understand
Well,
you have questioned that interim order by the appellate
Yes.
authority, not granting of interim order before this court. You stand on a better
Not,
footing than
not,
this.
no, no, no. What happens is, all that, my lords, the person comes, advices are given, it's our duty to give advice. He has accepted the advice. He was misled. It's my affidavit. I'm ready to face the consequence, and the officer also should be ready to face the consequence. How they mislead? Copies are not supplied. The copies are, the inspector sends by WhatsApp message to the party, all copies. We were not given before the commissioner, we reported. He sends the copy by WhatsApp to the party.
I understand whatever
Yes.
the practical difficulties you are putting forth,
Yes.
but it can't be from 21/8, 2025 till 2026 June.
And 107 days, much, 500 days.
Let them, that's why we'll also appreciate their conduct also.
Yes.
But we can't say to
Until, what happens
to revoke the suspension temporarily,
only
because
with a,
you are now, according to them,
with
on a
a,
prohibited.
with a very limited scope, I am in this court, in this state petition. The appellate authority made, now the order of the appeal is against a different officer. Deputy Commissioner of the district suspends the license under section 29. Here is a different officer who directs the shifting without compliance with law. Let them not be bound by this order for the purpose of deciding correctness or otherwise of the suspension of license. Suspension of license is section 29 on a different ground. Not if I don't shift the business, it cannot be suspended. He can stop the
On
business
what ground they are suspended?
on the ground that this is not
Violation
complied.
of Rule 5.
Section
It is in
29 I
highway.
read.
Let's, whatever the case
Section
is, my lords.
29. Power to suspend.
What I'm saying, because you have not,
Complied.
you have not shifted as per the order passed by them.
If I have not shifted, there is a different way of executing it. He may not honor my intent.
That's why you have a case on the merits which is pending before the appellate tribunal.
Please. Yes.
And the appellate tribunal failed to grant an interim
Give
order.
him the reason of this.
They have questioned it, but because that he said that you have not shifted, you can't question this order now.
I have questioned the commissioner's order, refusing the interim order before the tribunal. The tribunal, learned tribunal is also of the same view that it was
That
set
should
down.
have been questioned, but you can't go to that original shifting order now.
But for that, what happens is, but for that, I have no legs in that case.
Learned
That's the-
AGA takes notice, already issued notice. Unofficial.
I have to file objections, my lords.
The respondents, where are the other respondents, how many?
Only one respondent.
No, my lord, the state of Karnataka has to be made party, which they have not made.
No, I
And
have
some Sangha, army, green army,
So only
the
one
complainant.
respondent as of now.
No.
The respondent shall file their objections.
Maybe,
You should also make them all parties to this.
no, my lord, they are referred to the complaint of, no, we don't know whether secretary.
The first respondent shall file their objections.
Huh.
Let's just matter after 4 weeks.
Grateful, my lords.
I have asked Dura about, they have locked the shop. It's livelihood. My lord, livelihood, my lord. It becomes futile everywhere, my lord. And
That you will get your
I may be
relief,
permitted to
from
spend
that
2
order.
minutes, my lord, even on other aspect also. Our state law officers are representing the state authorities. And within that, you have not made the party. I brought the Karnataka High Court Act. It is not necessary to make a state government as a party. Chapter 7. Officer is a state.
On that ground,
No,
it's not that
see,
on that
this
ground I am
kind of-
not granting interim order.
My lord,
Not granting because I am not convinced.
Grateful, my lords.
my lords, may I kindly, what happens is, the license fee is few lakhs. My lord, may I kindly, it is not refundable. Few lakhs of rupees license fee is fees. Shifting order is 3 times the license fees. All these are there, my lord. That's why, maybe Monday, my lord, it may.
You are supposed to get an order before the appellate authority, but not in this case. We will not grant an order of.
No, appellate authority, my lord, now it is, my lord, because it is coming in the way, he refers to this order, immediately the appeal was,
You have to have in that writ petition.
No, my lord,
We will not consider the suspension when it is not before the court.
suspension order. No, my lord, again I have to come before my lords, again against the order of
When
the,
it comes, we'll hear it on the merits of it.
please, my lord, appellate tribunal now, today it is set down for order. If it is there, I have to, my lord, trouble your lordship with one more writ petition. These gullible people are, my lord, state authorities. It is very sorry that I am making a statement.
All this is irrelevant.
They are also not so gullible. Yes.
Shockingly, they treat the persons, shockingly, citizens. irrespective
may I
of
make a
anybody.
mention?
Yeah, that matter also, both are connected, yes.
If my lords would be
My lords,
gracious
may
to
I-
grant an order of-
No, my lords.
or only, my lords, I may not be mistaken for troubling, or one observation that independent of the order of this, without it being influenced by this.
How can I say that? That is the reason why they have cancelled, suspended your license, because you are not following it.
Suspension is not permissible for this.
That is on the merits of the matter.
I will
Then
come
that can
back.
be argued. If it is not granted,
Please, my
I
lord.
think
I understand that. I will
Yes, yes,
take
yes.
your lordship on
My
that.
lords, may I make a mention?
Yes.
My lords, serial number 133 of list number 2, my lords. If it could be had on Monday, my lords, there's
No
some
mention
urgency.
in the evening without that. If you have an urgency, only urgency is matter coming up before the trial court. No other urgencies, because everybody has. So I will not repeat all this every day.
My lords, this is a
Only
part heard matter, my lords.
part
It has,
heard?
it's a DRT part heard matter, my lords.
That matters I have adjourned already.
My lords, if it could be had on Monday, my lords.
Why, what is urgency?
My lords, urgency is that the auction or anything of that sort, my lords, and it's already been heard considerably. It only needs to be reserved, my lords, because only few submissions are left.
I have given it a date.
Milots, Milots, one submission, Milots. Serial number 153, Milots.
Yes.
Milots, serial number 153, urgency is cases coming up tomorrow, Milots. But my lords had granted me a time.
Counsel, or you should follow what is happening in the court. I will not give any date for the matters in the evening. If the matter is coming up tomorrow, you should, a day before, you should mention in the morning. I will take it up at 2:30. At this time, I will not hear any mentions.
Please, Milots, I'll mention in the morning, Milots. Right.
Oh, serial number. So, one more. Listed of serial number 86 along with this 60, 75
ನಾಳೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಸರ್ ಥ್ಯಾಂಕ್ಸ್ ಸರ್
10 along with 65.
86 ಇವತ್ತಿದೆ ಸರ್ ನಾಳೆ
Okay. In one matter, you simply gave date. In one matter, the serial number 10, you say this along.
ಇಲ್ಲ ಇಲ್ಲ ಇಲ್ಲ
You give the same date.
ಇಲ್ಲ ಇಲ್ಲ ಹಿಯರಿಂಗ್ ಆನ್
Date is not given.
ಟಾಪ್ ಬರುತ್ತೆ ಸರ್
Serial number 41, list 3. Supreme Court direction ಇದೆ ಅಂತ. ನಾಳೆ ಬರಲ್ಲ ಹಾಗಾದ್ರೆ?
ಯಾವುದು?
Serial number 41, list 3.
ಯಾವ್ದದು?
Serial number 41, list 3.
ಎಲ್ಲ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಇದೆ ಸರ್.
ನಾಳೆ ರಿಲೀಸ್ ಆಗುತ್ತಲ್ಲ ಸರ್?
ಇದೊಂದು ಲಿಸ್ಟ್ ನಂಬರ್ 2, ಲಿಸ್ಟ್ 2, serial number 206, 207. ಇಲ್ಲ ಪಾರ್ಟ್ ಮಾಡ್ಬೋದು. Subvention scheme. Or you 106 ಮತ್ತೆ really 106. This serial 103 list 2 serial number 10.
Court officer, would you be giving dates for the other matters which are not picked up to now?
Tomorrow, sir. All matters will be repeated tomorrow.
Thank you.
ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು, ರೀಚ್ ಆಗಿದೆ ಈಗ. ಹೌದು.
ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 155 ಮತ್ತೆ ರಿಪೀಟ್ ಆಗತ್ತಲ್ಲ? ಅರ್ಜೆನ್ಸಿ ಇದೆ ಆಕ್ಚುಲಿ, ಜಡ್ಜ್ಮೆಂಟ್ ಪೋಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಹೌದು,
ನಾಳೆ ಮೂವ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಆಯ್ತು.